Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault. And you're charged with theft. Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault. And you're charged with theft. Sir, you're charged with especially aggravated kidnapping.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
Got the wrong guy, and the dog was biting him.
He roughing him up quite a bit. There's a lawsuit.
9 out of 10 judges prefer watching the Recovery Addict live stream in their courtroom.
The fireworks are not done.
Now we're getting commentary on the case. I didn't ask you to interrupt me.
Is that correct?
It's literally not true.
Oh, for crumb's sake.
All right, welcome back to the Recovery Addicts channel. The Court of Public Opinion, I am Recovery Addicts. I've also made an executive decision that we are only going to chase news when it's freezing cold outside because it is smoking out there. It is smoking hot. But I'm cooked. I'm cooked through and through. All right, we are back. Sorry for the slight interruption. Every dry run we take works a little bit better. So that one was interesting. We'll talk about that later. I'll have to do a tabletop teardown of what happened and what didn't. Sarah Bathage. Sarah, I don't know how to say your last name. Sarah B, welcome. You are, yes, it was another good attempt. It's like an oven outside. Sarah, you're first in chat, and you're proud of it. You're like, me. Yes, it was you. You've confessed to the crime. We're going to punish you very promptly. Everything up here related worldwide is your responsibility. There you go. We've given you the internet. It's official. And now we have to jump right back to court where we left off moments ago. I'm trying to see where we had just gone to lunch, right? They had just ended their lunch break. They had just left. So we're coming back right from lunch right now. We had some hot mics right there at the very end. All right, let's go to 6, shall we? That's not it. This is it.
Okay.
Judge, we have experts here because they said they were calling experts. That's a deposition that's recorded that can be played at any time.
It is an order that I wanted to go before my next expert.
Well, you said your other person was next.
We would request a jury out regarding Dr. Larkin as we were provided with
Okay, hang on, you're jumping to something else on me now. So you want me to order the defense to the call first?
Your Honor, I'm simply asking that we have a jury out about this document that we just received.
Let's go back a second. Are you objecting to them playing the deposition at this point?
Yes, because we just asked Dr. Carney to leave her job and come over here to assist us with our defense experts, and they said that's who they would call.
You did say that.
I never said who I was calling, that sure. I said I had experts today that I was calling. We have not stated who we were calling next.
So you want to play the deposition, which is a 50-something minute long.
Yes.
Wow.
You want her to go, so you want me to order them to do that?
Judge, I'm simply asking if we could have a jury out to Your Honor to make a determination if Dr. Larkin will be allowed to testify, because we just received a report that we have not had. It has an opinion and a conclusion about the cause of death of Jake Benny.
I haven't even seen that, Your Honor. So if she gave them the report, it's not
Wait, your
something
staff
they
said
gave me.
they had everything.
That's been emailed. When they said that they emailed that over, that is what they emailed over.
When?
This morning, I don't even know if it was morning.
She
Let me see
prepared
what
it
you're
for her testimony today.
Is it a report?
Yes.
Yes.
Is it a report?
Let me take a look and I'll let you know.
Okay.
Well, that is the court's making
Hang on.
Judge, we received it. I'm sorry.
I got to get the definition of what a report is first.
so crazy.
It was definitely her opinion, but this is not something that we've had in the past. This is something that she formulated for her testimony.
When?
I'm assuming, I don't have to ask, probably yesterday.
Okay. Letter, is it a she?
Yes, I'm
Letter
sure it's yesterday.
See if Dr. Kelly Larkin is out there.
No, she's not here yet. She is my last witness. So I was under the assumption that I could call my witnesses in the order that I wanted to.
That's normally the case. I was just trying to help do this jury out here while Dr. Carney was here.
She's not here yet.
So let me have that, make a copy of that. Can Dr. Carney come back? Who is Janice Lindsay?
She is a toxicologist.
And who is Dr. Mario Bartolome?
He is a toxicologist medical review officer.
And they're going to be testifying about, someone said, the cause of death?
In regards to Dr. Larkin, yes.
And Dr. Kelly Larkin is what?
She is an ER doctor, a medical doctor.
Not a forensic pathologist.
No.
And you want to ask her what you just found that out, what her opinion is today. So what are you wanting to ask her?
I want to ask.
What is her opinion?
Her opinion is that this was more in line with a fentanyl overdose and what she's seen in the ER as opposed to a cocaine overdose.
Based on levels of fentanyl that are not reported.
No, based on the symptoms that were explained
Symptoms.
and described.
Okay, so back to my question, whether Dr. Carney was available prior to Dr. Larkin testifying, if she does.
Judge, are you asking if she's available tomorrow based on?
No, we're going to finish today. I'm talking about today.
She will move things to be here.
Okay, all right, well, I guess we've got an hour-long deposition, and then where are the few extra text messages that you're wanting to introduce? Do you have a copy of those?
Yeah, they're putting it on a thumb drive now.
It's where?
They're putting it on a thumb drive. So
I'm talking about copies, hard copies that I can look at and see if it's relevant.
we don't have a printer here, so we would have to go back to
We
the
don't have a
school
printer
office.
here.
We do, but it's not paper. So we don't have paper here. So we have to go to Ms. Riddle's office. This is
Here,
not our
there's
office.
some paper right there. So
No, that's not. Thank you.
no, it's just 30. So get those printed out now, delivered in here to me, so I can look at them, so we don't waste more time. So
We don't have a
we've got-
printer. Oh, we don't have paper.
I don't know, I guess Dr. Carney, she can be available for 4 o'clock or something. I don't know. Okay.
This is a circus.
And on the deposition, the court reporter made me aware that there's an objection on page 28 about an exhibit, but then there's nothing else. The testimony just goes on without an issue. Is that accurate from the state's perspective?
I haven't looked at that in a while. I do remember I objected one time, and I don't feel like it was worth rejecting it.
Okay.
That was your question.
Have you reviewed some record before your testimony that it just went on? So that's, I don't need to make a ruling on that.
It's not my it's my understanding you do not.
Okay.
I don't know if the defense was asking about it.
We're not.
Every time we ask for a ruling, it's sit down.
Yeah.
Just to clarify for Dr. Carney's schedule, Dr. Larkin will be here at 4 o'clock, and we're doing that at 4 o'clock.
I'm just guessing. I don't know how long or how many the text messages will come in with Mr. Devlin. I don't know how long Bartolome or Lindsay will take. I don't know. Are they here?
They are here. Dr. Larkin is our last witness.
And where is she?
She should be here in 20 minutes or so.
They are here. She'll be here in 20
She's our
minutes.
last witness.
So maybe it's 5 o'clock. I don't know.
There's a ton of snark in
These
this.
are the messages they gave me previously, and they said they have 30 more. Just for
Actually, it's
reference.
not, it's probably shorter than that.
Can you get me someone on your
They're printing it now.
staff give me what you're trying to introduce through Mr. Devlin. Can they get that?
They're getting it now.
Okay.
Judge, before the jury comes in, with respect to the witness, Dr. San Bartolome, this morning we discussed notes, anything, information, like we were advised, the court's hearing that everything had been sent, and at 1:52 this afternoon, we received yet another packet of notes.
So,
Dr. San Bartolome.
Is this the first we've heard him speak in this trial?
I went and I spoke with all of my experts, and out of abundance of caution, I asked them to turn over everything they had. I was following what the state had been doing. So I
I'm
didn't
not
know
worried
that
about what the state's been doing. We're here to what you're doing.
Well, I have to follow the leader over here, so.
No, you have to follow the rules.
They do too, Your Honor.
So then let me know if you think they haven't.
Oh, sit down. Oh my goodness.
I'm sure the court would know that her team had it apparently at 10:03 a.m.
This is nuts. This is so crazy.
Have you seen this, Ms. Holmes?
No, I haven't. That's not my witness. Can I see it?
It's not what?
Is that Bartholomew? That's not my witness, so no, I haven't. But I'm sure Mr. Jordan may have.
Bartholomew is not your witness?
No, he's Mr. Jointer's witness.
Okay, I thought you were speaking for everybody. Has anybody to the west side of me, to my right, in the southwesterly direction, including the individual seated at the defense counsel table, had this?
I'm not entirely sure what that is, but I did receive it at 10:03.
Oh, why did Ms. Hollins know that you were, why didn't you pop up and say, hey, wait a minute, whoop, whoop, wait a minute?
I could have, Your Honor. I did check my email, unfortunately.
So you didn't get that until when? Or when did you, I know it was sent 10:03, when did you get it?
I believe whenever we was anticipating breaking for lunch, Your Honor, I double checked my email.
Anticipating, when is that?
We came back at 1:50, so it had been around an hour before that.
Okay, so when Ms. Hollins was saying that's it, and confirmed with Ms. Miller or whoever this young lady is, that that's it, you knew it wasn't?
No, sir. I did not know it wasn't.
Oh, I thought you said you looked at it in anticipation of one. Let me see it back.
Defense can be in trouble here soon.
Is the defense anticipating getting into information in this document?
What information specifically are you referencing, Your Honor?
Any.
The sensitivity of identifying a woman with a substance abuse use problem is 80 to 88%, and sensitivity is 35 to 37%. I have no idea what that means, but that's what I'm asking.
It is my understanding that Dr. Mario has treated pregnant women with substance abuse issues. Substance use issues, rather, not abuse, but substance use issues.
So, what does that have to do with this case?
We have a pregnant woman who we believe had substance use issues.
And then he's going to say what?
He's going to opine in his professional opinion about whether or not being pregnant is a barrier or an automatic stoppage to a person using substances.
Well, everybody in the nation knows that.
It's not like when it comes from an expert, Your Honor.
Judge, this goes back to our previous objection.
So you're wanting, hang on, you're wanting this jury to hear from Mr. Dr. Bartolome that pregnant women should not use drugs, alcohol, or illicit substances.
No, not that, Your Honor. There's been an assertion in the state's case in chief that once Ms. Benning became pregnant, any prior use stopped.
Do you have proof from Dr. Bartolome that she did?
That she did stop?
No, that she did use.
We believe that she continued to be involved in
Does he know that?
Yes, he's reviewed the records in this case, Your Honor.
What record?
He's reviewed medical records, he's reviewed text messages, he's reviewed...
What medical records show that she was using drugs?
Medical records show the absence of a test while she was pregnant, Your Honor.
Absence of a what?
Testing, drug testing. Actually, there was testimony
Does that mean she used?
No, that does not mean that she used, but she did have cocaine in her system, which suggests that she could have.
Everybody, they're saying she used too much cocaine.
Y'all, but they were silent on alcohol, Your Honor, and there's cocaine in her system.
Yeah, and that can be argued for the jury. So what does Dr. Bartolome have any information directly about Ms. Benning's drug usage?
He has direct information that was derived from the text messages in her phone, that was derived from the medical records, specifically regarding the OB/GYN records, where there wasn't any test.
They didn't do it, so that's just a non-issue. What else?
For Your Honor, those two things are central to our defensive theory. If the state is wanting to allege she could have not taken the substance because she was pregnant.
Yeah, she could have taken a substance.
I know, Your Honor, that's not the argument we made.
Does the state agree she could have taken a substance?
There's no evidence, there's no proof about that.
Does the state agree that Ms. Benning could have taken a substance?
And this witness would not materially assist the jury?
The answer is yes.
In understanding that.
Whether he has any relevant information, and whether this should have been provided to the state.
Your Honor, I just received a text from Mr. Weissman in regards to his witness, Dr. Pickles. He is asking if it's possible to put this witness on prior to the planning of the deposition. I told him that I would speak with the court. She should be very short.
That's up to you. You said it had to be this deposition next.
No, I just didn't want it to be Dr. Larkin for certain, but I can't accommodate.
You said you wanted to put this deposition on next.
I do.
So you want to call Dr. Brucolari next or the deposition?
I can, if you'll allow, I will let him know that he can bring her over. She's very short.
She's not even here.
No, it seems like
Okay, bring the jury down. We'll play this deposition.
One last thing. Do we have anything from Dr. Jancy Lindsay?
We just turned it over.
What?
Is that the notes that you were throwing around?
Those are not even notes. Those are articles that she relies on. It's not Jinx material. It's not anything that we are turning over or trying to admit, but out of an abundance of caution, we turned it over. So we have what we have.
So no notes or no reports?
We gave you notes as well.
It doesn't matter what's been said, it can change.
They're not supposed to be, they are.
But of who? It doesn't say.
They're from Dr. Lindsay. That's what you asked for. That's what you have.
Let the jury step down.
So just a little update where we're at right now. The three-ring circus, all the animals have escaped and are interacting with the other animals and the audience right now. This is turning into a cluster. A big old mess. Defense is playing games trying to force the prosecution to have the witnesses go a certain way. It is their case. They usually get the privilege of doing that. Prosecution is trying to limit what the defense can bring in because they have witnesses that are just saying the opposite of what the state says. They don't like that.
Who's the next witness on behalf of the defendant?
The defense calls Alyssa Smith by deposition.
Okay. All right. Well, ladies and gentlemen of the jury, this witness, by agreement, their deposition was taken since they were unable to be here this week or for some reason that the party's aware that they couldn't be here, so that's going to be plate for you, and you can analyze that testimony as you would if the person was here and live and in person. Okay.
Judge, I'm sorry, we had a recording done of this witness. I don't know. I think this is the
What did you say?
That's not how we had a deposition recorded, but if it, I don't know if it's.
That's the court reporter's recording.
Correct. We had somebody from our office that came and videotaped it.
Is this not, okay?
I don't know. I haven't seen this, but I'm sure it'll be fine.
Oh, right.
Best
Just
evidence.
for the record, this is the deposition of Alyssa Smith related to State versus Blaise Taylor on Friday, April 17th, 2026. Ms. Smith, could you please state your full name for the record?
Yep, Alyssa Smith.
And could you spell your first name for the court reporter?
ALYSSA.
Ms. Smith, where are you employed?
Vanderbilt Lifeline.
And you said Vanderbilt Lifeline, is that correct? Can you explain what is Vanderbilt Lifeline?
We provide pre-hospital care across a bunch of different service lines, from events to flight to ground transports.
And what is your position?
I'm a critical care paramedic.
Can you explain what the critical care paramedic does?
We provide life-saving interventions in pre-hospital setting.
And that pre-hospital setting, can you describe, are you on an ambulance or some type of vehicle, or where are you normally physically working?
In my current role, I can be positioned on an ambulance, or I can just be in a venue. It just kind of depends on my assignment.
And would you ever sometimes be at Vanderbilt University Medical Center?
Working currently, no. We're not working at the hospital.
And how long have you been in that position at Vanderbilt?
In my current role since fall of 2023.
And prior to fall of 2023, what did you do?
I was working in the ER at Vanderbilt Adult.
And what was your position in Vanderbilt's emergency department?
Paramedic.
And can you describe what was your role in patient care when you were a paramedic in the Vanderbilt emergency department?
We were mostly support for the nurses. Anything that they would need, IVs, medications, we would work traumas, anything that would come in. We were just kind of support for the doctors and nurses there.
Okay. And that position is an EMT position, but it's a position at Vanderbilt Hospital. Is that correct?
Yeah, it's a paramedic position.
And so there are other paramedics that would work for National Fire Department with ambulance services. Is that correct? Okay. And specifically, were you working in that position as an EMT at Vanderbilt Emergency Department in February of 2023?
Yeah, I was working as a paramedic.
And were you working specifically on the night of February 25th, 2023 into the early morning of February 26th?
I was.
And while you were working, were you involved in providing any patient care to patient Jade Benny?
I don't remember.
In preparation for testifying today, did you review records to verify whether or not you were involved in any patient care related to Jade Benny?
Yes.
And were you involved in any way?
Yes.
And specifically, did you ever administer fentanyl to Jade Benny? And did you review records related to whether or not you administered fentanyl to Jade Benny?
Yes.
And in the records, there is an entry from February 25th, 2023 at 23 and 27 hours that indicates that fentanyl was dispensed.
Yes.
Did you review those records?
Yes.
And can you explain, what does it mean when a medication is dispensed?
When we are pulling it from the medication dispensing machine in preparation to either have it on hand to give or to give to the patient.
And did you locate in the records whether or not you actually administered that fentanyl that was dispensed at 23 hours and 27 minutes on February 25th of 2023?
No.
And no, you didn't review the records, or no, it wasn't?
It wasn't administered.
Okay, so it was not administered?
No.
Did the records indicate what happened to that fentanyl that was dispensed?
It was wasted.
And can you explain why would it be wasted, and what does that mean?
Yes, on the note on the document, it states the patient condition changed.
And so that fentanyl specifically was not administered to the patient, is that correct?
That's correct.
If I can have just a moment. Thank you, Ms. Smith. I don't have any other questions.
Ms. Smith, good morning.
Good morning.
My name is Letitia Quinones Hollins, and I'm going to be asking you some questions. If at any time you don't understand anything or you feel like I need to rephrase, please let me know and I'll do my best, okay? I want to talk to you a little bit about your background. Are you from Nashville?
I'm not.
Oh, where are you from?
Arkansas.
Okay. And what part of Arkansas are you from?
Jonesboro.
When did you come to Nashville? When did you come to Nashville?
Fall.
There was an objection in there. I'll count it. It's not on the screen, but we've got
What
them.
school did you attend?
Nosy College of Art for my bachelor's in photography.
I'm sorry?
Nosy College of Art.
Nelsie?
Nosy.
Spell it for me.
N-O-S-S-I.
Oh, Nelsie. Okay.
Yeah.
College of Art. And you got a degree in photography. Would that be bachelor's?
She has a
And what
photography
did you do
degree from
after you graduated? What year was it that you graduated?
Nosy Name
May of
University.
2025.
Just last year. Congratulations. How old are you?
Thank you. 26.
And so then if we go back to 2023, were you in school then? You have to speak out loud so she can
Sorry.
That's okay.
Yes.
Okay. And what year were you then?
What age was I?
No, what year of college were you?
Okay. I started in fall of 2021.
Okay. And went straight through. Okay. When you were doing your studies at Nosy College of Arts, did you get any type of training in any medical training there?
From the college, yeah.
Okay. And did you get any type of medical training in?
Yes.
And where were they?
Arkansas State University.
Okay. So I'm assuming before you came to Nashville, you were also in school in Jonesboro?
Yes.
At Arkansas State?
Yes.
And what were you studying there?
That's where I obtained my EMT basic and my paramedic license.
How long does it take to get EMT and paramedic license?
EMT is typically a semester, paramedic is typically 12 months straight through.
Does the semester that you take for the EMT go towards the year to become a paramedic as well? So they're separate and apart?
Yes.
And so then that would be a year and a half that you study in order to become an EMT and a certified paramedic as well?
Yes.
What is the difference between an EMT and a paramedic?
Scope of practice.
Scope of practice. What is the difference in the scopes?
A paramedic is able to treat and do more, interpret 12 leads, start IVs, administer medications.
Things of that nature.
Yes.
And an EMT is only able to do what?
They're typically the driver, and they're there to support their medic and anything they can help them do during treatment.
Okay, fair enough. They are not allowed to administer medication?
Tennessee is different with advanced EMTs. I was a basic in Arkansas, so I know they're allowed to do some here. I don't know because I was never an advanced.
Okay, sounds good. So as a paramedic, though, you were able to administer medications?
Yes.
What year did you receive your paramedic certification?
2021.
So right before you came to Nashville to start at Nosy.
Yes.
And when you came to Nashville to start at school, I'm assuming you started as a freshman or you had credit already?
I had transfer credits.
Okay. Were you still a freshman?
Yes.
And were you working during that time?
Yes.
Okay. And would that be 2021? Mm-hmm. And where were you working?
When I first started school, I was at Emerson Ambulance back home, and then I started working at Hobby Lobby for a little bit to take a break.
One of my favorite places. Okay. And what about when you came to Nashville?
That Hobby Lobby was here in Nashville.
Oh, okay.
Yeah.
Hobby
How long
Lobby.
did you work at Hobby Lobby?
Roughly 5 or 6 months until I started at Vanderbilt.
That's awesome.
When did you, so did you have any employment between Hobby Lobby and Vanderbilt? When did you start at Vanderbilt?
March of 2022.
And what position did you start off?
Paramedic.
Paramedic. What department? Would that be emergency?
Yes.
Did you work in any other department at Vanderbilt outside of the emergency department before February 2022? Okay. So by the time that by the time it's February the 25th of 2023, you have been at Vanderbilt working as a paramedic in the emergency department for almost a year.
Yes.
Is that fair?
Yes.
And I'm assuming you were going to school during the day?
Yes.
And then working at night?
Yes.
What were your hours during that time?
If it was I started on night shift from 7p to 7a, and I moved to a mid shift from 3p to 3a at some point. I think I was working mid shift by then.
Okay. So 3 p.m. to
3 a.m.
And I'm assuming you guys work 12-hour shifts. How many days per week were you working 12-hour shifts?
3 to 4.
So it's full-time, and full-time student?
Yes.
Yeah. Could you tell us exactly what your title was from March of 2022 to February of 2023?
Paramedic.
And nothing else in between?
No.
Did you hold any supervisory roles or anything of that nature?
The last 2 months that I was employed in the ER, I became a paramedic lead.
Okay.
That's it.
And can you tell me when would the last 2 months be? I know you said
August and September. I left September 24th.
September 24th. So September 2024, that's when you moved to your current position?
2023.
23, okay. So September 2023 is when you left the emergency room department and came to your current position?
Yes.
And your current position again is?
A critical paramedic for lifeline.
Is that viewed almost as if it's a promotion, if you will? Or it's just like a lateral move?
Lateral transfer.
Okay. In your position as a paramedic in the emergency department back in 2023, February, tell us exactly what your daily, average day responsibilities were.
So I would come to work, clock in, check off all of our equipment throughout the department, look at the board, see what patients we had, get offgoing shift report from offgoing paramedics, and just help wherever the nurses need me and whatever I was told to do.
When you say check equipment, what type of equipment are we talking about?
Our crash carts, our trauma equipment, all of our cabinets, all of our carts, make sure everything's stocked for the shift.
Okay. And is medication in any of these cabinets or no? So what would be in your carts and cabinets and things of that nature?
IV supplies, I'm trying to think, like bandaging things, basic things.
Almost like support supplies for the nurses and things of that nature. Okay. So you would come to work, you check the equipment, see what patients are there in the emergency room, and then I'm assuming you then wait for someone to give you instruction as to where they would need your support. Who would primarily be the people who would come to you and ask you for support? Would it be the nurses, doctors?
Yes.
Both?
Yes.
Okay. Was there a particular doctor and or nurse that anyone was assigned to?
No.
It could be anyone.
Yes.
How many, if you know, how many nurses would you say would be on duty at any given time in Vanderbilt's emergency back then?
I do not know.
Okay. You know how many patients the emergency room department, in terms of rooms, how many rooms of patients do you guys take care?
I don't have an exact number. I know we go up to 38, like physical rooms.
38.
But it could be more, not 100%.
Yeah, I've seen sometimes where patients say all that because they're running that rooms. Who would have been your supervisor back then?
As our paramedic supervisor, it would have been Eric Frank.
Eric Frank. Did you guys have more than one supervisor?
For paramedics, no. He was our overall paramedic lead.
So outside of Mr. Frank, everyone was in the same role and position?
Yes.
Were you supervised directly by any doctors and or nurses?
No.
And so you, on February 25th of 2023, I'm assuming based on your prior answer, the only reason you remember that you were working that particular day is because you checked the records.
Yes.
And that makes sense, right? It was 3 years ago. You're stating that you were on duty there from 3 p.m. to 3 a.m. during that time?
I believe if it was my normal shift, then yes. I don't know exactly what my shift was.
And do you remember at all Ms. Benning coming to the emergency department on that day?
I do not.
Do you remember which nurse and or doctor that you were working with on that day?
I do not.
Do you remember whether or not during that time that there were more than 38 patients, or it was pretty hectic during that time, or if it was just a normal call day? Do you remember anything?
I do not.
I should probably just ask you this. Do you remember anything about that day?
I do not.
And trust me, it's fair. That was 3 years ago, so that's it. Okay. During your position and your daily duties at the emergency department, do you ever have interaction with family members or things of that nature?
Yes.
And what type of interactions would you have with individual patients, family members, and things of that nature? that treatment plan to the family members?
It's typically the MDs, but if we come in and we start doing something, that's what I would explain what's going on.
And when you say that you would explain what was going on, you would explain what?
Like, hey, I'm about to start an IV.
Okay.
Typical things.
Not what the doctors are going to do, just what, this is what I'm going to do.
Correct.
Now, do you have any authority to, on your own, determine what type of medication a patient should receive?
Not in the yard.
Not in the yard, okay. Do you have, on your own, any type of authority as it relates to any type of treatment, not medication, but an IV and or a bandage or anything like that? Can you assess a patient on your own and say, this patient needs an IV or this patient needs a bandage?
I have to obtain orders from the doctor.
I'm sorry?
I have to obtain orders from the doctor.
From the doctor. Can you obtain those type of orders from a nurse?
Yeah.
Only a doctor. And so when you looked at the records for Ms. Benning back on February 25th of 2023, I'm assuming you noticed, like we all, that you had pulled some medication that day. And you said before that you dispensed medication.
Yes.
Tell us again exactly what dispense means in the EMT emergency room department world.
Pulling it from the machine that stocks it, that had where it's stored. Just pulling it out of the machine.
Okay. And so if anyone is like me, what do you mean pulling it out of the machine? What does that mean?
We go in, type in the patient's name, type what medicine we need, and like pull it out of the machine and we have the medication now.
Okay. So I'm assuming then there is some type of machine that houses medications.
Yes.
And that machine, does it house all medications or only controlled substances or things of that nature?
It houses all medications. It's not only controlled substances.
Okay. And so if you are dispensing, which we now know the EMT emergency room department world means pulling it out from the machine that houses the medication for the emergency department, we can assume, can we not, that a doctor, because you said you cannot take orders from a nurse, right, that a doctor had to have told you to do so.
Correct.
Because you otherwise would not get medication out of it.
Correct.
What credentials must you put in order to obtain those medications?
The patient's name and the first 5 letters of the medication you're trying to access.
Do you have to give any identification?
First 5 letters?
From you?
Yes.
Okay. Tell us what that is.
It's our login, our ID, and our password.
Anything else besides your ID, your password, the name of the first 5 letters of the name of the patient, and the actual medicine?
It's the first 5 letters of the medication and the name of the full name of the patient.
Okay. You have to give the patient's date of birth.
No.
Do you have to put anything in there as it relates to the doctor who gave you the authority? And so we see that on February 25th of 2023 at 23:27, which is 11:27 p.m.
Yes.
That you first pulled midazolam.
Yes.
What is midazolam?
Another name for it is Versed, and it's just a sedative.
A sedative means that it does what to a patient?
It calms them down. We give it for seizures a lot. It just kind of relaxes their muscles.
Okay. Does it put them to sleep?
Patient dependent.
Okay, so it can make you drowsy, but it's not an agent that puts you under.
It can't. It depends on the patient. Everyone handles meds differently.
Okay.
So it depends on the patient.
Well, let me ask you this. If someone wanted to cause someone to go into an unconscious state, would they use midazolam in that type of arena to make that happen?
Yes.
And then we also saw that you also pulled fentanyl.
Yes.
What is fentanyl?
It is a pain medication.
Is it also used as a sedative?
No.
It is solely for pain.
Yes.
So one can assume then that if you are administering pain medication to a patient, then that patient had to have been in some sort of pain.
Yes.
And how would you know a patient is in pain?
They'll tell us.
I noticed, if I could, you reviewed your records when you prepared for today?
Yes.
I want to show you what I'm going to mark as
It's a very quiet objection happening on the video.
Okay, can she tell me? Since she's a witness. I'm going to mark it as Appendix Exhibit 1. Take a look at Appendix Exhibit number 1. Have you ever seen that document?
Yes.
Okay. When did you see that document?
A strip of only what I had done under my name was emailed to me.
Okay. Who was it emailed to you by?
That I do not know.
Okay. Do you, what email would they have emailed it to you?
My work email.
Your parent work email?
Yes.
Are you able to go back and take a look and see who emailed that document to you?
I don't have the ability on it.
Not now, but at some point.
Yes.
Okay. Do you remember when it was emailed to you?
No.
Was it this year?
Yes.
Was it in preparation for your testimony today?
Yes.
And you just don't remember who it was? No. Who have you been in contact with in preparation for your testimony today?
My lawyer.
Who is your lawyer?
Pickles.
Have you been in contact with anyone else?
No. I got the subpoena emailed to me and that was it.
Okay. So then the only person that you've been in contact with as it relates to your testimony here today was your attorney?
Yes.
In these records, you notice that your name was present?
Yes.
Do you also notice where it states ABS override pool?
Yes.
What does that mean?
It means if we have a patient coming in or a patient that needs emergency medication right in that moment, we can go in and override and just pull the medication that we need as told by a doctor.
Okay. Why would you need to override it?
Because they don't have time to go in and put the orders in the computer. Because it's an emergent situation and something's happening that we need those medications.
Okay, so is there another protocol for dispensing, medication outside of this ABS override that would not require any time?
No.
So in every instance that you want medication, you have to do an ABS override?
Oh, no.
Okay. No. So what would you do if it wasn't an override, I should say?
The orders would be put in by the physician and we would go in and be able to pull them.
Okay, so then what you're saying is that the normal protocol is that a doctor would put in orders for medication.
Yes.
And it is because of those orders that you can then go to the machine that houses the medication. Does that machine have a name, by the way?
The Omnicell.
Omnicell? O-M-N-I? S-C-E-L-S?
Yes.
So in a normal procedure or protocol, doctors put in orders into a system. That system somehow communicates to the Omnicell.
Yes.
And allows for you to go in and then put in the patient's name, the first 5 letters of the medication, your ID and password, and the medication is dispensed.
Yes.
But in this instance for Ms. Benny, there were no orders in the system.
Yes.
For the Omnicell to recognize.
Yes.
Because of the emergency situation.
Yes.
And so because of that, you implemented the ABS override pool.
Yes.
Okay. And what exactly is the override pool? What do you have to do there?
We hit, it's about medication override and the recent emergency, whatever the reason is for needing it overridden, so that it's all documented.
In that situation, what would the reason have been, if you know?
I don't know the exact reason.
Okay. Would it have been communicated to you?
Yes.
Okay. Who would have communicated that to you?
The pharmacist or the doctor.
Okay. Is it required for you to put in that reason every time you do an ABS override?
Yes.
Without that, you cannot administer it. Dispense it.
Correct.
Okay. And so then we can assume that when you did this ABS override pool, there was a reason stated as to why you were able to do that.
Yes.
When you put that reason into the system, Are you also inputting the individual who communicated the reason to you?
No.
Just only the reason?
Yes.
Okay. How many doctors would you say are on duty at any given time during the 3 p.m. to 3 a.m. shift?
I don't have an exact number.
Would it be more than one?
Yes.
Okay. More than 5?
Yes.
More than 10?
I don't believe so.
Okay. So somewhere between 5 and 10. Yeah. Who would tell you the dosage of the medication?
The doctor.
When the doctor is communicating this information to you in this emergency situation where the orders are not put into the system, are you taking notes or are you just memorizing?
When we pull the medication from the Omnicell, it is the whole vial. So we go and pull the medication, we come back to the doctor and verify the dose before getting it.
Okay. So when the doctor is communicating to you before you go to the Omnicell, you're not taking notes or anything at that time, you're just remembering as you go.
The medication, yes. All I need to know is the medication.
Okay. So because we see in these records that there was a fentanyl pool, there was a midazolam pool, in an override situation, then we can, based on what you just testified here today, assume that there was a doctor who communicated this information to you in terms of what the patient needed.
Yes.
Now, when you dispense the medication, who administers the medication? Meaning, who gives the patient this medication?
Either myself or a nurse.
Not the doctor?
Typically, no.
Okay. And how is fentanyl and midazolam administered to a patient?
Through an IV.
And just so that we're clear for the sake of the jury, when we're dispensing medication in this setting, that means you're taking it from the Omnicell. When you're administering medication in this setting, you're actually getting it to the patient.
That's correct.
And so, at some point, based on your testimony, it was determined that this medication would not be given to this patient, correct?
Correct.
Okay. Now, who would have told you that? So someone had to have told you to get the medication, dispense it. Who would have told you not to administer it?
The doctor.
The same person?
Yes.
Is there anyone else who could have given you the authority not to administer that medication?
Yes. Another doctor.
Okay, but it had to be a doctor?
Yes.
Okay. Not the RN? Or a nurse practitioner? And again,
don't do again. Just move on.
You're not taking notes or anything. You're just on the spot.
Yes.
So, it is now determined that you did not administer, the doctor makes the, based on the records, make the determination that you're not going to administer these medications to the doctor. What do you do with those medications?
They are wasted.
Are they wasted immediately?
Yes.
Okay. And how are they wasted?
We have a system in the Omnicell where we go in and waste it with a witness, and then they are disposed of. And it's called a cactus. It's a drug disposal thing that we sort the medication into.
Okay. Is that in the Omnicell as well?
It's beside it, yes.
Right beside it. Is it a separate machine?
Yes.
Okay. And does it require any information on your part in order for you to dispose of the medication into that machine?
Yes.
And what is that machine called?
It's a non-machine. It's just a waste receptacle.
Oh, it's just a waste receptacle.
Yes.
Is that those red things you see with the danger?
A little different.
Okay.
It's not a Sharps container.
And you said, I'm sorry, I didn't catch the answer. Are there things you have to put in there? No, it's just, you're putting it in.
Correct. It's documented in the Omnicell.
Okay. So first you document the fact that we are going to waste this medication in the Omnicell.
Correct.
You then go to the receptacle, for lack of a better word, and you actually squirt that medication from the syringe into the receptacle.
Yes.
What do you do with the syringes?
Throw them away.
In the trash or something?
In the Sharps container.
Is there a special place for you to dispose of the syringes?
What does this matter?
Trash cans and bioplastic trash.
Okay. When you dispose of the medication and you're inputting it into the Omnicell, are you also putting the reason that you're disposing?
Yes.
And where are you getting that reason from?
The doctors.
Are you having to list the doctor's name that told you that? you stated, I think you said something about the patient changed, and that's how you knew that you disposed of it. How did you know that you disposed of that medication? For Ms. Benning particularly?
Yes, in the report it states that I wasted it, and under the reason it states patient condition changed.
Okay. And what report are you speaking to in that regard?
It's a continuation of this report.
Okay. A continuation, you mean medical records?
No, it's all of it's in the medication report.
Okay. On the document Defendant's Exhibit 1 that's in front of you, is that information on this sheet? So there's another document somewhere that states that?
Yes.
But it's not a VUMC medical record?
Yes, it is.
Okay. Would your name be attached to that as well?
Yes.
Have you seen that document?
Yes.
When did you see that document?
It's the same one I was referring to, or I don't know when it was sent to me.
I'm sorry?
That's the one that was emailed to me. I'm not sure exactly when I received it.
In addition to Defendant's Exhibit 1?
I only received a strip that showed my name and like what I did.
Okay.
I didn't receive anyone else's name. It just showed my name and my involvement.
Okay. And that, was it a screenshot of the document?
Yes.
So then it would have been attached to an email?
Yes.
Not the email itself. And what I mean by that is, you know, sometimes you'll receive an email and there's a screenshot within the email.
Yes.
As opposed to an actual document that you have to click on and download to review.
Yes. I believe it was just in the email.
In the email itself. And just so we're clear, because I don't want to confuse that, what you received is different than Defendant's Exhibit 1.
Yes, it's less information. It is only it has these two parts on here and only what I was involved in. It doesn't have, it's not full of all the other medications. It's only what I was involved with.
Fair enough, thank you. And in Defendant's Exhibit 1, is it fair to say that Defendant's Exhibit 1 would be, if you look at just the two strips of where you were involved, would it be fair to say that the information you received is different than what's in those strips shown on Defendant's Exhibit 1 because it doesn't show where the medication was wasted?
Correct.
Because in Defendant's Exhibit 1, we don't see that, right?
Correct.
When we see the statement, "Do not tube must always be secured," what does that mean? If you know.
Oh, is that on here?
Yes, ma'am. For the record, what she says is that on here, she's looking at Defendant's Exhibit 1.
Where on the, oh, there it is. I believe it's referring to not, you can't send it through the tube system in the hospital like we sent last, because it's a controlled substance, so we can't just send it through the hospital. If we were, for some, we would never have a reason to do that, but that's all that means.
Okay.
Is do not put it in the tube system.
Let's keep those separate and secure.
Yes.
When we see the status as active, what does that mean? On the right-hand side.
I do not know.
Okay. When you look at it, it says ordering mode standard. What does that mean?
I also do not know.
You see there where it says at the bottom package, and then it gives a number. Specifically under fentanyl, it says package 0409-9094-12. Do you know what that number pertains to? No. Fair enough. And finally, when you see frequency from 225.23 and 23.27 until discontinued, what does that mean to you, if anything?
I guess to me that's until they decide that we don't need it anymore, or until they discontinue the order.
Okay. And when you say they, you're speaking about the doctors?
Correct.
Okay. And to be clear, you would have nothing to do with the decision to administer these medications?
Correct.
Yes. Okay. and you would have nothing to do with the amount of medication that is determined that needs to be administered, correct? When you, and if you know the answer to this question, you can answer it if you don't. When you see fentanyl, well, let me back that up. If someone was coming in for a potential overdose for any type of drug, would you expect to see fentanyl administered? If you know the answer, if you don't, that's fine.
I do not know the answer to that.
And reason being, because you're not the one who made those determinations, right? So that was an unfair question, I apologize. But what we can say is that we know for certain, based on the records you reviewed, that at 23:27 on February 25th of 2023, although it states that fentanyl was dispensed, you did not, and anyone to your knowledge, administer fentanyl to Ms. J. Benning.
That is correct.
And let me be honest.
All right, was that it?
So, Ms. Smith, we're going to, I'm done at this time, but, and this is beyond your purview, but I want to say it on the record. We would like for you to grab that document, that medical record, where it states that you actually disposed of it, so that we could at some point talk to you again about it. And we'll work with the prosecution to that regard, okay? But we do want you to remove it, okay? All right, at this time, the country witness. And for the record, I would just like to say that we are not done necessarily with this witness until we deal with the issue of this record we have not seen.
Okay, here we go.
All right. Next witness. I think we're going to get back into the spice. That was pre-recorded before the fight really started.
I believe, Mrs. Collins, this is in the medical records, but you mentioned it during the deposition. Do you want this marked as a separate exhibit?
Yes, please.
All right, at least 60.
Your Honor, I would just renew my request that Dr. Larry not be asked about any testing that's not admitted as evidence as an exhibit.
Okay, I would have said whatever step up.
Yeah, it's going to get spicy.
Do you swear the testimony you're about to give to be the truth, so help you God? Yes.
Good afternoon, Dr. Brungaleri. How are you?
I'm doing all right.
Brungaleri, I'm sorry. Can you please state your name and spell it for the record?
Sure. It's Dr. Rebecca Brungaleri, REBECCA,
And how are you employed, Dr. Brungaleri?
I'm employed by Vanderbilt University Medical Center as the medical director of the Tennessee Poison Center and a medical toxicologist.
And how long have you been employed with Vanderbilt?
Since October 2018.
And I want to ask you a question in regards to
Just ask it.
The treatment of Jade Benning. Are you familiar with the patient at Vanderbilt by the name of Jade Benning?
Yes.
And do you remember about the time that she was being treated at Vanderbilt?
Yes.
Was there an occasion where you were involved with her treatment?
Yes.
Can you explain to the jury exactly what your involvement was?
Yes. I was called shortly after she was admitted to the ICU to assist in drug testing because there was concern that Ms. Benning had been poisoned.
And do you remember about the time that she was admitted to the hospital?
She was admitted at about 9 to 10 p.m. on February 25th, 2023.
And who contacted you? Well, let me ask you this. What is your role there at Vanderbilt directly?
I provide inpatient and outpatient medical toxicology consults.
Okay. What exactly does that mean?
So I can provide advice on toxicologic cases, so whether or not someone's been poisoned, intentional overdoses, unintentional overdoses, adverse medication reactions, and envenomations.
And you just stated something about unintentional overdoses. Is that what you stated?
Yes.
Okay. Can you explain to the jury what exactly that means?
So a prime example of an unintentional overdose is if a small child finds a pill on the ground that one of their caregivers has left and ingested it, and the management of that.
And so what would your involvement be in a case like that?
So I would provide advice on how to treat the poisoning. It could be a myriad of drugs that could be one, but for example, something like a blood pressure medication could be ingested by a small child, and then I would provide treatment recommendations to the team on how to manage that.
When you were notified, or let me ask you a better question, do you remember the exact day you were notified in regards to Jay Benny's treatment?
Yes.
And who contacted you?
The ICU team.
And for what purpose were they calling you in specifically as it relates to Jay Benny?
They wanted help with extended drug testing.
And what type of service did you provide?
I provided advice on extended drug testing.
Did you have an occasion to pull urine for or from Ms. Benny? Meaning, did you order a urine analysis or a drug test, drug screen?
I did help with drug testing.
Okay. And do you remember what day that was?
So I assisted in ordering, I don't remember the exact date and time for each time that I called the lab, but I assisted on add-on testing for urine that was already in the lab, and then at the end of her hospital stay, I helped order arsenic testing.
I want to draw your attention as to whether or not, well, let me ask a better question. Once that you order testing, where do you send your testing to? Meaning, where do you go? What lab do you utilize for your testing?
So for the add-on testing, there were 2 labs that I had advised or helped with ordering for. That was NMS Labs and Arup Labs. And then for the arsenic testing, that went to Arup Labs.
And I would like to show you what has been marked now as, well, I'd like to show you an exhibit, please.
What referencing?
No, I want to show you my exhibit that I'm handing her. It's not offering to evidence.
Your Honor, Dr. Bergolieri cannot authenticate documents, but it's very specific. She needs to be called about what's already been introduced.
That's what I meant. You said it was an exhibit. What number?
No, it's not an exhibit that's already been introduced. She's a witness. I don't understand why I can't give her a document, and if she can authenticate it, why am I not allowed to enter it into evidence?
Let the jury step down the hallway.
Here comes the spice.
Is this something, General Norman, you referenced before this witness was called?
Yes, Your Honor, it's exactly what I referenced before this witness was called.
And what, I don't know, what tests are you talking about that haven't been made exhibits?
I'm sorry, I thought you were asking me.
No.
Your Honor, work order 23078883, which is what this is about, it was not introduced as an exhibit. Dr. Mithen did not, we did not submit it. Dr. Mithen did not testify about it.
What is it?
It is a urine test on a urine that was collected on 2/26/26 and 09/22. We did not submit that lab test through Dr. Mithen. This is part of the NMS lit pack. Dr. Mithen is not here to testify about any of the test results.
I don't know. I guess my question, why wasn't it admitted?
I'm sorry?
Why wasn't it asked about?
We purposely did not ask about it because there was confusion about the date. And that was the limited testimony of Dr. Mithen, is that we showed that the work order was not the same as the one before, that there was one urine sample from that 2/25/23 to 22/59 It was a completely different sample, and that is what was sent to CFSRE. We have had no testimony
And this
about.
one deals with what? Which one?
Deals with, that's the thing, it's not in evidence. It's a
Which?
secondary urine sample.
226, 1335, or 227, 23 at 4 o'clock?
No, it's neither, I'm saying it's not either one of those. This has not been
That's only
submitted.
3 I've seen or heard reference to in the medical.
Correct. There has not been testimony related to this, other than to point out that the work order was different, and she knew for certain that the sample transferred to CFSRE was from 225, 23, and 2259.
What are you wanting to ask this witness, Ms. Collins?
Specifically, I would like to address 2 things with this witness. There is, in fact, an email between this witness and Dr. Bethune in regards to a sample, a designer opioid screen, from 225-23 at 2259. In this email...
That's been testified about.
I'm sorry?
There have been references to that.
Yes, and there's been an issue as to whether or not that urine screen was in fact on 226 or 225. I have an email in front of me from Dr. Bruccolari where she references a sample from 225-23 at 2259. That date is extremely important to the defense because...
That's 225, 23, 2259 is not an issue.
It is an issue on our side, Your Honor.
That's...
Your Honor,
is that the urine screen you're concerned about, John Moore? 225, 23, and 2259?
That 225, 23, and 2259 is a completely separate work order, and that is in evidence, and she's more than welcome to ask about that. She is trying to ask about this other urine sample that we've had no testimony about. It was not admitted as evidence in any way, shape, or form.
Then I guess I need to go back to Ms. Holland. You've not told me anything that the state's objecting to, so what else are you wanting to ask this witness?
In addition to that, I would like to offer, there is a test from CSFRE where there is coca-ethylene that was found in the urine of Ms. Benning.
That's been testified about.
Not by this witness.
Okay, maybe you're jumping the gun. I don't know. She's apparently not asking about any other urine screen.
Judge, this email is about a urine screen that is not in evidence at all. NMS has not testified to it.
So that doesn't make...
Dr.
That doesn't
Larry
matter
cannot
if you think-
authenticate anything about the results of this test because we would have to have the NMS toxicologist to
There's
testify
not been
about.
testimony about you're saying the only testimony about coca-ethylene was from a blood test.
No, Judge, I'm talking about the emails in the first test that she wants to ask about.
There's been testimony about coca-ethylene, right?
Okay, so we're talking about a separate issue.
Coming from where?
Judge, which CFSRE report are you referring to?
2023-0090.
I have no objection to her asking
That's
about...
what I said. It sounded like we were jumping the gun.
I was going back to the original because you referenced a urine screen. And
She was talking about a urine screen.
so she's not going to be allowed to...
Show Ms. Holland the group of things that you're holding there when you're talking about objecting, and see if she has any plans of going into that.
I have one of these work orders. I am objecting.
You know, I didn't realize that my evidence was confined to what the state offered it to
Well,
evidence.
you would have to be, there would have to be a foundation for it. Who did it? Wonder what. So what is your answer to her question?
I'm not trying to offer those test results.
She's not
I
trying to
am
offer.
speaking to this email written by this witness referencing a urine sample from 225-23. The purpose of that...
Is that an issue?
It is to...
I'm not asking you.
Oh, I'm sorry.
It is if she is going to get into the lab.
She just said she wasn't.
Well, Judge...
Is that accurate?
That is correct.
All right.
And in terms of, I am wanting to get into the results of the coca-ethylene found in the CSFRE.
Judge...
In what, one of those work order numbers?
This work order...
No, the
is-
one she just showed you on her file there.
No. It's not.
On the manila file, you had two.
This work order that the email is about is this work order that is not in evidence. The email is about something that is not in evidence.
Is that accurate?
I'm not trying to enter those results, Your
Oh.
Honor. I am trying to simply enter an email from this witness referencing...
Show this witness that email and she can clear up what work order it's about.
Let's see if defense gets this in. This is what the state has been trying to prevent.
clear.
Hang on. Is all of that information you're looking at, Doctor, concerning 225, 23, 22, 59 year exclusion?
So, as best to my memory, it is not. This is in reference to a different specimen number. So at the time this was done, which was April 6, 2023, there was some differences in lab collection dates and times to what was matched in the EPIC record. I am pretty sure this is referencing the lab that was actually done at 2/26/2023 at 9:22 a.m. And this specimen did not ever go to CFSRE because it went back to the crime lab. So
Okay.
this is not
about what you're wanting to ask about.
So I'm not interested in getting in the results of that test. I am simply interested.
She's saying this email applies to a total another work order that wasn't sent in MS.
Again, I am not trying to enter into evidence any results from any test.
But why would you want an email about a test that wasn't tested?
Because there's a date on there that is very important to
Ask
my
her what you're
client's
wanting to
case.
ask.
Thank you. Is there a date that you are referencing in your email, Dr. Brucalera?
Yes, and I am saying at that time it was incorrect because when you backtrace this work order to the specimen ID into the EPIC medical record, it is a different date and time which was not discovered until after this email was sent.
And that's fine. I just want to reference the actual date that you have in that email. Back on April, I believe it's the 6th of 2023.
The date that I have is 2/25/23 at 22:59.
Thank you. That's all I needed.
Wow.
And then,
She's saying that's not accurate.
I understand.
So you're
The
entitled to
state-
introduce relevant evidence, not evidence that's not relevant.
The state has made it an issue that that date is not accurate. They have made that
Well,
an
that
issue.
date's accurate.
May I finish, Your Honor?
220. You're saying the state's saying 225/23 and 22:59 is not accurate.
That is correct. They have stated that in their
No,
case
they're
in
not
chief.
stating that. That's accurate. But you're asking about another work order that's not been testified to in the record, so how do we know what the results were?
I'm not trying to get into the results.
But you're
of
wanting
that
an email
test.
to confuse the jury about what's going on here, right?
Sir, I'm not.
Okay, well, I'm not allowed this email, so is anything else?
That's fine.
All right, let the jury step
I'm
up there.
not done. I have another test. As I stated, there is another work order that Dr. Brucalera is aware of where Ms. Benning tested positive for cocaethylene. I simply want her to have the opportunity to testify about that because
What
it goes
work
to my
order is that?
clients. It is work order number 2023-0090.
Was that tested
Yes, it was.
by Vanderbilt?
Yes, it was tested by Vanderbilt, but what's in question is what went to CSFRE, which is
What?
it went to the Center for Forensic Research and Education.
But your hospital tested it and it showed what?
So it went to NMS lab. So our hospital drew it, sent it to NMS
The
lab.
hospital didn't test it.
Our hospital sent it for extended drug screening to NMS. I do not.
Vanderbilt Hospital test what she's asking about.
Could you repeat the question, Your Honor?
Did Vanderbilt Hospital test what this lawyer is asking about?
I don't know if they ran tests on that sample themselves.
She has personal knowledge that Ms. Benning tested positive for cocaethylene.
Is that accurate?
Yes.
From what source?
That's from the Center for Forensic Research and Education.
She didn't do the testing.
But she has personal knowledge.
It'd be hearsay.
She's a toxicologist, Your Honor. And she's treated Jane
But
Benning.
you want everything to be reliable, right?
No, what I would like is
I
for
don't want
this.
everything to be reliable.
May I finish, sir, please?
Just answer my question. You want all the test results to be reliable.
I would
right?
love for that.
Okay.
But
Well,
that's
we
not
don't
the
have the
case.
people that did this test. Did you subpoena them?
I don't need the people to be
Well,
there.
then she can't testify about the results of someone else's test.
She can testify about her personal knowledge
She doesn't
because
have personal knowledge.
she just told you she did.
It's from another testing agency.
It doesn't matter. She got.
Okay, well, I
You can
think
make
it's
your
got-
ruling, Your Honor, and that's
I
fine.
ruled, so that's out. So
And what is your
else do you
ruling?
want? I just said it's out.
Thank
What
you.
else do you want to ask her about?
There's nothing else.
Okay, let the jury step in.
Can I get my test back, please?
Sure. Subpoena somebody from the lab.
Subpoena somebody from the lab. They might do that. Might hurry and write a subpoena and get somebody in. I'm worried this judge is doing too much. I've got a completely non-relevant science question. Did I ever show you?
Any questions from this tech? All right, thank you.
Did I ever show you a magnet that attracts and then it repels without switching, moving around?
All right, yeah, get him. Somebody.
Get him. Let the lawyers step up. So we're gonna have a sidebar. While I have a sidebar, I'm going to turn off the sound because it's so loud in there. Have I ever shown you guys a magnet that that doesn't behave like a magnet? I might do a video on it for my, I don't know, my TikTok or something. It's a magnet that from far away they attract until you get close and then they repel, so they never touch. Seems strange, huh? See, it doesn't sound like a real magnet, but it's real. Okay. All right, I'm going to get it then. They break so easily. I've broken every single... I think I bought this demonstration like probably 6 times. They're just, the magnets are brittle, so they break a lot. Still waiting for the sidebar to be over. We are trying to catch up. We have to work late today. Sorry if you had plans. We might do an all... do you guys want to pull an all-nighter? I could probably zoom just a little bit, but we've got a lot of audio tweaks that involve multiple streams simultaneously being synced up, and it's one of the tricks of how I get the audio good. So I don't want to zoom unless we have to.
Let the lawyers judge.
Judge says we're not done. Sidebar number 2. I vote no on the all-nighter. The mods I think all said no. Don't sleep over what could go wrong. not a sleepover. We'd be working. It's a work party. Only if Ari makes us peanut butter and honey sandwiches. Oh, they were so good. Shelly Small, didn't watch the hearing, did see the results. It looks like we have a trial date tentatively scheduled for next year. So I'm gonna zoom a little bit because we can. Hold tight. Yep. That's the wrong one. Let's go here. We zoomed.
You have to sit back there outside, sir. Get us Mario Bartholomew.
The state is agitated a little bit. Whoa. Where did all the lawyers go? Where did all the lawyers go? Looks like the judge what probably happened right there is the judge made a ruling as to what the witness could or could not talk about specifically as a result of this series of sidebars they've had. And so now prosecution and defense went out to talk to the witness in the hall together to make sure that information is conveyed appropriately to the witness. And how's the grandbaby? Oh, good, I hope. Detective Ed, 24 months. You just got a new clerk courthouse. Congratulations. Still need to get out to see my grandbaby. Pardon me for not eating others' foods during a poison trial. Thanks for the laughing disco, Mark. Appreciate it.
I do.
Thank you very much for your support.
The attorney was going to ask you just some, I don't know about.
Hello.
Procedural matters, and unfortunately, you have not.
The bottom line issue, they're wanting to call you, okay?
Yes.
Outside the presence of the jury.
Okay, so a proffer going on, no jury.
Good afternoon.
Good afternoon.
Can you please spell your name for the record?
Mario San Bartolome, M-A-R-I-O. Last name is S-A-N-N-B-A-R-T-O-L-O-M-E.
And what do you do for a living?
I'm an addiction medicine specialist and family physician.
Oh, sweet.
And can you tell this court a little bit about your education?
Sure. I'm double board certified in family medicine and also in addiction medicine. I'm also a medical review officer, which is the individual that is involved with drug toxicologies as it relates to substances of abuse. And I currently work as an addiction medicine specialist at a community clinic overseeing a treatment and any sort of substance use related things at a federally qualified health center.
And can you tell us a little bit about your education?
Yes, I went to UC Davis for undergrad and then went to medical school at UC Irvine, followed by residency training at Long Beach Memorial, and then pretty much started practice right around that time.
And have you published any articles?
I have not.
Have you dealt with or worked at addiction treatment centers?
Yes, I have.
How many?
Approximately, I'd say 5 or 6. I've been a medical director for every level of what we consider to be along the continuum for addiction treatment. So inpatient, hospital-based detox, inpatient rehab, outpatient, intensive outpatient, and partial hospitalization programs.
And what, if any, other specialized skills and trainings you may have?
Primarily just the added medical review officer, I think, to the addiction medicine board certification.
And do you have any experience treating patients with addiction?
Yes, I do.
Do you have any experience treating pregnant women with addiction?
Yes, I do.
What about cravings? Pregnant women with cravings, is that a thing?
Do you have any experience in dealing with and or diagnosing substance use disorders?
Yes, I do.
And what would some of those be?
The substances? Is that the question?
Yes.
Oh.
Name them.
Methamphetamine, cocaine, opioids, alcohol use, cannabinoids, pretty much any substance of abuse, hallucinogens, inhalants.
Did he mention shrooms?
And what is substance use disorder?
Well, a substance use disorder is a diagnosis that's related to a chronic illness that we call a substance use disorder based off of the substance, the primary substance. And it involves biological, psychological aspects that are typically defined by somebody continuing to do things despite negative consequences.
And have you ever testified before as an expert, as a medical review officer, and a addiction specialist?
Yes, I have.
No further questions at this time, Your Honor. Okay. I would ask that he be tendered as an expert in, as a medical review officer, as well as a addiction medicine specialist.
The state's not so much concerned with his qualifications, but with the relevance.
What do you want him to opine for this jury?
I want him to opine for this. Okay.
Ask him. We'll hear it. It's a proffer.
Dr. Mario, in your experience, is pregnancy a automatic stoppage to substance use?
No.
Why not?
Well, because even though it is definitely a well-studied external motivator, in other words, if somebody is in the process of using substances and finds that they're pregnant, it is something that is associated with a higher likelihood of having motivation to stop using. But by itself, it's not something that's a guaranteed that somebody would stop using any substances.
Okay. And what is addiction medicine trying to understand?
Well, addiction medicine really deals with judgment. It deals with physiologic changes that drive somebody to have impulsivity, to have the kind of behaviors that can be harmful to them. And despite those things, there's changes in the brain that cause them to continue the behaviors that hurt them. So a lot of it has to do with judgment, and a lot of it has to do with how substances interface.
Can self-reporting in clinical settings, what is your opinion about self-reporting in clinical settings?
Well, it definitely is very valuable. That's what we base all of our screens with. People self-report. It has some limited value in that we are relying that the individual is being forthcoming. And that can be difficult in addiction because addiction also, or even without addiction, actually just with what we would consider substance use. That means no addiction, no dependence, just they happen to use a substance. But in the setting of screenings and things like that, there's a lot of stigma, unfortunately, that's attached to any substance use. And so sometimes people, they have reasons to fear being forthcoming with certain things that have to do with substances.
If you know, can you please explain what is an opioid epidemic?
Well, the opioid epidemic is currently something that we've experienced since around 1999. Currently, we're in our fourth wave of the opioid epidemic, and everyone's probably seen in the news drugs like fentanyl or heroin. These are a class of chemicals that typically we use for pain. And the first wave of that really happened somewhere around 1999, and it was around prescription drugs that doctors would prescribe, and sometimes people could get dependent on them. Now, dependency is not the same thing as addiction. It can even just be dependence. It can be around pain. However, it does leave people where if they stop using it, they experience what we call withdrawal. And withdrawal can be a pretty severe neurologic type of reaction to not having the substance, access to the substance, which then, when we clamped down on that and reduced that from the standpoint of the system, it created the second wave. And the second wave was around heroin, where people found that they could no longer access prescription drugs, and so they went to use heroin, which was cheaper and more accessible. The third wave came somewhere around 2012, 2013, which had to do with fentanyl. And that was the beginning of what we see now, where you didn't even have to be addicted. You could just actually come into contact with a very potent opioid, a synthetic opioid like fentanyl, not from a prescription, but something that was either adulterated, added to something that you thought was something else, or the very thing in question being the fentanyl. And that went on for some time, and now we're in our fourth wave. And the fourth wave involves fentanyl plus psychostimulants. And psychostimulants, that class, involves primarily methamphetamine and cocaine. And those are the second highest amount of prevalence that we see next to fentanyl in cases that involve fatal overdoses.
What scheduled drug is fentanyl?
It's a Schedule 2.
What about cocaine?
It's a Schedule 2.
What about marijuana?
It's federally still scheduled right now. This thing is a Schedule 1.
What about Adderall?
Adderall is a Schedule 2. That's a psychostimulant.
And if Adderall is a psychostimulant, does that mean it will fall within the fourth wave?
It is. It's an amphetamine.
And are counterfeit or fake Adderall pills contributing to the opioid crisis?
So that's the big thing that's happening now, and this is why the DEA has put out warnings about this. It's not that people are consciously seeking out, usually when they pass away, necessarily the combination of fentanyl with a psychostimulant. It's that oftentimes they think they're taking one thing, but it's adulterated. That means it's been added or spiked, if you will, to something else. And that can actually happen in both directions. It can happen to people that press pills and make Adderall, they'll add fentanyl, and it can also happen in the other direction.
And when clinicians assess risk, do they look at isolated events or overall behavioral patterns?
Well, an isolated event rarely leads to any sort of a diagnosis, right? So we're always collecting information. Some of the information comes from the patient. Some of it comes from corroborating avenues from other people or other things that are observed that contribute to the diagnosis. So generally, it's an overall kind of a compilation of processes that we look at, not just one thing.
And have you had the opportunity to review medical records in this case?
Yes.
Have you ever seen, do you know of a pregnant woman who normally would smoke marijuana?
Yes, that happens.
And are they always forthcoming about their use?
No. I mean, in pregnancy in particular, again, there's significant stigma, significant fear of consequences, child protective services, being judged. These things that are unfortunate that shouldn't exist, but they do exist, and I think they're even more marked in that group of people that have any sort of substance use. It doesn't even have to be cannabis. It can be any sort of substance.
And in your expert opinion, who would be amongst the most stigmatized class of people when it comes to drug use?
I believe it would be the actively pregnant woman.
Would it be judges?
I'm sorry?
Wouldn't be judges?
Wouldn't be judges.
No, I think that there are states that still, and we've had this historically, that want to put women in jail for substance use. So rather than looking at it as a medical condition, they look to remedy that by illegal action to put people away. So I think that's pretty severe. We don't do that. We don't do that to any man that I know of in the same way. And so I think that they're particularly stigmatized because there's an element of another being, the element of a child. So the concept of, well, you're hurting the child, therefore you have a separate action against you. And that's where that comes from. And I think there's also social pressures.
Sounds like he wants to.
It's a critical, delicate time as well.
And could that stigma and social pressures lead to a pregnant person concealing their substance use?
Sure, it can.
Backtracking a little bit, what about mushrooms or psilocybin? What schedule drug is that?
So psilocybin, or what's sometimes called magic mushrooms, is a Schedule 1. It's in a category we call hallucinogen, that people take it and then they can have psychedelic type of reactions to it.
Mario, I want to give you a hypothetical. If there's a pregnant young lady and she notifies her friend that she's pregnant, and that friend says, "Oh, you've been drinking," is that an example of stigmatizing a person?
Well, it can be that anytime somebody that is pregnant shares any information about any substance use, that this is why doctors get trained to have more of a poker face about it, that our concern is how do we evaluate what you need rather than judge what you did.
And in your expert opinion and in treatment, have you ever heard of someone being able to smoke mushrooms?
So in my practice, I have not heard of anybody doing that. After almost 20 years now of doing this, I think everything that could be smoked has probably been smoked by somebody at some point. However, in the case of psilocybin, combusting it or burning it actually would deactivate the active ingredient, so you wouldn't get what you wanted from it, and then you would also be inhaling a bunch of fungal spores into your lungs. So there's lots of reasons why it's something that people don't really do, even though certainly you can try it.
Spores.
And lastly, if you could just talk a little bit about how substance use impacts, if at all, the prefrontal cortex of a person.
Sure, that's really at the hallmark of all addiction. It's one of the most difficult parts to sometimes understand. People that have substance use disorders need help, and this is the reason we look at it as a disease, is because the parts of the brain that get affected, we know. We actually have studied it. We know the parts. And maybe the most frustrating part for a lot of people is How is it that somebody that maybe in other dimensions of their life function well, how is it that they can have this other component that is not functioning well? And the part of the brain that that is involved in this is right in front of your forehead, right behind your forehead. It's called the prefrontal cortex, and that's the part that controls judgment. It controls what we call executive function. It's the part that keeps you safe. It helps you make decisions. And unfortunately, certain substances impact the part of the brain that controls a neurotransmitter called dopamine. So there's really two players in the play. The dopamine pathways, which we also call the reward pathway. When you do something that is good for persistence, I mean, it obviously doesn't exist for drugs to exist. They're there because of their survival things. So increases in dopamine decrease the function of the prefrontal cortex, which is why in substance use disorders, there can be lapses in judgment.
And in your expert opinion, if a person is pregnant, but they're engaging in, let's say, facilitating drugs, what would you opine about that person's judgment?
Well, that would definitely fall under, what we consider to be part of the clinical impression. So the clinical impression, without going into a diagnosis, because you really need to do a physical exam and do a comprehensive exam to come to a diagnosis, but risk-taking is part of the hallmark of addictive disorders. So engaging with a drug dealer in any fashion certainly would fall under that, whether you're an intermediary, whether you're buying yourself, whether even just associating. I think that would be one of the signs of many that we do include in our evaluation of what a substance use disorder might be.
And again, it's not uncommon for in your experience, in your expert opinion, for a pregnant person to hide any type of substance use from their friends and family.
It's not uncommon for all people with addictive disorders, but I think even more so potentially with somebody with a pregnancy that's going on at the same time. There's a bit more to lose, I suppose, that is part of the thought process.
And along with drug or facilitating drugs, being around drugs, would a person's proclivity to engage in promiscuity be something that you would consider about the judgment? Could you assess that at all?
Well, it's something that can be, just as a general. It doesn't necessarily have to do with substances, but it certainly is any high-risk behavior where you can link, where there's typically the prefrontal cortex puts the brake on and it stops it. That would be something that could be in consideration.
Your Honor, at this time, I would like to tender Dr. Mario as an expert, as a medical review officer, and an addiction medicine specialist.
Any questions from the state?
Yes, Your Honor. Well, Doctor, would understand by that by analogy, a pregnant woman should never work as a bartender? Because they're being around.
I don't understand the question.
That they shouldn't be ingesting?
Well, so for somebody with an addictive disorder that has pregnancy, yes, my recommendation to that person would be working in a bar would probably not be the best, just because of exposure.
There is absolutely no proof in any record that you've reviewed that Jay Benning was addicted to any cocaine or any other controlled substance, is there?
Not of cocaine or no addictions.
And she was a casual user of marijuana, correct?
Well, so we don't use terms like casual user, so that would have to qualify that. I mean, we have what we consider to be misuse of drugs and then use disorders. We can't really make a determination on use disorders because a full evaluation wasn't done. The labs, the examination. She did not have a use disorder that I could state as a physician because that examination was not done. But me chats with.
I'm not asking you about misuse disorders. I'm asking you about Jay Benning. I'm not asking about other people.
I'm not talking about other people. I'm talking about Jay Benning as well.
Okay. Well, in California, is marijuana legal in California?
It is. Well, it's decriminalized, so it's
decriminalized, whatever, and actually legal in a number of states, from what I understand. Okay, do you treat people with marijuana addictions?
I do.
All right. So, do they come to you out of the blue, referred by law enforcement?
Law enforcement doesn't give me many referrals unless there's court ordered. However, I do get referrals, and I do have people that come in that tell me that their cannabis use has gotten past what they can handle, and they feel like their life's out of order.
Out of control.
Yeah.
Absolutely no indication that happened with Jay Benning, is there?
I would consider engaging with a drug dealer unusual behavior. That would be linked to, in this case, cannabis.
What gives you that information?
From the text messages that she was having between Danny, the dealer, she was getting for her coworkers and for herself, cartridges of cannabinoids, all sorts of different species of cannabinoids, some magic mushrooms. I'm sorry?
She was getting them?
She was brokering them. Some of it was promised to her, and but most of it was as an intermediary for coworkers. I would consider that to be unusual behavior, I think, for anybody to engage in that, because the risks are high. Not judging if it's a good thing or a bad thing, but to put yourself in a position to have to be an intermediary and then potentially be at risk for the consequences when you give somebody else a substance that somebody else brokered for them.
From the records you reviewed, we're talking about Adderall. There was no Adderall or any derivative of that found in Ms. Benning's system, was there?
No.
And you and I talked, and we have a time or two, at least more than say hello, that you would agree, would you not, doctor, that she died from acute cocaine toxicity by oral ingestion, correct?
Well, I'm not here to actually, my scope is not to testify on cause of death, so I would leave that to the toxicologist and Dr. Larkin.
Well, did you not tell me that you would agree with that finding?
Objection, Your Honor. Witness has already stated.
Right. And that, how many people have you ever treated at your clinic or for being addicted to orally ingesting cocaine?
That's exceedingly rare. I mean, I know that people use it in their gums, they've had it in their mouth, but there's definitely not been a lot. That's not, actually, in general, that's not a common way. Yeah, so. Because
they die?
No. That's not why. It's because it actually takes longer to get the effect, number one. Number two is because it actually deactivates a lot of it, so it's hard to get the same effect that you could get if you snorted it, you smoked it, or you injected it. That's the reason why. And it's quite a hierarchy that can be applied to most things, actually. If the particular substance isn't particularly absorbed well with how you take it, that's not how it's used.
There is absolutely no indication, doctor, is there from the medical records that Jade Benning consumed any drug or alcohol after she found out she was pregnant? Is there?
Correct, not medical records, no.
And so, nothing that you have testified about is based on any personal interaction with Jade Benning, correct?
That's correct.
Either during her lifetime or from obviously the review of the records. There is just nothing there.
Yeah, I have not personally evaluated Ms. Benning.
And the phases of heroin has nothing to do with this, does it?
No. Are you referring to the different?
Your epidemics.
Yeah, well, they're not mine. They actually are ours. But I mean, the heroin was just one stage of that, and so that was just one to kind of explain why there are different stages of that exist. That the most recent one is fentanyl and psychostimulants.
But your testimony about the phases. What was before heroin?
Before heroin was prescription drugs.
Before prescription drugs.
Well, that's the first one. Prescription drugs, then there was heroin, then there's fentanyl, and then there's fentanyl with psychostimulants. That's the four. And we're likely to answer a fifth one now with xylazine, which are like anesthetics that are being adulterated into the supply of fentanyl.
And back in the 70s, there were other substances.
Back in the 70s, a whole other time of what was available, so I'm not really speaking to that.
That's all.
Okay. Thank you.
Thank you.
Step down, step back outside. Oh, you got more questions?
Not done yet.
Maureen, can you explain what cocaethylene is?
Cocaethylene is a byproduct.
Your Honor, I object. Wasn't covered on direct or cross-examination.
Okay.
It's a proffer.
Treatment. Specialist addiction medicine.
Yes, Your Honor, and cocaine and alcohol was just referenced.
Is that what you plan on getting into with Dr. Larkin if she tests with us? We've already heard testimony about it, right?
Yes, Your Honor, but however, what was just elicited from Dr. Mario was about a person working in a bar, and was there ever any evidence of any uses of cocaine with Mrs. Benning?
Is he aware of any usage of cocaine?
Are you aware on whether or not the substance cocaethylene was found in Ms. Jade Benning's system?
Well, my understanding is that there's one of the lab reports that did show that there was cocaethylene. It sounds like there's probably contested. It's maybe for the. Go ahead.
What is cocaethylene a byproduct?
Well, so when you consume alcohol in the setting of cocaine, you produce a compound called cocaethylene. It creates a high toxic environment, so your heart will work harder. All the things that normally cocaine will cause, it can make it worse, and it's one of the known problems, right, with combining those.
And can alcohol be an addiction? Can it be abused?
Yes.
Can it be misused?
It can.
And can you be a casual cocaine user?
You can. You can be a casual cocaine user, somebody that uses not with great frequency. It's possible. It's possible with alcohol as well.
Any other questions?
So you can be a casual cocaine user, but not a casual marijuana user?
I don't think I said you can't be a casual marijuana user. That you can't be a casual? No, I don't think I would have said that. I mean, if I did, I misspoke. But you absolutely can. You can be a casual.
You wouldn't use the word casual.
Yeah, I wouldn't use casual because in the context of what you were talking about, it was.
He's asking you can be a casual cocaine user.
So you can be. So if the definition of that is that somebody uses infrequently, if that's what your definition is. When we discussed the issue of the marijuana, I thought you were talking about something more like diagnostic. I just wouldn't use those words for something diagnostic. But they both can be used with low frequencies, for sure.
Doctor, about the cocaethylene, you said someone told you about that?
No, I've seen it in the reports from one of the labs. But again, I'm not here to testify in my scope about that. I think you have a toxicologist and you're going to have Dr. Larkin on that.
And what you said, did you prepare a report about all of this?
I did not. I don't have a report.
That's all right.
Do you prepare any notes? Step out. We're going to decide if you get to tell the jury any of this.
Yes, Your Honor. Yes, Your Honor. State renews objection to this doctor testifying under Rule 702. There's been nothing that he has testified about. In fact, knowledge of this incident, no knowledge was being other than she was not addicted. All this testimony would have to come under Rule 702 that it is would substantially assist the trier of fact jury. And the Merriam-Webster dictionary, synonym is important or essential. This testimony is not anywhere close to being essential. It's irrelevant. It is designed to, if anything, just attempt to paint Ms. Benning as someone she was not. I would ask the court to exclude this testimony in its entirety.
Sure. Donna, it is not only important, but it's a vital and critical issue that the state has put before this jury through multiple witnesses, which is the fact that Ms. Benning would not engage in any type of drug use or behavior because she was pregnant. And so it is very...
They didn't say that. They said there's not any proof that she did.
And, Your Honor, we believe the contrary. We intend to get into that.
But this gentleman doesn't know that.
Yes, he does, Your Honor. He has reviewed text messages that suggest she was offered drugs while she was in fact pregnant.
He testified that it has no
He got
evidence.
to the text messages, but if those come in, then they come in. He doesn't have to interpret them.
No, but certainly they are evidence of the lifestyle that Ms. Benning was engaged in. The state certainly has taken the position that it is a barrier to her being involved in anything illicit because she was in fact pregnant. And so the defense has a right to put on evidence before this jury that simply being pregnant is not a reasonable statement of sobriety in and of itself.
I asked the state that 2 hours ago, and they agreed with me.
But, Your Honor, they can take that position because they have rested. They've already paraded a bunch of witnesses before this jury who have said otherwise.
So you think you need this person to tell the jury that women that are pregnant can still use drugs?
And that they are stigmatized, and that may be a reason that they would not disclose to family members and loved ones.
Okay.
Oh, man. You need this witness to tell pregnant women they can't use drugs.
The cocaethylene that was brought on redirect and then recross, as the witness said, he's not here to interpret what that, he knows what it is, but he's not here to say one way or the other about what that means for Ms. Benning. the other proffer involving pregnancy, not being an automatic stop from using drugs, pregnant women can still use drugs, the testimony about fentanyl overdose or epidemics, I don't know if that word was used, the detective's already been asked about, testified. There's no proof, and this witness has said he doesn't assess Miss Benning as being an addictive disorder person, patient, if she were one of his patients. So under, I mean, he's a fine gentleman, useful in his field, I'm sure, but 702 requires the court to assure that there is some issue that the jury wouldn't know about and that his testimony would substantially assist the trier of fact in some issue to be determined. And the court just doesn't find that. So no need for Dr. San Bartolo. What?
No need for the doctor.
We've already had the offer of proof.
There's one other thing that I would like to add, and that is the state has put an issue that since Miss Benning has become pregnant, she is now leading this clean life. Miss Benning is...
Like I said to your co-counsel, they're putting on proof that there's no proof she did use.
However, Your Honor, she is heavily involved with the sale of drugs.
Right.
That is dangerous behavior in and of itself.
Okay.
The jury needs to be educated in regards to...
And what proof is there that she was involved in dangerous drugs on the day or in and around the day she died?
Because on that very day, she reached out to her drug dealer. The very day she passed...
Any proof that she met with him?
We don't know.
Okay. Well, your Dr. Larkin says on the day of her death, text messages indicate that Jade met with her drug dealer. You just said that inaccurate.
Well, I think an inference can be made that she did.
You just said she didn't.
And you asked me, is there any proof that she did?
That's what we deal with, is proof.
Well, we have to be able to put on a defensive theory. So all I
Sure,
have to say...
I haven't figured out relevancy-wise what it is, but that's where I'm trying to get to.
What's relevant is...
But I've already ruled on Dr. San Bartolo.
If I could just say, what's relevant is the doctor stated about the most stigmatized person when it comes to drugs is the pregnant woman, which means that she will do whatever she can to hide her interaction, use, dealing with drugs, such that her family
Just
will not
present
know.
proof, if you have it, that she was using drugs. That's all you have
There's
to do.
no proof, Mr. Taylor did this either, but there is an inference being made. In that same instance, we would like to make the inference in regard to Ms. Baker.
And I ruled, like you've asked me to do. Now, what did the state determine about Bumble?
Your Honor, Tom Miller is on his way over. I do not believe that this is active use for Bumble. I do not think it should be admitted. I would like to have a jury out on it.
Okay, where is Mr. Kevin? Bring him in. We'll hear what he says this means. And is the state opposed to the other text messages?
Yes.
I am opposed.
Some of them have already been mentioned and introduced or talked about.
I am opposed to the one on 120-23.
121-23 dealing with what? They got them categorized as discussion with Blaise.
I'm sorry, it's like it's under the drugs category.
Okay. Which, is there a page? I got a 5, a 6, and a 7?
4.
4. That's the metadata with the message. Could I get an 8 in the top shelf?
Correct.
What is your objection?
My objection is she's not ordering this for herself. It's in January and it's not relevant. We've already had testimony related to the same thing.
Correct, but they can put on other proof. What's your other objection?
On page 5, that is a received message, not a sent message.
I don't know what Mr. Edmund's going to say. So it's received, but it's still drug related, right?
Correct.
Okay. Anything else?
Yes, on 6, it's from 11/5/22 and it's received. And the state submits it's not relevant.
Okay. What else?
Also number 7, it's received. It's from January 18th of 2023.
Okay. Anything else?
On page 8, the reference to Adderall, I feel like we've already been through. This is not Adderall that Ms. Benning was requesting for herself. It was for her friend that was...
Right. We just confirms that, right?
I'm sorry?
This just confirms that. That's
Yes.
for someone else.
No. Right, this is like someone else is asking for it, not Ms. Benning.
Anything else? Anything else?
Number 8, I feel like actually clears up the
That's the
Mario
one you just
situation.
asked about.
I'm sorry?
That's the one you just mentioned.
I'm sorry, that was number 9, was the one that kind of clears up the Mario situation because she wasn't ordering it herself. On number 10, there's no date on this. Also, it just seems cumulative. So there's no date for the message sent. There is a date. They just cut it off. And the thread, they included 235 messages, which doesn't seem useful, but it doesn't tell you what date this message was sent.
Okay. We'll see what they have to say in their prompt. Anything else?
Number 11, like everything, he's printing stuff without the usernames in it. This message would have a username, but it's clearly someone else asking for narcotics. It just seems like it's Mario, and that would be important to the other text.
Anything else?
12, I don't have an objection. Pages 13 through 15, no objection. Communication with Blaise Taylor, no objection. Plans with Blaise Taylor. Again, I don't have a specific objection. I just have no idea why we would submit a message without the person the message is sent to. And then the Bumble, I have a giant problem with.
Okay, we'll hear about that.
And the Jerry and Porter messages, the state's objection is that these are not relevant to any issue before the court.
According to the defense theory, it shows you talking with another guy, texting another guy.
No giant problem here.
These are texts from December.
Right.
The first page is from December, so she's not even speaking to Mr. Taylor then.
All right, if you'll step up, Mr. Devlin, raise your right hand and be sworn.
Still jury out.
I do. All right, if you will, in your proper clear up whether your person here, witness, knows anything about page 23 and what that means, 22 and 23.
Why does he have a computer up there?
Mr. Devlin, could you please state and spell your name for the record?
Sure. My name is Eric, E-R-I-C. Last name is Devlin, D-E-V-L-I-N.
And Mr. Devlin, how are you employed, sir?
I'm currently the managing director of the Lone Star Forensic Group, a digital forensics company based in Houston, Texas.
And could you give the court your credentials in regards to the digital forensics?
I have an undergraduate degree in history, political science, and film at Southern Methodist University. I have a law degree at South Texas College of Law. After graduating from South Texas College of Law, I took the bar exam, passed the bar exam, became a prosecutor at the Harris County District Attorney's Office, which is Houston's DA's office. I was a prosecutor there. I tried everything from traffic tickets to death penalty cases. I spent most of my time as the chief of the cybercrime, human trafficking, and child exploitation divisions. After I left the DA's office, I opened a forensic company. And I've received thousands of hours of forensic training. I have certifications through a variety of platforms. I have examined thousands of cell phones. I have testified in state court, federal court. I've testified in, so far, I've testified in Ohio, Texas, Florida, South Carolina, and Indiana.
And he has a cinnamon sugar beard.
And have you had any specialized training in regards to cell phones particularly?
Yes, I have specialized training from Celebrite. I have specialized training from magnet forensics. I have specialized training in generic phone forensics. I also have advanced smartphone training.
Have you had any occasion to publish any publications and or articles?
Yes.
Have you been certified as an expert in forensics, digital forensics, prior to today?
Yes.
And will you be opining in or giving information today from the cell phone and dump and or forensic download of Ms. Jade Benning's phone?
Yes, ma'am.
At this time, I would tender Mr. Devlin as a forensic expert with the cell phone of Ms.
Tell us what page 23 means.
What does page 23 mean?
It starts on page 22, but page 23 specifically is the activation of the application for Bumble, which is a social contact application. This indicates when you go from the springboard, which is the basic function of the screen, opening that particular application.
And does this, or do the notations that we find on page 23 actually state that Ms. Benning opened that application and interacted with it?
I can't say Ms. Benning did. I can say that this phone opened.
Thank you. And did they do so on each and every occasion? Did this phone, every notation that we see here, did it in fact interact with the Bumble application?
Each one of these is an interaction with the Bumble application.
And it's not simply just a notification?
No.
Interacting how?
Either opening it, closing it, switching it, adding in, making contact with the actual application.
Can you tell me that Ms. Benning was communicating with, accessing information about other men?
No, sir.
Can you tell us what is the purpose of the Bumble application? What is its purpose? What is involved?
The Bumble application describes itself as a social contact application. So while many people use it for the purpose of dating or hookups or other interaction, other people use it as a contact social media application that time.
Business purposes mostly.
What can you tell us she was doing?
I can't. Just that the application is being interacted with. And the application was installed previous. So.
Can you give us, can you give us a date that this application was installed on Ms. Benning's home?
I show an application, an installation of the application on 2/17/23, and I see another installation on 2/22/2023.
Any other questions?
So he's going to testify that she opened up Bumble on her phone a couple times and used the app.
Mr. Devlin, did you pull out the information where Ms. Benning registered with Bumble August 6th of 2022?
I didn't see that part.
Okay, so you were searching specifically for user activity on Bumble, and you didn't just put Bumble in as a search term in the Axiom software.
When I was, sorry.
Did you not do that?
I did enter Bumble as a search term, that's correct.
Okay, but you missed where she got a text message from Bumble with her registration code on August 6th of 2022 at 12/17/27.
Your Honor, if I could just note, that would have been during the date-limited portion of our search.
No, you wanted to go back to January 2022.
I don't think you're allowed to go back on those issues. You were limited to certain issues that we could search.
No.
Well, you're wanting this witness to testify about her accessing Bumble, and they're asking their question. Go ahead.
And so if this same database that you have here on page 23, if there's activity on here after Jake Benning's death and after the phone is in police custody, do you think you might change your opinion as to whether or not this is user activity or if it's just updates within the Bumble app?
The Bumble app can have updates, absolutely, as a part of it, depending on if the phone is powered on and connected to the networks. I did see actually registration codes. I did see other messages that were what we call system-generated messages, but I didn't see any messages at all on here with her communicating with anybody on the Bumble app. So
no messages with Ms. Benning communicating with anyone on the Bumble app?
Not that was recovered, no ma'am.
So it's possible that she could have even gone in to look at one of her girlfriend's profiles just to give her some feedback as a nice friend.
Some people do that, yes ma'am.
And Your Honor, I would think that that is a point for cross-examination.
Do you have any other questions?
You're speaking to me? Are you speaking to me or this?
To you.
Yes, I do.
Did you find entries like this after the date of death?
I haven't noticed it, Your Honor, so I didn't look for that particular. So
you didn't look after 3/6?
No, sir.
Okay.
When you looked at the Bumble application, did you pay close attention to whether or not the application itself was interacted with as opposed to just a notification?
These logs here are not notification logs. These are actual interactions with the application.
And when you say interactions, what do you mean?
That means the application was opened, the application was interacted with. I don't know what they did with it. I don't know if they searched for somebody. I don't know if they communicated with somebody, but there was an interaction with the application. That's as far as I can see on here.
So then it is a possibility that if she interacted with this Bumble, it could be that she was looking at dating men.
It's possible.
So in the same manner that she could have been trying to message a friend or a girlfriend to check on her, she also could have been messaging a man to try to date.
Could be, yes ma'am.
Again, Your Honor, based on...
Do you have any other questions?
No, I do not at this time.
Does the state have any other questions?
Not related to the Bumble app.
Okay. All right, thank you, sir. You can wait right back out.
Thank you.
Out he goes. Will the judge allow this one? She
opened the Bumble app. There's no evidence that she used it to communicate with anybody.
First two pages, columns 22 and 23, prove that Miss Benning was dating other men.
I think it infers that she was dating other men. There are other messages that we also believe that she was dating other men in connection with that. And so,
what are you speaking of?
I'm speaking of in December, when she was in fact pregnant and living a clean life, she sent naked photographs to 3 different men. These things.
That's not in what you said.
It's not, because I did not want to put that type of information in here, but it is important.
So you're not planning on asking about that?
I do plan on asking about that. That's why I'm bringing it to the court's attention now, because the state has...
So what other texts are you wanting to introduce to this jury?
Outside of this, I want those text messages.
Where are they?
In December. I did not want to print out those types of photographs.
You're wanting the jury to see them, right?
No, I do not. I would just like for them to hear about them. That's why I never printed them. I was not going to print those text messages. Neither did I want to make them a part of the record. But I do want to talk about them. It is only fair that Mr. Taylor, who has been painted as someone who doesn't care, dating other women while he's with Miss Benning, that he is not afforded the opportunity to show.
Trash her.
No, they're trashing him, if that's the case.
So you want to trash her?
No, I want the jury to have all the facts, Your Honor. That is all.
That would be great if in fact it's proven.
Well, I can tell you those 3 messages are proven in December.
Has the state seen those?
No, the state has not seen them.
Well, I thought you downloaded her phone.
I haven't looked at every single thing on her phone, and particularly whether or not she's dating men in December when they're broken up. The state's position is irrelevant.
That's the first time in 7 days I've heard that. So back to the pages 22 and 23. What does that show me under 401?
What it shows is that Bumble is known to be a dating application. It is not known to be a place where you go and look, say hello to a friend.
He said it was.
He said it was one of the things you can do.
Well, then I'm saying it wasn't, because your witness just said it was.
He said that in response to the state's question if it was a possibility. He said yes.
He says that happens.
It's a possibility. But that is not the primary purpose of Bumble. That might be the primary purpose of Instagram, TikTok, Facebook, but it is not the primary purpose of Bumble.
So Bumble, Tinder, and Hinge are in their own class.
I doubt you would, but I was just asking that if you want to inquire with your witness, Mr. Devlin, about the application, Bumble application being installed on 217 and 223, that the state can also ask him if he looked at August of 2022 when it was installed.
Yes.
And your position is what?
If the state can talk about August of 22?
Just ask what they asked when the witness was in here.
We were confined, Your Honor, to a search period.
So is it fair to the jury to know that she also installed it on another occasion?
I don't have a problem with that.
Okay, that's what I asked. Okay, the other issues that the state had, you can cross-examine, find out dates, find out whether it's received. I mean, if it's received, some of these, quote, drug, quote, involvements, it's received, so. It's like dating men. What does that have to do with 225? Lord, if I know, just like these others. But that's one of their many theories. So remove page 23 from your PowerPoint and or exhibit. I'll let you ask your witness about these other texts and slides that you wanted to introduce. Is he the next witness?
He is, Your Honor.
Do y'all need a break?
Well,
and you can cross-examine, find out dates, find out whether it's received. I mean, if it's received, some of these, quote, drug, quote, involvements, it's received, so. It's like dating men. What does that have to do with 225? Lord, if I know. just
We
like
went back a little bit, sorry.
these others, but that's one of their many theories. So remove page 23 from your PowerPoint and or exhibit. I'll let you ask your witness about these other texts and slides that you wanted to introduce. Is he the next witness?
He is, Your Honor.
Do y'all need a break?
But he needs to get on the plane, so I can wait if you don't mind, so that he can make his flight. I will wait for my break.
Okay. All right, let Mr. Devlin step back in and bring the jury down.
Judge, are you keeping out all three of the Bumble references?
I don't think, you're talking about the one sheet that says Bumble?
Yeah, I don't know why you bring it up if you're keeping the other pages
Well,
out.
22
and 23 are the Bumble pages.
22 just confirms that, according to him, she installed it. So you can pull out 21 and 23 and ask him about 22.
Okay, so 20, because I have the presentation on my own. So 22 can stay in, 23 comes out.
And 21, 23 come out.
I don't have an objection to 21 and 22 to staying in. I was trying to clarify that before.
Well, 21 is just some creep. It just doesn't matter. You can ask him about 22. All right.
The defense calls Eric.
Okay, there, we're not in here yet.
Oh.
Jury's not here. You gotta wait. Oh my goodness. Okay, we are catching up. The closings in this case are going to happen tomorrow.
Your Honor, I'm assuming he can be present for this.
Okay.
Which means we need to fly through a lot of stuff today.
To be clear, what page are we taking out?
Do you have Mr. Brand?
Yes, I have it. Page 23, I have
Defense has been neutered in their case in chief. Expert witnesses been pruned from their. Just turned on the fan in there. It's loud. Expert witnesses have been pruned from their the list. The judge saying we don't need that. That will just confuse the jury. We're not allowing that in. The creep is irrelevant. The bumbling case has gone off the hinges. This is what happens when you want to tender your witness, right? I mean, tender your... Just kidding. That's funny. Do they not do motions in limine in Tennessee? Apparently not enough. We need to do more.
Defense calls Eric Devlin.
You swear the testimony you're about to give to be the truth, so help you God.
I do.
Mr. Devlin, could you please state and spell your name for the record, please?
Sure. My name is Eric, E-R-I-C. Last name is Devlin, D-E-V-L-I-N.
And I'm from Texas, where everything's bigger.
At the present time, I'm the managing director of the Lone Star Forensic Group. We're a digital forensics company based out of Houston, Texas.
And where did you get your education, sir?
My undergraduate degree is from Southern Methodist University. My law degree is actually out of South Texas College of Law based in Houston.
And did you take the bar?
I did.
And did you pass the bar?
I did pass the bar.
And after you passed the bar, can you tell the jury how you were employed?
I was employed at the Harris County District Attorney's Office, so that is the prosecution office for the city of Houston. I was there, I prosecuted everything from traffic tickets up to death penalty cases, but I spent most of my time as the chief of the cybercrime, child exploitation, and human trafficking sections.
Have you had any specified training as it relates to digital forensics?
Yes. While I was a prosecutor, I actually began taking forensic courses to be a better prosecutor, present those cases in court better. While I was taking those classes, I actually realized I liked that better than the practice of law. So when I left the district attorney's office, I opened a forensic company, and I've continued taking forensic classes in a variety of courses, both cell phones, computers, as well as cell location analysis, as well as surveillance systems and other recording systems.
This man talks faster than all of their Texans combined.
Specifically to digital forensics?
Yes. I have received thousands of hours of specialized training, everything from Celebrite, Magnet Axiom, as well as a variety of other forensic courses specifically. I've also received advanced training in smartphone examinations.
And have you been published, or have you published articles in regards to digital forensics?
Yes, I have published articles related to digital forensics, cybercrime investigation, and child exploitation.
And have you had the occasion to testify before in digital forensics?
Yes, I frequently testify in Houston, where I'm based out of, but I've also testified in Florida, South Carolina, Ohio,
And I think I'm missing a couple. So,
And have you had the occasion to testify on both sides, for the prosecution and the defense?
I more frequently testify for the state side than for the defense, but I do testify for both. So,
Thank you. At this time, I would tender Mr. Devlin as an expert in digital forensics.
Any questions from the state?
And I would offer Mr. Devlin's CV as an expert.
Okay, get that, the signature one. All right. All right, again, ladies and gentlemen of the jury, Mr. Devlin will be allowed to testify in his field of digital forensics. You can place such weight as you choose to upon his testimony. All right.
Mr. Devlin, have you had the opportunity to review the digital download of Jade Benning's phone?
yes.
And in doing so, have we asked you to locate specific text messages, not all of them, but just a representative of some text messages?
Yes.
Specifically, I'd like to draw you to page 3.
Yes, ma'am.
Did you find any text messages within Ms. Benning's phone that dealt with drugs?
Yes, I examined an Apple iPhone 13. I was asked to examine and review the forensic extraction that was done by law enforcement. I did find a variety of messages related to drugs and other narcotics activity.
And can we start on page 4, if you will, and explain to us what is that we see there?
This is actually a Snapchat message. So this message was between Danny, the Snapchat ID, Danny Wallace Jr. and a Jade Benning. This activity occurred on 1/20/2023, approximately 6:53:47 p.m. This was in Central Standard Time, so that sometimes changes based on the phone. This was a message that the user account Jade Benning posted to the Danny Wallace Jr., specifically stating, hey, could I get an 1/8 of top shelf and 1 Sativa or hybrid cart?
Danny Wallace Jr. Is this Danny Weed?
Do you happen to know what a sativa and hybrid cart is?
I am familiar with it. I am familiar that they are narcotics. I am not familiar with exactly what kind of narcotics they are.
So we'll draw your attention to page 5.
Yes, ma'am.
What date is that, sir?
This was 2/3/2023, approximately 9:57:21 p.m.
And is this message from or to Jade Benning?
This is a message from Jade Benning.
And could you read the message for us, please?
It says apple fritter with the emoji of a fire sign, $25, 1/8, $50 quarter, $100 half, $150 zip.
Thank you. And on to page 6, please. Is this message to or from Ms. Benning?
This is a message that was posted inside the Telegram chat room, so it's not one sent by Ms. Benning, but it was received on this device.
What is a Telegram chat room?
Telegram is a social media site, communication site. It's created by an individual out of Russia. It is advertised itself as to be super encrypted. It is not a good place. So.
And was this application downloaded on Ms. Benning's phone?
Yes, ma'am.
Telegram.
Can I draw your attention to page 7? Is this message to or from Ms. Benning?
This is a message posted in that gas station chat room on the Telegram application.
What is a gas station chat room?
On Telegram, you can create all kinds of chat rooms and invite whoever you want to be as a part of it. That's one that occurs, and actually in narcotics activity frequently occurs this way. It allows them to advertise sales or purchases or deliveries of different types of substances, and it's, again, believed to be encrypted and heavily anonymous. So.
And could you read for us the message that's on this particular date?
It says pressure plus with the emoji for a carts with a fire, $30 a pop, price cut on 2+.
Could I draw your attention to page 8?
Yes, ma'am.
Could you explain to the jury what this represents, what page 8 represents?
This is an actual iOS text message, so this is a communication between this particular device and another individual. That individual they're communicating with is phone number 501-451-0608.
And could you read for us the text message?
The text message start at 11/22/2022, 10:40:13 a.m. Do of your coworkers get Adderall? The reply, Lauren has some. Message again, ooh, what MG? The reply was 15. Message to this particular device, ooh, ask her, can I buy some? And then the next was a follow-up. This is still a message to this particular device. And what color are they? And the reply from this device was orange.
And to the left there, who do you see is the sender of this text message?
The sender of this message is this number is listed in the contacts as belonging to, and I'm going to kill the name,
Nijaha, Nijaiha.
Nigeria?
Yes, ma'am.
And what is the date of that text message, sir?
11/22/2022.
Can I draw your attention to page 9?
Yes, ma'am.
And could you read for the jury what page 9 represents with the date as well as the context?
This is an iOS text message, and this is between the Jade Binning account and Mario Gutierrez account. On this message, it occurs on 2/18/2023, 9:33:02. The message was from the Jade Binning account saying he's about to bring your weed. There's a reply from the Mario Gutierrez account, says I fell asleep, and I don't know if I'm allowed to curse in this courtroom or not.
That's okay, thank you. Could you please turn your attention to page 10?
Yes, ma'am.
And could you represent to the jury what page 10 represents?
Page 10 is a iOS communication between the contact Danny, in parentheses weed, and this particular device. On this one, the message is, I have mushrooms right now? LOL, my coworker's wanting some.
And on what date is this text message?
I appear to have cut the date off on that text message. I can't tell you.
Okay, thank you. Would it be between the dates that you have listed there where it says first message, last message?
Yes, ma'am.
Thank you. And those dates would be between April 6th of 22 and 2/25 of 23?
Yes, ma'am.
Could you now go to page 11?
Yes, ma'am.
And what does page 11 represent?
These are text messages, specifically occurring on 2/25/2023, 9:10:46 a.m.
And what does the message say?
The message says, yo, can you holler at Danny? Your boy needs a half, please and thanks.
Now, I don't see who this message was sent to. Do you have that information, Mr. W?
I do not have that information.
And what date is on this text?
This text here is 2/25/2023 at 9:10:46 a.m.
On page 12, can you tell us what page 12 represents?
Page 12 is a text message between Jade Binning and the contact Danny Weed, and it occurs on 2/25/2023, beginning at 3:39:21 p.m.
And what does it say?
Specifically, it says, hey, my coworker wants to get a half from you. The account Danny Weed replies, bet I gotcha when I get back. The account for Jade Binning replies, sweet.
Now, did you ever find through your research whether or not page 11 was a message from Mario Gutierrez?
I got to be honest, I don't remember. So,
thank you. I want to draw your attention to page 13.
Yes, ma'am.
Now, before we move on, were those all of the text message that involved drugs in between with Jade's phone from January of 22 through February of 23?
No, ma'am. They were a sampling.
Okay. Let's now go to page 13. What section would this subject matter address?
I was asked to look for conversations about Blaise Taylor.
I'm going to draw your attention to page 14.
Yes, ma'am.
Please read for the jury the text message.
This is an iOS text message starting 12/31/2022 at 2:55:57 p.m. from the account 501-541-0608. Send a message saying, I'm interested. Followed up with another message of, did you text or are you just going to wait? The account belonging to this particular device replied, he called me back. And then a second reply of, I told him that I would call him when I get off. The account ending in 0608 replied, oh, I don't know, I didn't know you answered. And with a second reply of, how was his tone?
Do you know who this number 501-541-0608 belongs to?
I believe that's the same name that you gave me earlier that I butchered, so.
Nigeria.
Yes, ma'am.
I'm going to draw your attention to page 15. And what is the text message thread, please?
On this one, it's a continuation from the previous page. It's the account belonging to this particular device replies, he sounded the same as always, but I could tell he had something he needed to talk about, of course. The account ending in 0608 replied, why am I anxious like I'm talking to him? This device's account replies, LMAO, because I've been waiting for this. The account with 0608 replied with, get off work already, LOL. The account for this device replied, right, I keep looking at my watch. And then the final message on there is a reply from the 0608 account. Keep me updated.
I now want to draw your attention to the next section. Could you tell us the subject matter of this next section?
On the next one, there's communications with Blaise Taylor.
And can I draw your attention to page 17?
Yes.
Can you please read that text thread for us?
Yes. In fact, I'm sorry, these are smaller, so I may read it from your larger screen. This particular account, the local user account, initiated a message saying, "Thank you for coming to help/see the new place. I'm glad we got to talk about all that we did. It gave me a better understanding on some things I didn't have before. I hope you feel a little better as well, babes," with an emoji. The reply was from the phone number ending in 5738. "Thanks and no problem. Just wanted to keep communicating and stay on the same page." The second reply of "Loved. Thank you for coming to help and see the new place. I ... This account replied, "100% agree with you." Another reply, "100% also turns me on when we have our talks." The account ending in 5738 replied, "Laughed at 100%, also turns me on when we have our talks." With another reply of "Why, LOL." Then another message of, "I feel like most of the time it's really me telling you stuff you probably don't want to hear."
Now, in regards to this text message, is this Jake Benning's phone in the blue?
It is.
Can we now move to page 8?
This is a continuation of that text thread. The account ending in 5738. "I feel like most of the time it really me telling you stuff you probably don't want to hear." The next message was from the Jake Benning account. "Not necessarily. You're just keeping it real at the end of the day, and that's all I ask of you. And because to see you serious for one, LOL, and us being able to calmly communicate about the situations we have in front of us just lights me up." The account ending in 5738 replies, "LOL, okay. Well, I said I'll always be upfront and answer any questions you have." This account here for this device replied, "Heard you." And this device, this account, the one ending in 5738, was under the contact name of Blaise.
Thank you. Let's now move to page 19. And what subject matter is this section?
This specifically is related to messages regarding plans with Blaise Taylor.
And can I get you to turn to page 20?
Yes, ma'am.
And could you read for us the text message here?
This message was on 2/25/2023 at 12:03:10 p.m. The message was sent saying, "Okay, LOL, I'm going to plan to do a little at-home paint with Blaise tonight."
And what date is that text message?
2/25/2023.
Can we now move to the next section?
Yes, ma'am.
And what section is this?
The label on it is Bumble.
Can you please identify page 22 and explain to the jury exactly what this is?
This specifically is a set of logs related to the installation of the Bumble application.
What is the Bumble application?
Bumble is an application that's on both iOS and Android devices. It's described as a social contact application.
And what day do you see that this particular phone installed the Bumble application?
There is an install of 2/17/2023 and another installation date of 2/22/2023.
And can I draw your attention to page 24?
Yes, ma'am.
And what is the nature of this section?
I was asked to find some communications related to Jarius Porter.
And can you read for us on page 25?
Yes, ma'am. On page 25, the communications start 12/17/2022, 9/17:30 p.m. It's a message from this particular device to the porterjarius@gmail.com. You've been getting it the last few. The porterjarius@gmail.com replies, "Yep, I'm on my way back to the shape I was before. I started dating a world-class chef." The message, this particular device replied, "LMAO, I heard that." And then a second reply of, "That's good though."
Okay. And can you move now to page 26?
Yes, ma'am. And these are, there's a lot of messages in between, but it was designed to give basically an idea of the length of the conversations. So these messages occur on 1/24/2023 at 1:12:02 p.m. This message from porterjarius@gmail.com. "That's good. I'm glad you have to."
Let me
You want to switch here?
Yes, please.
Switch to the other.
I'm sorry, do I continue?
Yes.
Oh, sorry. The message was porterjarius@gmail.com, 1/24/2023, 1:12:02 p.m. Message says, that's good. I'm glad you have to. I'm just honestly sad, but I know I want to be forever, and God make no mistakes. Glad you're feeling better. This particular account on this device replied, yeah, I know it hurts to know, but you can talk to me about your feelings if you want to express anything. I want you to take care of yourself better and not let yourself go down the path of just turning to drinking and smoking more to heal. The Porter Jarius account replied, of course, Shawty, and LOL, don't forget, working out too. It's some good going on too, but you're right, I've been planning on slowing down. This device's account replied, I know you're working out too, LOL, but still, don't be doing that extra stuff.
No extra stuff. Don't do extra stuff,
The
people.
next text message that we have.
This was a message, actually, I'm sorry I printed out in black and white, but this was a message from this particular device, specifically saying, Blaise told me last night he signed up for monthly subscriptions of diapers from this company, kudos, LOL.
And what's the date, I'm sorry, on this text message?
1/10/2023, and I can't read the time, so. No, I just need to move it over.
7:42?
Yes, 7:42:10 p.m.
And can we get you to read this text message?
Yes, this was a text message from the account 1501-231-5975, asking the question of this device, does Blaise rub your belly, LOL? This particular device replied, sometimes.
And do we know who the number 501-231-5975 is?
I don't think I do offhand, so.
There were other messages, oh, I'm sorry. What is the date? I apologize. On that text message. If you remember before I pulled it up.
I do not remember before you
Let me
pulled it up.
grab it.
Those messages were 1/25/2023, began at 9:30:11 p.m., ended at 9:30:35 p.m.
Mr. Devlin, in your search within Ms. Benning's phone, did you happen to run across a text message between...
Objection, Your Honor.
Okay, let the lawyers do.
Lawyers approach. That's 168 on the objection counter. The question was, in your review, did you happen to come across an objection, or did you have to come across a text message and then it got cut? We're going into these text messages. Man. One more reminder. Don't put anything in a text message on any app that you wouldn't like read in court. It's good advice. Yeah, the objections from the depot. Yes, I did. We only had 3, I think, but I added those. Or YouTube chats for that. Yeah, it's okay. We'll delete your YouTube chats if they're bad. So they'll just, and it's like it never happened. It's like no one will know. How they'll never know. Yeah, they'll know. They'll find out. Oh. Text like a prosecutor is reading.
Did he receive a text between Najee and Ms. Benning?
Regarding her posting about her baby, do you remember seeing any of those text messages?
Defense one.
I vaguely recall that, but I couldn't give any details on it. I've seen a lot of messages. So.
Okay. And you don't remember if Ms. Jackson, Najee Jackson, asked Ms. Benning when she was going to post about her baby?
I remember that specific message of when are you going to post?
When Ms. Benning responded, do you remember it having anything to do with Blaise Taylor?
I don't recall the response. So.
Thank you. I'll pass the witness.
Questions from the state?
Thank you, Your Honor.
Mr. Devlin, you have gone through and testified about some random text messages. Would you agree?
Yes, ma'am.
Okay, and so when you said that you went through Ms. Binning's phone, did you actually take the text message that you have in your page 4 of your report, and did you actually look at the other messages surrounding it to see what context it was given? Which, Your Honor, I'm going to ask what he's doing right now with that tablet.
Okay, scrolling through his.
Are you looking at the report?
Yes, ma'am.
Okay.
I'm trying to see what was on page 4.
Yes,
So,
I'm happy to. I just didn't know if you were looking at the extraction.
oh no. Did I see the messages, the context of messages? I did not.
Okay, so you didn't look at the messages that actually preceded Jade's message to Danny, where one of her friends said, "We please top shelf an 8," and Jade responds, "Okay, I'll let you know when he's going to come."
I'm sorry. Yes, I did see all of that. That's absolutely correct.
Okay, so this message that Jade sent, like, could I get an 8? She wasn't referring to herself because she was getting it for one of her friends.
My reading of it was that she was getting it for somebody else.
Okay. And then same thing with page 5. There are other messages that reference apple fritter, and Jade was seeing if anyone wanted this because she regularly would get different weed from Danny Weed for people that she worked with.
I mean, that particular set of messages was a frequent post within that Telegram group. So.
Okay. And going to your page 8.
Yes, ma'am.
Okay, and so your page 8, that is not Miss Binning, that is one of her friends asking for Adderall, correct?
Correct.
And did you actually read through that message thread with Miss Binning and her friend had a valid prescription for Adderall? Did you notice that?
I remember the discussion of that, yes.
Were you familiar with the Adderall shortage that the pharmacies were having during this time frame of November 2022?
I'm not familiar with that, so.
Okay, so if pharmacies were out of Adderall during that time, which actually if you read through the text between Ms. Jackson and Ms. Binning, they actually talk about the fact that Walgreens can't get it and everybody is out of their Adderall prescription from their doctor.
Okay.
Okay. And then, so this one, I would like for you to look at page 9, skip page 10 entirely, then look at page 11 and 12.
Yes, ma'am.
Okay. Did you connect page 9, 11, and 12 in any way?
Did I connect them? I don't guess I understand your question. So.
Okay, well, page 9 is actually the last message in a sequence of messages, but you put it first. And then when you go to page 11, you left the other person off of this thread, which it's readily available in the extraction, but you left off Mario Gutierrez as the person asking Jade, "Can you holler at Danny? Your boy needs a half."
I do recall that. Yes, ma'am.
Okay, so that's Mario Gutierrez, but you left his name off of this.
When I pulled it, I don't think it was included in there, but that's correct. I believe it was Mario Gutierrez.
Okay, and then page 12 follows where Ms. Binning asks Danny very specifically, and this is on February 25th, "My coworker wants to get half." And Danny responds, "Bet I got you when I get back."
Yes, ma'am.
Which, and I apologize, page 9 doesn't actually relate other than it's from that Mario thread. The time that Mario gets anything is on February 18th, but your report listed 2 dates. It listed the 25th, which kind of inferred that the messages you included in 11 and 12 were on the 25th. But no one meets Danny on the 25th. You would agree with me about that, wouldn't you?
I have no idea if anybody met Danny on the 25th. So.
Because there's absolutely nothing in Ms. Binning's phone that indicates that happened. It's the opposite. Danny said, "I'm not here. I'll hit you when I get back."
I do recall that further messages where he said, "I'll hit you when I get back."
Okay, and on page 13, this section is labeled a conversation about Blaise Taylor. And that conversation, that's not the only one, correct?
There's quite a few messages about Blaise Taylor.
Okay, and this is from December 31st of 2022. And then again, the next section that you have that begins on page 16, that is not the only communication that they have, correct?
No, they had quite a few communications.
Okay. And then we get to page 19, which is plans with Blaise Taylor. And again, on page 20, for some reason, even though it's in the extraction, you left off the person Ms. Binning was speaking with. And this is from the date of 2/25/23 at 12:03. She messages her best friend, Najee Jackson, to tell her that she's going to plan to do a little paint with Blaise tonight. So you didn't put in the thread that they were talking about where to get the paint and maybe Dollar Tree would have it?
There was,
that
I remember,
may be connected to why she stopped at Walmart?
I remember all those communications. I know that there were some, even some pictures. I believe there was a picture of a crib as a part of it. There was talk about what they were going to paint. So I mean, there's a couple of those messages. Yes, ma'am.
Okay. And then on page 22, you have this Bumble information, which you have an install date. But you didn't include the message that showed that Ms. Benning registered for Bumble in August of 2022.
This was, when I ran this particular search term, this is what came up. But there, we talked about those messages before. I did see a message back in August of 22 that showed a previous registration for Bumble.
And did you notice that the app was only in focus for 119 seconds?
Not very long.
It was very quick, wasn't it?
Yes, ma'am.
She found a match right away.
You don't have any user data to show what was happening when she accessed that app.
Correct.
And so, like, if I thought that Kendall had a Bumble profile and I just wanted to go click on it to look at it to kind of give her some feedback as a girlfriend, it could have just been that.
Absolutely.
And then you included some random messages with Mr. Jerry Porter. Did you notice that they were very close friends?
They appeared to communicate quite a bit. So during that period.
As very close friends.
I don't know enough about them. I just know I was asked to pull these messages. So.
Okay. And then the last messages that you apologize for being in black and white, so they don't have a page number. Do you know what I'm referring to?
I do know the message you're referring to. So.
Okay. So this is January 25th of 2023, and it's just a message from Jade's mother asking her, does Blaise rub your belly? And Jade responds, sometimes.
Right.
Did you keep reading the messages on where her and her mom actually message back and forth and draft a message from Jade to send to Blaise to tell her how much she wanted him to go to her OB appointment where she was going to find out the gender of their baby?
I recall something along those lines. Yes, ma'am.
Okay, so. And you recall the messages where Blaise Taylor did not go to that appointment, correct?
I'm unaware if Mr. Taylor went to that appointment or not. So
you didn't look at those messages where he didn't show up?
I read through them. As to whether or not he did or didn't, I don't recall that. So.
Well, do you recall that he never went to a single OB appointment with Jade Benning?
Objection. Speculation. This witness doesn't know that.
Okay. You can ask whether he reviewed any text about that. But...
Did you review any text messages where every time she had an appointment and asked him about it, he didn't go?
Objection. Counsel is testimony.
And do you recall any text messages about appointments?
No, Your Honor. No, Your Honor.
And the last message where Ms. Benning tells her mother that Blaise told her the night before that he signed up for a monthly subscription for diapers from this company. Did you find any other mention that proved that Mr. Taylor actually signed up for a diaper subscription?
No, I did not.
Thank you.
Any other questions?
Mr. Devlin, you were just asked the nature of the relationship between Jarius Porter and Miss Benning, weren't you?
Correct.
Were you aware that Jarius Porter...
Your Honor, can we approach?
Well, she opened the door when she asked the question.
I don't know what you want to ask, but you can approach it.
Oh, man. Good times, good times. It's getting spicy. I think at the end of this trial, the two counsel tables are just going to have to duke it out in the parking lot. There's no other way. I mean, we can set up an octagon outside the courthouse.
Remember in the beginning when we started 110 years ago?
If she opened the door, I didn't hear exactly what she's trying to get into. The text message, maybe. We'll see. Got to be careful about opening those doors because once they're open, things can and people can come through. Might have to zip ahead just briefly. I'm not sure how long this is going to go. The states get a little spicy here. Pause while we fast forward.
Were you aware, you stated on cross-examination that Ms. Benning actually downloaded Bumble first in August?
I found a registration message. It may have happened. Bumble may have been downloaded before that. But that would have been at least the earliest time that I know of.
Were you aware, or did you find out through looking through the phone that Blaise and Miss Benning met on Hinge in the same month of August 22?
I did not see that. So,
in regards to Mario Gutierrez, did you notice through the phone that Mario Gutierrez is the significant other of Lauren Weber?
Yes, ma'am.
And Mario Gutierrez on the 25th is the same one asking Jade to get her narcotics.
Yes, ma'am.
And that's Lauren Weber, the person who went inside of her home when was told not to, the crime scene. That is her.
Okay, see, there's disputes about it, so don't throw that up like it's true. So what is your question?
Your Honor, she said she did. In regards, she said she went inside of Miss Benning's home.
Right, we've heard that, but there's nothing about police. We've heard all that today. The jury's heard it. So what is your question that this gentleman would have a foundation about?
Did you have an opportunity to look through the text messages between Jane Benning and Jarius Porter?
Yes.
Did you find that they were a little bit more than just friends?
Having read through the messages, I don't know if they were just friends or if they were what they call friends with benefits. I don't know.
What sort of benefits?
In regards to
like 401k?
The appointment of I think it was a February 2nd appointment.
Probably dental.
For Miss Benning to go to the doctor to find out the sex of the baby. Did you see any text messages where, well, let me first ask you this. Did you learn through the text messages that Mr. Taylor worked for the Tennessee Titans?
I don't recall seeing that, so.
Did you see through the text messages that on that very same day, he had to work or had an assignment at work with the Tennessee Titans?
If I did, I don't remember that, so.
In regards to the Bumble application, and I think that the question that was asked of you on cross-examination was that it could be an app where someone will go and say hello to a girlfriend. Is that what was said?
I mean, I thought the question that was asked of me was, is it possible that somebody logged in to see if their girlfriend's profile was on there? I thought that was what was asked.
What is the primary purpose of the app Bumble?
They call it a social contact website, but for the most part, it is a hookup or dating application.
And this is the very app that Jay Benning registered for in August and then downloaded again, and I think you said February.
Correct.
Thank you. I passed.
Any other questions?
No, Your Honor.
All right, thank you.
Thank you, Honor.
All right.
Sorry, let the lawyer step up just a moment.
Judge invites everyone up to the bench really quickly. One more time. All right, we've learned all that we need to about Hinge, Tinder, and Bumble. Apparently, they're all apps that let you meet people socially. It's sort of like, I guess you go there to, if you're new in the area, you just want to get the lay of the land and see how how, you know, where the hangouts are. Lift up Grinder. Okay, that's on there as well. But friends with benefits. Great news. All my friends, I guess, can sign up for a 401k, full health package, and dental insurance. That's the benefit I'm going to offer my friends. Unfortunately, they have to pay for it all themselves, and I'm not going to help facilitate any of that. But they technically.
Let's go to the jury, down to a few other witnesses, but we have to have another jury out hearing, so instead of sending you back out and back in at whatever time, we're going to recess for the day for your purposes. Remember what I said about not discussing the case, forming any opinion about it, looking things up, watching anything on media, ignore all of that. And tomorrow, be back in the morning, 8:45, 8:50, we'll get you up here and resume the trial. Thank you very much.
We're not done. We're not done. We're still catching up, so we have today's to get through as well. I'm sorry if you thought you were on the home stretch. No, the spice gets better and better, and we are here for it. It gets spicy here. It gets spicy in the next segment, because tomorrow, in real life tomorrow, not that tomorrow we're going to watch tonight, but tomorrow in the real life is closing arguments. So we need to be done by then. We need to be caught up.
And I mentioned that the bench conference about having a jury out hearing the state back to this document that was Well, let me ask this. Is Dr. Larkin out there?
Your Honor, that please use the lady at the podium.
Okay. All right, we'll take 10 minutes.
Your Honor, can I use the restroom? I've been holding it. All right, we're gonna skip ahead to get to the good parts here. Little break where everyone gets to run to the little boys and little girls room, and then we come back for the spice. 3, 2, 1. All right, I'm coming back there. Boom.
You have. Sorry, is there anything from the state's perspective, objection-wise, discovery-wise, about Dr. Lindsay? That's
But we have absolutely no idea what Dr. Lindsay intends to say because we have some handwritten notes. It says red top tube and some work.
She's being called for what purpose, Ms. Holland?
She is a toxicologist who sent over a summary as requested to the state regarding what her subject matter would be. She is going to testify to the levels of concentration of cocaine, cocaine, and fentanyl in the samples of blood and urine of
She's going to be able to testify to an amount of cocaine that was taken?
She is going to be able to opine on the amounts that are listed on the toxicology reports and the litigation papers.
Okay, in terms of whether they are numbers that you actually rely on?
Correct.
Okay. So she's gonna be opining about what you asked Dr. When you got into the 500,000, 98,000, those kind of numbers.
No, I didn't.
No, I'm not talking about you, I'm talking about the state.
Judge, I'm sorry, I have the same standing objection that she shouldn't be talking about any work order that is not entered into evidence.
And we don't plan to.
That's fine, I don't think they're doing that. So, and then on Dr. Larkin, you now have this document, right?
Yes, so.
I'm asking the state.
Yes, sir. The report that we got today?
Right.
Yes.
So, is it the state's opinion that I can exclude Dr. Larkin from testifying because you just today got this document?
Yes.
Yes, Your Honor.
Based on what?
On the prior motions that we filed last year, we have had, zero notice. She's typed a report. She's trying to opine as to the cause of death, and we have had no notice. Reciprocal discovery as well. Your Honor was specific with them that if an expert was going to have a report, it had to be provided to the state pre-trial.
That is not a report. I did not get it until today. The court asked us to reach out to
Where
our
is Dr.
experts.
Larkin?
She's right here.
Let her step up.
You're responsible for your witnesses.
Stand right here, raise your right hand. Raise your right hand.
I swear.
Do you need to do something?
Change out batteries.
Okay, go ahead. We waited on everybody else.
Dean, thank you very much. Dean rushing up there to change the batteries on the witness stand mic. The Sennheiser wireless transmitter requires 2 AA batteries or a battery pack. You can take either one. And we're going to have that turned on here in just a second.
Did you generate this 2-page document?
Yes, sir.
When?
This weekend, I guess.
And you gave it to who?
I was asked this morning to send
Gave
my
it to who?
notes.
Did you give it to anybody this weekend?
No, I did not.
Why did you compile this 2-page document?
That is the way that I approach when I'm going to do something like this. In my mind, I
Wait
need
for the
to.
last minute?
Yes, sir.
Why is it?
because I'm going through what I put together over time, and when it gets closer to me going to testify, I want to make sure that I clearly and concisely put my points. I was an engineer before I was a doctor, and that's how I
Okay,
approach
so when
problems.
did you send this to anybody?
This morning I was asked for notes, and so those are the notes that I have. So I sent those when I was at the airport this morning, about 10:30 maybe, and I sent that to Letitia and her team.
Okay. Any questions from the state?
Dr. Larkin, how long have you been working on this?
That was just very quickly putting that together.
No, she didn't ask that. You're talking about it, the case?
Right, how long have, you said that you just at the end put your analysis together that you've been working on. How long have you been working on your analysis?
I think I got asked to, I think when originally they were in Nashville a few months ago, I was told about the case, and then more recently, I've done work on reviewing all the records, and that's probably within the past month or two. I don't know for sure, but more recent. It hasn't been years or anything.
Okay, so maximum 2 months, maybe a month, you've been reviewing records related to this case.
Approximately. I don't know exactly when I started. I'd have to look at when I started getting some information, but
Do you have documentation about that with you?
I don't have it on me. I could find that out, but it's been several months. I would say on the outside, if you want a number, maybe, several months, something like that.
Well, you said 1 to 2, and now you're up to several. Which one is it?
Yeah, I'm going to object to this line of
Okay.
questioning. This
Is there something in your phone or something you have today that you could tell us? Look up and tell us.
I can tell you.
Okay, yes.
I can tell you.
We reached out to her prior to the last trial. She was not officially retained at
That
that
was in
time.
January.
Yes, it was.
Okay.
However, she did not start actually digging into the trial until probably maybe 2 to 3 months ago, before she got everything that she needed.
Okay, what other questions do you have?
Did you take notes along the way?
No, I don't. I mean, I guess I put the notes into there. I don't have any other notes that I've taken, if that's what you're asking.
So no other notes, and you put that together this morning?
She did this weekend, last weekend.
Yes.
Last weekend, but you didn't send it to anyone?
I did not until today.
Were you instructed to not type up a
No,
report?
I object. I object to that line of questioning because what I tell my expert is confidential from Mr. Taylor and his constitutional rights. She
Do you have
doesn't.
any other questions other than that?
No, it's not your right.
All right, thank you.
I would have allowed that question.
Okay, here's what Rule 16, the Rules of Discovery under the Tennessee Rules of Criminal Procedure say, dealing with information subject to disclosure by defendants. Inspect and copy of photographed books, papers, documents, photographs, tangible objects, or copies or portions of these, if within the defendant's possession intends to introduce them. That's part A of that B1A. In terms of our discussion about what a report is, that's under B where it says reports of examinations and tests. And the pertinent parts say that the defense has to disclose upon the state's, the defense asks for discovery, then the state, the defendant has to comply with reciprocal discovery, which the rule says inspect, copy, or photograph any results or reports of physical or mental examinations. That's what all the appellate cases mainly deal with, is insanity, mental health examinations, and of scientific tests or experiments made in connection with a particular case or copies thereof, if the item is within the defendant's possession, custody, or control, or the defendant intends to call as a witness at the trial the person who prepared the report. So, does this document
meet that
deal
criteria?
with scientific tests or experiments?
Judge, she's giving her opinion based on the review of the tests.
Right. But did she do any scientific tests or experiments?
Well, I mean, I don't know, not that I'm aware of, but she refers to laboratory testing confirmed.
Okay. But then on the second issue, if it should have been disclosed, it didn't exist till this weekend, which this is, what is this, Tuesday?
And if the defense instructed her not to.
48 hours earlier. So we get to the bottom line of if there's a failure to comply with the request, the court may order that the party to permit the discovery inspection. It's already untimely for that. Grant a continuance, prohibit the party from introducing the undisclosed evidence, or enter such other order that deems just under the circumstances. So, if, I hadn't finished yet. If there is, I'm not sure there's a violation of Rule 16, but if there's a 48-hour violation, what is the state seeking the court to do?
Judge, we're asking that it be excluded just as we did in our pretrial motions.
Okay, but even fall under Rule 16.
It's your decision.
Did you carry her?
How do I turn over something that I don't know exists? There's an email at 10:53. So it's not a report. She has done no scientific testing. She has done nothing of the sort. She made notes for herself to prepare to testify. The court tells us, reach out to our people, find out if they have notes. Today is Monday. I'm in the middle of trial, questioning witnesses, trying to get all the experts together to give the court what it asked for. That's difficult to do when I'm direct examining and putting on my case in chief. So at the break,
48 hours if she did it on Saturday, which I don't choose to and ask specifically. Go ahead.
and so we're complying with what the court asked. She didn't call us and tell us that's what she was doing. And as I stated, it's not even a scientific test. It's nothing that she conducted any type of test on her own. We don't intend to introduce it into evidence. So I don't understand what it is that we've done wrong.
Okay, anything further?
Judge, I have a secondary objection, depending on if you are going to allow it.
All right.
The state has a couple of other issues with this report, that is notes or report, whatever it is. Her report relies on information that is inaccurate and it's not in evidence. And it's specific to that urine test that Ms. Hollins keeps attempting to ask all these witnesses about that is not in evidence. And the state is, again, asking that she not be allowed to testify to any of the lab reports that are not in evidence, but she based her opinion on a lab result that is incorrect. She also is opining as to the cause of death, and the state's position is that she's not qualified to do that.
It's two objections.
Since she's an ER doctor, where are you referencing a specific date about a urine screen?
So on her handwritten notes, it's kind of...
Oh, I don't have... Oh, who are you referencing?
So
Dr. Lindsay?
Dr. Lindsay references that drug sample, and then Dr. Larkin, I believe, also references the urine sample. Right, it's on the bottom of page 2.
Fentanyl was detected in a urine specimen that was collected before fentanyl was administered in the emergency department. Is that what you're referencing?
Yes, and then it says, therefore the fentanyl identified in the specimen could not have originated from the hospital treatment, and instead indicates fentanyl exposure before her arrival at the hospital. And then she goes on in the third page, in the second paragraph, to talk about the opioid epidemic that has spread.
Yeah, I mean, I'm not going to let her testify about that. What about is that next to last and last sentence on page 2 accurate, Mrs. Hollins?
I believe that that is a question for the trier of fact. We were given discovery in this case, and when we were given discovery in this case, up until 10 days ago, the date on those lab reports were 2/25/23. 10 days before trial, they changed the date, and now we're precluded from being able to utilize that date.
Well,
so we believe that's an issue for the
the other
trier of
screen
fact.
wasn't tested, right?
All of them were tested. All of them.
Which one? I thought the Dr. Brucaleri said no one that's been here tested it.
No one what?
No one has testified to the test result.
The work order 090 that went to some other lab hasn't been testified about?
Yes, it has been.
From who?
Katolsky, I believe it was. Dr. Katolsky.
We're referring to NMS work order 230788883. That is the one that this report is referencing, had a 2/25/2259 date. That is inaccurate. We did not correct it 10 days ago. We sent information to the defense months ago about the error on this date. We had the report corrected only in the event that it was somehow admitted during the trial, so we would not be sending inaccurate
Did Ms. Smith,
information.
from your deposition you introduced, say there was no fentanyl administered?
Correct, as well as...
I'm asking Ms. Hollis.
Exactly. So what that means is when that urine test was tested.
What urine test?
The urine test that was tested before she was administered in
By
the
who?
blood test. In the blood test.
Tested by who?
Tested by NMS.
No, NMS did not
No,
test that.
they didn't.
It was CFSRE.
See, that's where the
Since when
courtroom's full of
Since when does a
confusion.
prosecutor call a lab and be able to change a medical record and we have to adhere to it?
No, I'm just asking you, is there proof
No,
that
there's
you're
no proof.
asking your expert to testify about?
Yes, for the last
Bring
3
back
years.
in Dr. Larkin. We'll figure what work order she's given his opinion about it.
Since when, Judge? Since when does a prosecutor get to call the lab and change a medical record? Whoa.
What general Norman is the work order that no one's been here lab-wise to testify about?
NMS 2307883.
230.
78883.
The jury's gone home for the day.
You're going to be able to testify without anything in front of you?
No, no.
Well, my question is anything in this document, 3-page document, that has anything to do with work order 2307883?
I don't know. I think Dr. Yancey's in the back.
Who?
You're looking at the document that I submitted, not Dr. Larkin.
Why are you standing up?
Because...
Just have a seat.
Okay, I think, so...
Just have a seat.
I don't have any
You
reference
see
to any
those
work
last
orders
two
in there.
sentences in your report?
It's not a report though, right?
Oh my goodness. Why are you standing up?
Where'd you get that information from?
From the toxicology records that I looked at.
From who? What lab?
I would have to look. I can't remember. These are just notes that I have.
How are you going to testify? What are you going to use to find that out?
We'll put those up when I put up the notes. I can ask to have that
She's
put
thinking
up.
about me.
So you have no clue where you got that information?
I got them from I have all the toxicology reports and I have summaries. I would have to look exactly where it came from.
Okay.
If this were a report, it would actually have reference to that.
Okay, well, tell me where that information came from.
I would have to have the report
Do
to
that.
pull it up.
Where is it? Is it the same report you asked about earlier, or this
Well, I
one?
can share this with you. What I plan to testify or have her testify about is I'm alleviating your issue.
You're not asking her about those last
I'm
two
not.
sentences? Oh, you said earlier you were?
No, I didn't.
Yes, sir.
Then why'd you put this in this document?
As she stated,
Those are just-
I'm not asking you.
Those are just notes for me to
So
look
you
at.
didn't rely on
I've
this?
never ever
You didn't
actually
rely
produced
on this
something like
last
this.
paragraph for any of your opinion?
Not for what I'm going to be testifying to. No, those are just some of my thoughts. I've put
Okay,
down.
why don't we do this?
If
You
I-
ask her what you want her to testify about.
I'm going to tell you, she's not prepared right now to testify for that because I don't have my things together yet. She's going
What do
to
you
testify.
need to have together?
I'm going to tell you what the 2 reports that she's going to testify to.
Okay, give us those.
I don't have any problem with that, sir. 231, 26889 is one of them.
What? Defense is circling the drain here.
And then 231, 29285.
Judge can't believe this. Expert witness on a stand, not prepared to testify, doesn't know what she's going to say because the defense hasn't organized the questions.
Blood in the comforter.
Okay, you have issues with that?
I do not have issues with that. I do have issues with this witness whose non-report that I consider to be a report relies upon false information. And
I don't know. Let me try to find out again. Your opinion that says the history, witness observations, clinical presentation, toxicology findings, and objective medical evidence support the conclusion that Jade's collapse is more consistent with respiratory arrest resulting from combined cocaine use and pre-hospital fentanyl exposure than with a primary sole cocaine-induced cardiac event. Is that your bottom line?
Yes, sir.
Where do you get the information that there was pre-hospital fentanyl exposure?
Clinically, I can tell you in my 30 years of experience in treating patients with different types of overdoses, we have a clinical picture, we have the 911 call, we have the other witnesses that have spoken, we have the EMS.
You're talking about the sleepy, awake, talking, doesn't feel right, that kind of
Yes,
stuff.
and then and the 2 reports that we'll be talking about on the comforter.
So the
Unfortunately, it wasn't tested for and everything.
what was it tested for?
She's not privy to it because I haven't had the opportunity to meet with her, which I had planned to do tonight.
What
The
was it
state-
tested for?
Not everything, not fentanyl was not necessarily tested for, and
On what?
in the urine that's no longer done at 225.
That's what I'm asking. You said you included your toxicology findings in making that opinion.
Your Honor, what is unfair is she's telling you that those are notes. Those are not her lasting opinions. That is not a report. So you're trying to commit her to something that she never intended to be there. So that's unfair to ask her for that. She has stated as a medical professional doctor.
Why
Those
did you
are her
include that paragraph?
notes. Those are her notes.
Those are just some of my thoughts. It doesn't mean they were
So
what
this paragraph on the bottom of page 2 means nothing to your opinion.
I'd have to look at it again. I just made some notes, and I probably put, I mean, that's not the basis of my opinion, but again, they're just notes. They're nothing official. There's no report. I don't write a report that looks like that. I just was asked to give some notes, and they were some things I just put together this weekend.
You don't know, Mrs. Collins, that you plan on asking her about any pre-hospital fentanyl use.
Yes, I do, because it was in the vomit. Their own witness testified that the vomit was the fentanyl was in the
From the
vomit.
lower level and all that.
It's hard. It's really hard. But what I'm saying is that the fentanyl was found in the vomit. That was testimony that came from that.
But you don't plan on asking this witness anything about that other work order?
No, I don't.
Okay. Any other questions?
Yes, Your Honor. The state, number one, that was not Dr. Mithen's testimony. Dr. Mithen was very specific.
Okay, do you have questions of this witness?
Yes, this witness's notes include a reference to the EMS guy said he thought it was an allergic reaction. We do not have those facts in this case.
Where are you referencing?
That is the last sentence in the first paragraph.
Uh-oh. Witness paused and are fidgeting with their glasses for a second.
Our EMS witnesses said the exact opposite.
Well, here's what I can't do. And again, if she testifies tomorrow in front of a jury on inaccurate information, then again, have the Perry Mason moment and say, everything you've said, if it's based on inaccuracy, would be inaccurate. But she may not be asked that, so I don't know. So we'll have to wait and see what she's asked and go from there. Anything else?
Your Honor, may I ask that Dr. Carney be able to watch her testimony if she testifies tomorrow remotely, so that she doesn't have to be down here because she's been here all
Oh, I
afternoon?
get that, but it's important she's willing to do that. We try like we did the direct link. I don't know what happened there.
I think you said you resolved it, right?
Sir, you will have latency like she did today. It all depends on their bandwidth.
Just get with that gentleman and provide that link to Dr. Carney. Is she going to be out of town or something?
I don't know, just,
She's
she has a
welcome
job
to
to
be
do
here.
because she does autopsy.
Well, she's
So she's going to watch this while she does an
She needs
autopsy.
to be here, then have her here. All right, thank you. You can check that. All right, we'll be then in recess until 9 a.m.
Everybody's angry. Everybody's angry. Now we have to. Okay, we're not done. We're not done. I'm sorry. I thought you were. You thought you were done. You thought we were leaving. Now we're not. We're still here. We're still here. Let's see. Let's try. Let's try this one right here. We have to start with what happened today. Let's see if there's anything that happens right before the jury comes in. 7. It's on 7. Let's go there really quickly, and we'll get this other one ready as well. Hold, please. This is gonna be something else. We're only a couple hours behind here, but we'll have this pulled up for you just in a second.
Anything before the jury?
Yes, Your Honor. If I may, I'd like to make an offer of proof before the jury comes in regards to the text messages that we discussed on yesterday when Mr. Devlin was on the stand. And in addition to that, we'd also like to make an offer of proof in regards to the card that was left with Ms. Benning's file. May I proceed?
Sure.
I would ask the court to state to the court that if we were allowed to bring in the telephone records in regards to Ms. J. Bennett and the romantic relationships that she had with 2 other men, the state had brought up a text message by Xavier.
Okay, hang on. Let me make sure I understand what you're talking about. You're talking about the pictures that you wanted to ask
we're supposed to be here.
Dr. Lindsay,
Good morning.
could you please state and spell your name for the
Yeah,
record?
we're going to be right here. Hold on. We're starting with Dr. Lindsay this morning. There we go. All right.
Good morning to you, ladies and gentlemen. Jury, let the record reflect all of the jurors are here in the presence.
Yes, I do. Good morning, Your Honor.
So now we're live. Well, we're not live, but we're on today's testimony. We have to get caught up because it's closings tomorrow. The state rests at the end of today. And we're going to be working late tonight.
May I proceed, Your Honor?
Sure.
Dr. Lindsay? Good morning, Dr. Lindsay.
Good morning.
Could you please state and spell your name for the record, please?
Dr. Jancy Chun Lindsay, JANCI CHUNN
And how are you employed, Dr. Lindsay?
I have my own consulting, toxicology, and molecular biology business, Toxicology Support Services, LLC.
And how long have you owned your own business?
Since mid-2009.
And could you give the court information in regards to your educational background?
Yes, I have a bachelor's degree in biological and physical sciences. I have a PhD in molecular biology and biochemistry.
Okay. And could you tell the court exactly when and where did you start working as a toxicologist?
I started working in the laboratory formerly as a toxicologist. Most of my research over the years, I worked in a lab before going back to get my PhD, in between my bachelor's degree and my PhD, as a lab technician at the bench. And I was able to do a lot of toxicology research and even publish as a technician, which was really great. It helped me get into graduate school. But I started doing toxicology research then, and then I was hired directly after my PhD into Exponent Scientific Consulting Group as a toxicologist in their Toxicology and Mechanistic Biology division.
Whoa.
Very good. And have you had the opportunity to be published or have any articles published?
I have.
And have you had the opportunity to testify prior to today and be deemed as an expert?
Yes, many times over the past 20 years.
Would that be civil and criminal or both?
Both, and then military case.
Very good. At this time, I would tender Dr. Lindsay as an expert and would offer her CV.
In the field of
Toxicology.
Toxicology. Here we go.
From the state.
No problems from the state.
This witness be allowed to give her expert opinion. You can place such weight on it as you choose to. And that'll be 60. Okay.
Dr. Lindsay, have you had the opportunity in this particular case to review any materials as it relates to the case against Mr. Taylor?
Yes, I have.
Can you inform the jury exactly what all materials have you had the opportunity to review?
Yes, I have reviewed the toxicology litigation packets that everybody has been talking about, the detective investigations, the EMS report for Jade Benning, the bond hearing transcript, which had interviews with several of the people that are involved, transcripts from these hearings, all the literature that I brought on the toxicology of both cocaine and fentanyl and them together, the Pandora records, which are the administrative records for all of the medications which Jade received while she was in the hospital, the ME records for Miss Benning and the baby Abby's autopsy report in Jade's medical records.
Thank you.
Okay.
I want to now draw your
Light reading.
attention to Toxicology Lab Report by ENS 23129285.
I like that you guys have different colored papers. For some reason, that's very pleasing to me.
Yes, I do have it. Thank you.
You're welcome. Do you remember specifically what was tested in this specific lab report?
Yes, this lab report covers the testing of Miss Benning's comforter, the blue comforter, from the apartment.
And was there any type of bodily fluid that was found to be on the comforter?
So they have what they look to be vomit in a section of the comforter that they extracted in order to test that section of the comforter for drugs. And then they chose another section of the comforter as a case blank, which did not appear to have any vomitus on that portion of the comforter.
And what is a case blank, Dr. Lindsay?
So there are several case blanks in these types of tests. There'll be just the homogenate buffer that they use to extract, and of course it should have nothing in it. And then they'll use an area of the comforter or clothing that they believe does not have any of the liquid item or blood or whatever the matrix is that they're testing, so that can be a blank for them as well. So they'll have just the buffer, and then they'll have what they think is a true blank on the material.
There's been a lot of talk about the word matrix. Will you tell the jury exactly what a matrix is?
So in this case, when we're talking about matrix, we're just talking about whether it's blood or urine or fabric or vomit. That's all it means. It's not meant to be a fancy word.
Now, this jury has heard a lot of science, and I'm sure they don't want to hear a whole lot more.
What is the question?
Could you tell us exactly what was found to be positive on this comforter from Miss Benning's home?
Yes, I can. So on the comforter, we have the presence of fentanyl, we have the presence of cocaine, we have the presence of the primary metabolite of cocaine, benzoyl ligoxanine. They did not test for EME, but we do have cocoethylene as well, which is what forms when you use cocaine and ethanol at the same time.
Okay. And ethanol, would that be alcohol, like drinking alcohol?
Yes, that's correct.
Okay. Were there any other substances that were at some point found on this comforter but was later to be determined inconclusive?
Yes.
Do you know what those are?
I believe those were THC, methamphetamines, and I think it was just THC and methamphetamine.
Very good.
Yeah.
But to be fair, they later determined that the spikes, if you will, were not placed in that test, so they could not say affirmatively whether that was so. Is that right?
That's right, and they didn't rerun the test, which they could have done. And they also didn't report those values. Yeah.
Okay, and so to be clear, it wasn't that they weren't present, it's just that they did not run the confirmation to get a more definitive result.
Correct. This was the first time they were doing this assay, so they were coming up with a new technique. That's the best way to say it. So it hadn't been validated yet.
And what is an assay?
An assay is just a protocol for how you do something in the lab.
Okay. Now, were they able to quantify any of the substances?
Sorry. Goodness.
Clean up on aisle 7.
Here, I apologize.
There are tissues on the side of it.
I got
Got
it.
like 3
Sorry
boxes
about
of
that.
tissues. Well, those are lotion tissues. They don't actually absorb any.
Were they able to quantify any of the substances that were found on the comforter?
Well, they purported to be able to quantify them, but not really, because there's no comparative. Since they were doing this for the first time, they had no comparative liquid. They added a buffer, but it's not like it was blood or urine, so they added a buffer to it. There's nothing to compare it to in the literature to give it a. So they came up with an amount, but there's no other something in the literature to say if you took this amount of drug and vomited this much on this comfort in this volume, you would have, a certain concentration. So that's why it's really more qualitative, what we call qualitative than quantitative, or semi-quant.
Did you still need the towel for you?
Yeah, let court officer clean that up for you.
Sorry, that's very disruptive. Apologize.
And everyone else has been just fine up there with the water. No.
Okay.
I'm sorry, I do the same thing.
In
I
regards
spill
to
at my desk all the time.
cocaine that was found, how does the cocaine relate to, I think, what you call BZE? Can you explain that to the jury?
Sure. So benzoyl ligoxanine, or BZE, sometimes called BE, is the major metabolite of cocaine. It's formed when cocaine passes through the liver, as is the next metabolite, EN, the irigoxanine methyl ester.
And the BE and the cocaine, was that found in the vomit?
Yes, it was.
Now let's talk about the fentanyl. Where was the fentanyl found on the comforter?
So it was found in both the vomitus and in the case blank, which complicates things. Yeah.
Why does that complicate things?
Well, because the case blank was supposed to be a case blank. So finding fentanyl on the case blank indicates that there was the presence of fentanyl on the comforter, either from contamination or from prior use.
And did the lab expect to find fentanyl on the case blank?
No, no, it should not have had fentanyl.
What is the purpose of the case blank?
Well, to be a blank area of the substance you're testing, as we kind of went over a minute ago. Yeah.
Is that the purpose to see whether or not the instrument is working properly and things of that nature?
Now that's another blank. So like I said, you'll have like a buffer blank, and then you'll have just another blank for the media that you're using, if that's possible in this type of a fabric test, or maybe you're testing an airbag or something else like that.
Did they rerun that fentanyl to ensure that there was nothing wrong with their instrument and to ensure that the fentanyl that they found outside of the vomitus was in fact a true presence of fentanyl?
I don't remember if they reran that fentanyl, but I know that they validated that the fentanyl was there. Dr. Methune validated that the fentanyl was, or excuse me, Dr. Kolosky from CFSRE, I think, and Dr. Methune from NMS.
And is Dr. Methune the actual forensic toxicologist who in fact performed the testing on this particular comforter?
Yes.
Now I want to bring your attention to the cocaethylene.
Yes.
Where was the cocaethylene found?
So the cocoethylene was found in the vomitus, but not in the case blank.
OG.
Thank you. And again, no concentrations could be attributed to any of these substances as it relates to the comforter.
Well, comparatively, there's no ability to compare. So it's a semi-quant. They purported to have an amount, but what do you compare it to? That's kind of the problem.
And would that be consistent with Dr. Methune's testimony that you could not give a definitive quantitative value on any of these substances?
Yes.
I now want to draw your attention. Could you? Thank you. Do you see what's on the side of you there?
Yes.
And I believe that this would be State's Exhibit number 46, I believe. And could you tell us what exactly this is?
It looks like it's the chromatographs from the testing.
Okay. And what is a am I saying that?
The chromatograph?
Chromatographs, what is that?
It's the first part of the testing when you use a chromatography method. They'll say something like, we're going to test by GCMS, gas chromatography, mass spectrophotometry. If any of you remember chemistry back in school where you had to go through organic chemistry and identify the compounds, and you might have learned about chromatography and mass spectrophotometry. The mass spec looks at the ion, the chromatography looks at where that chemical elutes off of a column. And each chemical has its own kind of signature time where it elutes off of the column, and according to its abundance, it'll make what looks like a mountain peak, and you can measure the area under the curve and compare it to a standard curve to get an idea of the relative abundance of that particular sample.
Now, to be fair, did NMS find that the fentanyl was a number such that it was below the rate of where they would detect it, meaning below the reportable limit?
Below the limit of quantitation or below the limit of detection? Concentration. They've got it highlighted. Yes.
And what does that mean when it's below the level of detection?
Well, they won't report it often. So it's there, but it's not being reported.
And is that something that's pretty standard in all labs, that before they will actually report something, it has to be at a certain level?
Yes, I think people are probably most familiar with it in alcohol in hospital tests. If you don't have above 10 milligrams, which is about a half a drink for a 150-pound person per deciliter, then they won't report it. Even if you have alcohol in your system, they'll say it's just a negative test.
Very good. Josh, can you? I want to now bring your attention to work order 23126889. It is also on the screen.
Mm-hmm. Yes.
Can you tell us what exactly is this particular toxicology report testing?
Yes, so this is the blood that was taken at the hospital at 10:31. Unfortunately, it was collected in the wrong type of tube in order to store the blood and the enclosed chemicals properly. Typically, in order to preserve cocaine, which is super susceptible to hydrolysis and degradation, we have to add some sodium fluoride and some other chemicals to keep it stable, or it'll just spontaneously degrade. But they used a clear plastic tube with no sodium fluoride or anything in the tube, which is problematic. And then there's the liver tissue from the baby and the homogenate of the liver tissue and buffer from the baby.
And this, you had stated that it was taken at 10:59. Would that be on February 25th of 2023?
Yes. Sorry, I didn't stipulate that.
Would this be at a time when Ms. Benning was actually in Vanderbilt Hospital?
Yes, when she first came to the hospital.
Did this particular test positive for any substances?
Yes, it did. And let me get mine out because I can see it better. So it tested positive for the main metabolite of cocaine, benzoyl-algoctine, at 1,800 nanograms per mil, for cocaine at 78 nanograms per mil, and for agoctine methyl ester at 7,800 nanograms per mil, as well as for fluconazole in the baby's tissue, which is an antifungal at microgram per gram. So it was just a presumptive positive, a qualitative, what we call a qual instead of a quantitative.
And do you see whether or not cocaethylene had an indication on this particular test?
So on this particular test, they don't report cocoethylene, but in 8-9, no, they don't. They didn't report cocoethylene in this test.
And do you see whether or not a confirmation test was ran on cocaethylene on the last page of this particular report? It's also on the screen next to page 3 of 4.
Yes.
Why would a lab run a confirmation test on any substance?
Because they had detected it in the, hold on a minute.
Yes.
Okay, so these are the reporting limits. That actually isn't being.
We go back to looking at the witness. We can barely see
the
the screen at all.
result. Those are the reporting limits.
But do you see that there was a confirmation test actually ran for cocaethylene?
So they would run a confirmation test if they saw that it was in the first portion of the test, which is usually an amino acid screen.
And why do they run screens as opposed to just going straight to the confirmation?
Some labs do go straight to the confirmation through something called QTOF. Labs are moving towards that, but it's less expensive to do the ELISA.
She has a starfish necklace. I like that.
What reason then, if they found cocaethylene or had a detection, why wouldn't they report it?
It may have been below their reporting limit or their limit of quantitation if it's a quantitative test. So this particular test was a quantitative test. You see everything's reported in quantitative units in nanograms per mil, not just presumptive positive or positive, except for the fluconazole. So if it's below their limit of proper quantitation, that is, if it's off the curve, if it doesn't fit on their curve because it's too low, then they won't report it. Or if it's below their limit of detection for reasonable presence.
Thank you. I want to ask you now a few questions as it relates to the substance cocaethylene. Could you educate the jury? What reasons would cocaethylene appear in any matrix?
So if cocoethylene is there, that
this
indicates
so many
that a person
times.
has ingested ethanol and cocaine at the same time, and it has gone through the liver. It has to go through the liver to make the cocoethylene. So this isn't something that would spontaneously form in the saliva or just in the blood. It has to go through what we call first-pass metabolism.
And let me ask you this. Cocaethylene, I believe you testified before that it was when cocaine and ethanol come together at the exact same time. Is that
Correct.
right? Is there any other reason that that would appear?
No.
How long does it take? Well, let me ask you this. We don't see ethanol when you find cocaethylene. What does that mean if cocaethylene is the presence of cocaine and alcohol at the same time? How could you see cocaethylene but not see ethanol?
So the ethanol will bind the cocaine and make cocoethylene, and cocoethylene has a longer half-life than alcohol. So if the alcohol is above the level of the cocaine, then whatever left over you might measure, but people have an average burn rate of 18 milligrams per deciliter per hour for 0.3 milligrams per minute of alcohol. So she could have, in a scenario, let's hypothesize a scenario, If she had drank even 4 drinks earlier that day, it would have been completely gone by the time she got to the hospital.
And so can you educate the jury, what is a half-life?
A half-life is the amount of time it takes for a particular chemical to be divided in half in the blood or the urine, depending on which half-life you're looking at, for half of it to dissipate and be gone.
Now, half-lives in terms of what that is for each particular substance, is it different for every substance?
Yes, it is.
Is this a standard accepted practice in toxicology?
Yes, it's at the top of most of the toxicology treatises, I guess you would say. In the Baselt's reference, which is kind of the Bible of toxicology and drugs, it's listed in the top left-hand corner in the literature that I presented.
What is the half-life for cocaine?
So the half-life for cocaine is pretty short. It's cited as anywhere from 0.3 to an hour.
And I believe you testified that BZE is the first metabolite of cocaine, the parent cocaine?
That's correct, and it has a different half-life than cocaine.
What is the half-life for BZE?
I think it's 1 to 2 hours for BZE.
And does EME have a different half-life than the parent cocaine and BZE?
It does. I don't recall EME's half-life off the top of my head, but it is longer than cocaine, the parent compound, which is why you see the large amounts of metabolite with the smaller amounts of cocaine.
And EME would be the second metabolite that forms after BZE?
Well, they form, I have a chart, they form differently. So BZE and cocaine are not, or BZE and EME are not the only metabolites of cocaine. There are several other metabolites, but those are the main metabolites of cocaine that are formed and measured in the pharmacokinetic studies that we look at to try to get an idea of how much should be in the blood or urine after a person ingests a certain amount.
And what is the half-life of cocaethylene?
So cocaethylene has a longer half-life as well. It's cited as different, anywhere from like 1 to 4 hours, basically. Some say 1 to 2, some say 2 to 4.
Do you know what would be the difference as to why it would be 1 hour versus 4 hours?
So inter-individual metabolism, co-ingestants. If a person's taking a particular drug, that can retard the pharmacokinetic profile for that particular drug because drugs use similar enzymes. So for cocaine, the main enzyme is CYP3A4. And CYP3A4 is a universal enzyme that metabolizes a lot of drugs, including fentanyl.
And well, let me ask you this. What is pharmacokinetics? You just mentioned that. Could you educate the jury what that is?
So pharmacokinetics is, I guess, the study of the metabolism of a substance and the ability to look at it over time, its decay over time. You can measure the pharmacokinetics. If you give a person dose X of a drug and you know what their weight is and you can estimate their volume, their body volume of blood, then you can graph a curve for how long it should take for that particular drug using the known half-life in different compartmental models to be exited from the body. As long as you don't have some other drugs that are using the same enzyme that are interfering with that curve, which is unfortunately what we have here.
And would that be the equivalent that the jury could probably understand is if someone is pulled over for drinking while driving and the police may want to try to figure out what was his blood alcohol level at a certain time, if they didn't get it particular. Is that the same as the extrapolation of alcohol to get that quantitative number?
Yes, there's pharmacokinetics for alcohol, and we just discussed them a little bit ago, that 18 milligrams per deciliter per hour burn rate, and I do that all the time.
Okay. And so were you able to guesstimate or try to determine, given the cocaethylene that was found in the vomitus of Ms. Benning, were you able to utilize pharmacokinetics to get an idea as to when you would have thought that Ms. Benning would have ingested cocaine and alcohol at the same time?
So, I guess first of all, it's an assumption to say it was an oral. She ingested something orally, right, beyond the alcohol. We don't know for sure with the cocaine, right? And second of all, we have to allow for the pass through the liver for it to show up in the blood. So, we would say in the past few hours.
hours? 2 hours, 3 hours, 4 hours, or can't you say?
Can't really say. No.
And is one of the reasons that you can't say is because there, in regards to the vomit, there aren't any numbers that can definitively be determined for that particular test.
Right, we don't have a matrix to compare it to, the blood, right, or the urine.
What about the blood that was found in 231268889? Are you able in any way to try to determine the pharmacokinetics in that regard?
So this is the tube that didn't have the preservative in it, the plastic sample, and we know that cocaine is very volatile. However, we don't know to the extent that it was volatilized, or hydrolyzed, excuse me, not volatilized. And what I mean by that is I think earlier Dr. Carney tried to infer that Ms. Benning had a 78 cocaine level when she came to the hospital, and then they drew her blood and then it all just spontaneously hydrolyzed to the tube. And I think that is very incorrect to say. One, it's not possible because cocaine is metabolized so fast. Some of it would have metabolized already by the time she got to the hospital, no matter when she took it. Because that 0.3 to an hour, and two, because these numbers, if I just saw these numbers, the
7,800.
When you say these numbers, are you speaking of the BE at 1,800, the cocaine at 78, and the EME at 7,800?
Yes, the smaller amount of cocaine at 78, the VZE at 1,800, and the large amount at EME. If I knew nothing about this case, I would think that this was a person who had used throughout the day and had stacked. Because of the large amount of metabolite. Now, what does that mean practically for us? And the tube that doesn't have the proper preservative in it. It means we don't know. We don't know what that number should have been. We don't know if it was higher in cocaine and it just hydrolyzed. Or we don't know if it indicates there was stacking or use going on during the day.
Okay.
From a toxicology perspective.
Okay.
I think it was in liquid.
Because there wasn't any preservative in the tube. And so we don't know whether half of it hydrolyzed, all of it hydrolyzed, some of it hydrolyzed.
So are you stating then, Dr. Lindsay, that the pharmacokinetics as it relates to cocaine is determined once that cocaine is preserved properly, and that's when you get more definitive numbers?
Absolutely, 100%. Yeah.
And so when Dr. Kotulski stated also that he would not agree to add the EME and the parent cocaine to get a definitive number, you would agree with that?
Yes, but for a different reason. I wouldn't do that in a good cocaine sample.
Okay.
Because they have different molar ratios and different half-lives, so they won't be present in a 1-to-1. It's not an apples-to-apples comparison. You might get a relative sort of abundance, or what's better to do is to compare it to what's in the literature when they give measured amounts of cocaine, and then they record what 10 people have in their urine or their blood 2 or 3 hours after they give the dose. And that, I feel like that is a better mechanism to try to get at that.
To that point, did you ever review other material and ascertain that 2 days later, Ms. Benning's blood tested positive for cocaine and had a measure of 69 nanograms per milliliters of cocaine?
Yes, I did, which would be pretty impossible by normal pharmacokinetics if the half-life was maintained as it would be with cocaine alone.
What do you mean by that?
She would have had to use an elephant's worth of cocaine at the high end and anywhere from like 6 to 14 8 balls at the low end.
4 to 16 8 balls. What is an
16, yeah.
What is an 8 ball?
3.5 grams of cocaine. And that's the low end. So the pharmacokinetics don't make sense. So why? Why don't they make sense? So the co-ingestion, I'm going to get a little water and I'm not going to spill it this time.
Right.
Promise.
Sorry, that was me.
The co-ingestion of fentanyl or the co-use of fentanyl with cocaine, whether it's ingested or not, they both use the same enzyme, that's CYP3A4. They also both inhibit the clearance of each other. So fentanyl inhibits an enzyme that pumps cocaine out of cells. And fentanyl also causes dopamine to accumulate at the synapse, which is the main mechanism of action of cocaine. What does that mean? That means if you use them together, you don't have the same half-life. You have cocaine hanging around longer and you have fentanyl hanging around longer. And because of that, you increase the toxicity of the two drugs and you lower the threshold dose at which toxicity occurs. In short terms, using them together makes them much more toxic at a lower level.
And how then can you explain that if Ms. Benning was in the hospital on 2/25 at 22:31, which would have been on February 25th of 23 at 10:31 p.m. and stayed in the hospital until her next blood test draw on February 27th, how then did that nanograms per milliliters of cocaine only go down by 9 points?
So, one, it probably didn't just go down by 9 points. There probably was more cocaine initially. However, as I said, the cocaine pharmacokinetics don't work. She obviously didn't ingest or was exposed to an elephant's worth of cocaine, nor probably 16 8 balls. Cocaine has a very anesthetic effect, and they even use it in anesthesia for eye surgery and for nose surgery. So that much cocaine would have numbed her mouth completely, or her nose, or her face. It's just not probable. So what is probable is that the pharmacokinetics of using fentanyl and cocaine together retarded the clearance. How much? We don't know. So where normally with a single drug you might be able to do some pharmacokinetics to try to arrive at what the dose might have been in the beginning, you can't do that here.
So to have a number, for example, to utilize the number Dr. Carney opined on of 7,878, can someone, in your opinion, slip that amount of cocaine in someone's drink without them noticing?
Objection, Your Honor.
I'll sustain the objection.
I'll ask you a hypothetical.
But
I have to ask a question. Let me give you a hypothetical. If someone was to slip an enormous amount of cocaine into someone else's drink, what, if any, symptoms would you expect that person to feel when levels are 7,878?
So I think people are getting the levels kind of mixed up.
She just asked you a question.
Okay, that level is actually within a normal medium to high use parameter for people that abuse the drug.
But would
That's
they,
not answering the question.
would they experience any symptoms?
Yes, so they would experience the normal symptoms from using cocaine.
And what type of symptoms would they experience with 7,878 nanograms per milliliters of cocaine?
Oh, if the level was that high, what a medium to high user would experience: tachycardia, agitation, higher heart rate, pulse. Sometimes some thoughts of persecution, fuzzy halos around the eye, around bright lights, hyperthermia.
So, and I guess my question is, if they were to drink that amount, would that affect the numbness in their mouth?
That amount, perhaps not. It might make them a little bit numb. What would make them really numb is trying to do the pharmacokinetics back to an expected dose.
So,
from that 69, which is our most reliable sample.
Okay, so the 69, was the amount in her blood on February 27th. If you were to use the pharmacokinetics to go back to February 25th, 23, what amount of cocaine would she have had to consume in order to be at 69 nanograms per milliliters on February 27th?
That's where we talked about the elephant and the multiple 8 balls, and I said that it was improbable. So in reality, we just don't know how much she consumed beyond that first blood measurement, which was in an improper tube. So it didn't give us an idea of when. It could have been earlier in that day. It could have been right before.
But will it be more than the amount that we see on these tests?
Oh, yes. Well, the 69 going backwards, yes. But the 78 is within normal limits of a high dose use, medium to high dose use.
And given those numbers that you stated would be very high doses, would you expect someone who was drinking that amount of high dose to experience numbness in their mouth?
Yes, they should.
That was the wrong answer for the defense. numbness in the mouth that would make it difficult to understand what she's
I
saying.
want to ask you a question in regards to liquid cocaine.
Okay.
Is liquid cocaine a thing? Is that a thing?
Not really, but people do dissolve cocaine in liquids.
And to dissolve cocaine in a liquid, along with alcohol, how much cocaine would someone have to dissolve in a liquid to end up at the numbers we see on these tests?
To end up with the numbers that you see on the test, not that much. What a medium to high dose user would use. The problem is that the test is not reliable to tell us when it was used. That's really the problem.
And I'm not speaking of the numbers on the test, I'm talking about going back to 225 in order to end up on 227 at these numbers.
Oh, that's super high dose. That's improbable. That's how we know the pharmacokinetics are off. You can't use the singular compartmentalized.
In your
method.
opinion, do you believe that to use the pharmacokinetics to go back, because we know the half-life is 0.7 to 1 hour.
0.3 to 1 hour.
0.3 to 1 hour.
It's
and
different
so
in different places. Yeah.
that means, let's just use an hour for example. For every hour, you would have to go back, cut that number in half. Is that right?
Increase that number, yes.
Right, going backwards, increase
Yeah.
that number. And so every hour, you would increase that number by half to go back.
Which is billions of milligrams, which is why you're in the ton range. So,
And that pharmacokinetics is in fact the standard accepted manner in order to determine what that person's dose was at the time that we are trying to determine on 225, on the evening of 225, that is an accepted practice in your field of toxicology.
yes, if you can get it to a single drug where it's acceptable. Yes.
Thank you. I pass the witness.
Sure.
Dr. Lindsay, so you claim that you've reviewed several things in this case file, correct?
Can we get a little more volume, please?
No, I reviewed several things in the case file.
That's what you said.
I think you said I claimed to review.
You claimed to. I'm saying you said that you reviewed the toxicology reports, the detective investigation. You said
Yes.
the EMS.
It's on.
That's
The
correct.
reports.
Yes.
It's
Have you been
on.
watching all the testimony this week?
I've been watching most of the testimony. I tried to watch most of it. Yes.
Okay. And you reviewed the bond hearing transcript, correct?
That's correct.
And the Pandora records and the medical examiner records, correct?
That's correct.
And so you heard Dr. Carney's testimony before this jury, is that right?
That's correct.
And you heard Dr. Kovalewski's testimony before this jury, is that correct?
Yes, that is correct.
And you also heard Dr. Mithen's testimony before this jury, correct?
Yes.
Okay. And so you were talking about the methamphetamine and the marijuana that came up in the assay test on the comforter. That's what you started out talking about. Do you remember that?
I remember it was mentioned, but that was one of the side tests that were done, or one of the results that came up, but it wasn't validated.
Correct. It wasn't validated because they can have false positives, correct?
I believe it wasn't valid. Well, yes, because of the iron ratios, they weren't correct.
And that's what Dr. Mithen testified to, is that it could be a false positive. It did not mean anything. She just noted it, correct?
That's correct.
And you would not report out something that is that low level, correct?
So there was a difference between the ion ratios being off and it being a low level. I don't believe she said that they didn't report it because of the low level. I can go back and check the testimony, or you can put it
It was
up.
the ion ratios wrong. It was something that she couldn't report, correct?
Right, and they didn't run it again to see, because I think they were concentrating on the cocaine and the fentanyl. So, yeah, they only ran it that one time.
You would agree that Ms. Benning had multiple tests run and none of them tested positive for methamphetamine, correct?
Oh, correct, yes.
Okay, and none of them tested positive for marijuana either, correct?
Correct.
Okay, and also when she got to the hospital, she did not have alcohol in her system. That came back negative, correct?
No, you can't say that because the reporting threshold is 10 nanograms per mil. So as I discussed earlier, anything below that 10 nanograms per mil will be reported as a negative.
Okay,
but
So we can only say that it was reported as a negative, that it was either negative or less than 10 nanograms per mil.
Okay, so if the cocaine was dissolved in a very small amount of alcohol and put in her drink and she ingested it that way,
Yes.
that would explain the cocaine that is apparently so incredibly important.
It would have to be a larger amount of ethanol, not just a little bit, in order to come up in the assays. So we're not talking like a teaspoon. I think somebody had said something crazy like vanilla before.
Well, you just said somebody said something crazy. That's interesting because you're saying that it came up in the comforter, the cocoethylene, correct?
In the vomitus, yes.
Okay, but Dr. Mithen's report specifically does not even have a numeric value. The response was so low.
Yet it's still persisting in other matrices a couple days later, so it just hadn't formed all the way, probably.
It literally does not have a numeric value. That is how low it is.
Okay, but it's still persisting in other matrices days later, so we know that it was at a higher value then, even given its half-life.
Days later, when she's in the hospital receiving medication after medication after medication, trying to keep her alive on life support because she ingested liquid cocaine. Correct?
I don't know that.
Dr. Lindsay, you have heard
Excuse
three
me,
experts
you don't need to raise your voice.
testify.
Okay, have a seat, Ms. Collins. Just ask your question in a reasonable manner.
Dr. Lindsay, you have heard three experts testify that it was ingested and it had to be a liquid. It was in her drink.
Are you testifying? Because there's nothing.
Please don't interject yourself. Just keep yourself calm as well. You don't ask questions, okay?
I'm sorry.
Okay.
There is nothing.
Now, what is your question? You said three experts said X. What is your question?
You've heard the three experts testify that it was ingested orally, correct?
I've heard them testify that it could have been ingested orally.
Have you heard them testify that there was no evidence that it was ingested in any other manner?
No, I haven't.
You haven't heard that testimony?
I have not. If you point it out, I would be happy to look at it.
Okay, so you didn't hear Dr. Carney's testimony when she described her autopsy.
That wouldn't show you whether it was ingested orally or by any other manner.
Okay, and Dr. Lindsay,
Wow.
you
That's a
went
strong
on
witness.
and on about pharmacokinetics and calculating a dose. Did you provide your calculations?
Did I provide my calculations? No, but anybody can do them. If it's a half-life of 30 half-lives in between the first and the second dose, you would be up to billions of milligrams.
Okay, so you don't have any math that supports that at all for pharmacokinetics?
I did it at one time, but it was so off the chart, I knew that it was incorrect.
Oh, so you knew that you were incorrect?
No, I knew that the pharmacokinetics did not make sense. So anybody can take, the other experts didn't do the same calculations, and they could have, or they should have. They would have seen right away that it was not possible.
Well, you're saying it's not possible because you're refusing to acknowledge that it was ingested in liquid form, correct?
No, I'm not. I'm saying we don't know. It could have been ingested in liquid form, or it could have been used in another form. We just don't know.
Well, that's what you're saying, that you just don't know. But Dr. Carney was very positive when she did her autopsy report.
That
So
wouldn't have shown, an autopsy report would not show whether someone had ingested it orally or ingested it through insufflation or injection. An autopsy would not show that.
Dr. Lindsay, are you a forensic pathologist?
No, I'm not a forensic pathologist, but I'm a toxicologist, and it would not show that. I don't. If you want to describe how it would show that, maybe that could enlighten me.
Dr. Lindsay, I am asking you the questions.
Okay, and I'm
Have you
correcting
ever
you.
performed an autopsy?
No, not on. No.
Okay. Did you hear Dr. Krolewski's testimony where he said that he would not even attempt to calculate using pharmacokinetics to try to calculate the dose?
He doesn't do that regularly in his practice. He's more of an analytical chemist. It was clear by the way he answered the questions, and that's why he wouldn't do the pharmacokinetic calculations. That's more of a biochemistry type thing.
Dr. Lindsay, that was not Dr. Krolewski's answer. You do know that, correct?
I listened to his testimony, and that's how I knew he didn't do that. He didn't do it on a regular basis. He's more of an analytical chemist toxicologist than a strict toxicologist who does pharmacokinetic modeling. I think he was open about that.
She might be pushing too hard, this witness.
you reviewed everything in the investigation file and the testimony at the bond hearing, correct?
Yes, that's correct.
But you are here testifying that you think it's possible that Jade Benning was drinking 4 drinks out and doing cocaine. How was she doing it again?
We don't know.
Okay, but what did you use for your pharmacokinetics calculation?
So that's a little bit different. What I'm saying is we don't know whether she ingested it orally or whether through insufflation or whether injection. We just don't know because the numbers don't tell us. And the only reliable numbers we have are from a tube that did not have preservative in it. So while a ratio in a proper tube might give us an idea of whether it was orally ingested in case of instead of insufflated, we didn't have that because we have the tube that didn't have the proper preservative in it.
Okay, so my question is for the pharmacokinetics that you testified about, I think at one point you said 16 that you all, what was the ingestion method that you used for that pharmacokinetics calculation?
So I did assume an oral bioavailability for that. Oh, gosh, should have been using that before.
Yeah.
So you assumed liquid cocaine.
Cocaine taken orally.
Dissolved in a liquid.
It doesn't have to be dissolved in a liquid. It's the same thing if you take it orally or food, liquid, whatever. It's going through the metabolism that way instead of going through insufflation or vaginal insertion or whatever.
So you said that, and
Okay.
then immediately
Bingo.
afterwards you said, but you can't calculate the pharmacokinetics with this case.
Correct.
So you calculated it, and then you said you cannot calculate it in this case.
Yeah, so the history is that when I tried to apply proper pharmacokinetics to this case, it didn't work. And so then I went into researching, because it wasn't plausible, then I went into researching, well, why could that be? And then there are a couple articles that I provided the literature here. The best one is Chang et al., who goes into the pharmacokinetics of cocaine and fentanyl taken together and how they both inhibit each other's clearance. What does that mean practically? They both inhibit each other's half-life or clearance. So we don't know how much.
Dr. Lindsay, you're going on and on about cocaine and fentanyl. Those aren't the facts of this case. Dr. Lindsay, you do agree that on the internet there is information about liquid cocaine. Do you agree with that?
Yes, can we clear up the last statement?
Do you want to start arguing with her?
No, she just made a factually
Okay,
incorrect
if your lawyers,
statement.
they want to ask you, they'll ask you. Go ahead. What is your literature about liquid cocaine?
It's on the internet, correct? There's rehab facilities that have internet pages, and when you go to it, it says do not ingest it this way because it is lethal and it will kill you. You have seen that, correct?
Yes, if you orally use cocaine, you can overdo the amount because the bioavailability is less and it takes longer to absorb.
And it is known to cause death. It is lethal, correct?
No, lots of people use cocaine that way. I mean, it's not preferable. You kind of waste part of the drug, but apparently the high is supposed to be better.
That's not the testimony.
The problem is the fentanyl along with the cocaine, which lowers the threshold dose of toxicity.
Okay, so if a website says that it increases the risk of sudden death, you're just saying not really, even though.
I'm saying it doesn't cause death in all cases.
But it can cause death, and there is information on the internet that warns people about that. Don't you agree?
Okay, I'll rule it just, she's going to answer, I think.
Yes, of course it can cause death. It depends on the amount.
And you would agree, too, that there is a lot of information on the internet about cocaine and that it can cause a placental abruption or a spontaneous abortion if used when pregnant, correct?
Cocaine can cause myocardial infarctions, including things like placental abruptions. Yes, it can.
I mean, this is the U.S. Department of Justice, 1988, cocaine use in pregnancy can lead to spontaneous abortion of the fetus.
Yes, it can also lead to birth of those babies, which everybody knows about, the crack babies, the cocaine babies that are adopted, thankfully.
Thank you, Dr. Lindsay.
Any other questions?
Yes.
Wow.
Can I have that home, please? I was asking him if I could utilize the here.
Can you utilize the microphone, please?
It's up.
Thank you. Dr. Lindsay,
Yes.
I want to draw your attention, first let me do this. Draw your attention to the NMS litigation packet and from data in regards to, oh, sorry, that's the wrong one.
It's the wrong
In
one.
regards to 23129285. Do you see that?
I do.
And do you see the window for coca-ethylene?
I do.
And just to be clear, 23129285, is that the comforter we've been discussing this morning?
Yes.
And do you see a peak in a presence for coca-ethylene?
Yes, this was also admitted to by Mithun and Katalski.
If you'll just answer the question as it's given.
Sorry.
Instead of ad-libbing all of the information. Go ahead.
Thank you.
Yes.
And so does that in fact show that there was in fact the presence of coca-ethylene on the comforter in the vomitus?
Yes.
Now, to be fair, it was not up to the reportable limit, but it was in fact there.
Yes.
Are there reasons why a substance will not be at a reportable limit?
If it's not formed yet, if it's below the reportable limit.
And would this be before Ms. Benning ever made it to Vanderbilt Hospital?
Yes.
I now want to show you, again, NMS Laboratory Report 231-29285. Do you see that?
Yes.
That is the same number associated with the comforter. Is that right?
That's right.
And do you see the fentanyl peak in this window here?
Yes.
And is that peak a representative of, in fact, fentanyl being present in the vomitus on the comforter?
Dr. Mithun testified that it was, yes.
She added more.
So it's not just you stating that the fentanyl was present and or the coca-ethylene was present. This is NMS lab data that was performed by Dr. Mithun.
Yes.
Your Honor, may we approach briefly?
Okay.
All right, sidebar. Let's see if we can skip through this a little bit. Trying to skippity-doo-dah through this. Oh, it's pretty quick. There we go.
Finally, Dr. Lindsay, is there any type of treatment at a hospital that will cause you to test positive for coca-ethylene?
No.
Thank you.
Not that I know of. I would
Thank
say.
you. I'll pass this.
Any other questions?
No, Your Honor.
Thank you, Nadine.
Thank you, Your Honor.
At this time, Your Honor, the defense will call Dr. Kelly Larkin.
Okay.
Wow. That was a spicy witness. Not Kelly Clark's. No, there's not a concert. That was a really spicy witness. She had to make up for the other witnesses that got kicked off. She had to use all the spice from the other defense witnesses. We're not allowed in. Can we what? Are we approaching? Apparently we are. Just missed my timing there. Hang on 1 second. Did she spill her water on the way out? I don't know. She definitely spilled it on the way in. Prosecution, I think, was outgunned with that witness. I think they did not anticipate the level of snark and the ability to snap back that they were confronted with. but I think the witness overextended by questioning the ME. Oh, ME's medical, autopsy can't tell you that. Let me just ask you, what lane are you in again? Yeah, so possibly could have lost some credibility with the jury that way. All right, we're going to zoom because we can. Okay, this lady in gray who's standing at the gate waiting to come in is the next witness.
Yes, Your Honor. Maybe we have a few minutes to review this. Having now just been handed.
What?
Something different.
Yes. Which might result in a jury out.
You'll step down the hallway, listen.
Jury out. Here we go. Oh no. Oh no, the judge is not happy. He's not happy with that witness, with how she treated his court, the last witness. And he's not happy with the defense because we have another issue with late disclosure.
What do we have different, Ms. Holland?
This is my first time, so I'd like to take a minute.
All these experts just they show up on the day of testimony and bring a brand new.
This just appears to be notes that she took. The first page are notes that come from the testimony 911 call that Mr. Taylor made. There is testimony notes from Najee Jackson. She has names here of the EMTs. She has some medication notes from the medical records.
All of this just was generated overnight.
And it's not original thoughts, it's just notes that she took from the records.
All of that was generated overnight?
Yes, Your Honor. Yes.
What does that mean?
I'm assuming she took notes in regards to when she and I met and we went over what she would testify about today.
How long does the state need?
Not long.
Would you like to see the notes, Your Honor?
I don't know. How long does the state need?
We have just maybe 3 or 4 more minutes, and maybe in that time can get Dr. Carney connected up.
How long is it going to take to get Dr. Carney a link?
We just sent it to her.
Oh, okay. Somebody told me 20 minutes.
That's what initially, Judge, they actually said 30 minutes. And then we cut it down a whole lot.
We saved 10 minutes.
And just, I'm trying to see when, I don't know if it'll be this week or next week when we finish the proof, but you're planning on calling Mr. Taylor? Carl Taylor?
No, we decided not to.
Oh, okay. So this would be the last witness?
It would be.
Oh.
Last witness. No testimony from the. No testimony from the defendant. Then let's zip forward just a tiny bit because we're in break now. Just a few minutes for her to get connected. There we go. All right, the break is coming to an end. My apologies if you thought you were going to get a little bit of time to yourself. That didn't happen.
She has it, yes, Your Honor. Thank you so much.
All right, where, see if we can get our Dr. Larkin.
Okay. Maybe this witness said, watch out for the water because it's a trap. Where's our gray-suited witness? Not that one. Jury's coming in. There's our witness. It's a blue suit? Does it look blue to you? Looks gray to me. San Diego. Is that similar to San Diego?
Do you swear the testimony about to give to be the truth, so help you God? I swear.
Yeah, watch the water. Watch the water. Don't fall victim. Don't do it. Don't do it. Oh, don't. Okay.
I got a little here, so thanks.
Good morning, Dr. Larkin. Could you please state and spell your name for the record?
Yes, my name is Dr. Kelly Larkin, Kelly
And could you please give the jury a little background as to your education as well as your employment experience?
Yes, I'm a board-certified emergency physician. I've been practicing for 30 years. I have a bachelor's degree in science. I have a master's degree in neuroscience. I have a medical doctorate. And following completing medical school, I did an emergency medicine residency training for 3 years. Following that, I was invited to take the board examination to become board certified. I took the written boards. Once I passed that, the next year I was invited to take the oral boards. Once I passed that, I was a board certified emergency doctor. Since that time, every 10 years I have to recertify. So I've recertified twice now. And so I'm still currently a board certified emergency physician. And for the past 30 years, I've worked exclusively in emergency departments, mainly in Houston, Texas area.
And have you had any publications as it pertains to articles and or any kind of treatise?
I've had some publications from like graduate school and some small publications.
And have you had an occasion to also teach?
Yes, I've been a associate professor at University of Texas, so I've taught medical students, residents, paramedics, different emergency providers over the years.
Have you had the occasion to testify before and been certified as an expert in emergency medicine?
Yes, I have.
At this time, I would tender Dr. Larkin in the area of emergency medicine.
Any questions?
No question.
Okay. All right, again, ladies and gentlemen, this is Dr. Adele give an expert opinion in emergency medicine, her field, and you can place such weight as you choose to upon it.
And at this time, I would tender to the court Dr. Larkin's curriculum vitae.
Okay, 63.
Dr. Larkin, in preparation for your testimony today, did you review any of the materials that were involved in this case?
Yes, I did. I reviewed the medical records, the EMS records, the 911 call, some of the toxicology reports, some of the transcripts from some of the testimony this week. At least that much. Probably some other things too.
I want to go right to it and take you to, Josh. I want to go right to the 911 call on February the 25th, 2023. Do you remember reading the information in regards to that particular call made by Blaise Taylor?
Thank you so much.
Yes, I do.
15 months.
And did you have the opportunity to also read the EMS and the fire department's records as it relates to that 911 call?
Yes, I did.
And, well, before I do that, let me ask you, have you had the opportunity over the course of your career to treat overdoses?
Yes, I have.
Over the 30 years that you have practiced emergency medicine, how many overdose cases would you say that you have treated?
many. It's pretty common. So there's different types of overdoses, accidental and intentional, but probably 400 or 500 over 30 years.
Have you also had the occasion to treat patients who ultimately pass away and expire?
Yes, I think unfortunately all emergency physicians do, and probably 10 or so deaths in the emergency department per year, maybe some early on years in the trauma center more than, significantly more than that.
And in regards to those overdoses, those 400 to 500 overdoses that you treated and experienced over the last 30 years, did any of them have to do with illicit as well as prescription substances?
Yes.
Now I want to draw your attention to the 911 call on February 25th, 2023, made by Blaise Taylor. Can you tell the jury, did you read some of the symptoms that were explained by Blaise Taylor in regards to what he felt he was witnessing at the time?
Yes, so I read it. I also did listen to the 911 call as well, and I did listen to the symptoms he was describing.
Did you listen to any other person's description of Ms. Benning's symptoms as the medical episode was happening?
Her friend Nigeria had a around 6 minute phone call prior to the EMS arriving and kind of overlapping into that, well, prior to the 911 phone call. So there was a little description as well in her testimony this week.
And what symptoms, if any, stood out to you?
So if we start with her friend Nigeria, the phone call started and the way it sounds over those 6 minutes, towards the end of the call, she was not really able to understand what Jade was saying, whereas in the beginning of the phone call, she could understand what Jade was saying.
And what about any of the symptoms that were described by Mr. Taylor?
Yes, so Mr. Taylor described to the 911 operator a couple different times. Initially, he said that she had spit coming out of her mouth and that she was shaking. And then as the 911 operator was asking more questions about her status, he said that it sounds like she's snoring.
Was that a significant symptom to you?
It's a very significant symptom. We worry a lot. So snoring in a normal patient, this is not normal sleeping, is really a medical emergency. It means that they're relaxing the muscles in the back of their throat, impending respiratory arrest, not able to continue to breathe normally. So, and what's interesting is, I work in an emergency department where we have a lot of cancer patients, and so we give a lot of fentanyl in particular and a lot of opioids, and we really watch when we're giving those doses to make sure, and if the patient starts snoring or we see that that's too much, we realize, they have to be reversed. So it's something we're very familiar with and very concerning.
And if you would look on your screen, do you notice there that you'll see on line 48, do you see what it states there?
Yes, on line 48, that's where Mr. Taylor mentions it sounds like she's snoring.
And would that be the symptom that you thought was very alarming as you just described?
Yes, it is.
What, if anything, does that tell you? Well, before I ask you that, were there any other symptoms that you felt like were important?
I think those are the most important. We knew that she was breathing during this time period. That's mentioned several times by Mr. Taylor as the EMS operator was speaking to him, but those symptoms are very concerning.
And why do you feel like they're concerning?
Because, as I mentioned, when someone gets to that state where they're not breathing normally or they have sonorous respirations, that means that they're not getting oxygen delivered around their body, to their brain, to their heart. They're not getting rid of the carbon dioxide that's bad for our body. And so when those things start piling up, then that's when you can have a heart attack. That's when you can have a cardiac arrest. Because if you stop breathing first, it's just a matter of time till then your heart's going to stop because it doesn't have enough oxygen.
And did you actually see, as you just described, that in this medical incident with Ms. Benning?
Yes.
Did you have the opportunity in preparation for your testimony today to not only listen to the 911 tape, but to look at the emergency records in this case? If you could go back.
Yes, I did.
And what I mean by that is from EMS and the fire department. If you could blow up the pre-hospital care report, the second. Thank you. Do you notice in this report narrative where it states that the patient's boyfriend stated the patient was 4 months pregnant?
Yes, I saw that.
Now, I want to also ask you, did you also review the Emergency Communications Center information?
Yes, I did.
And did you also review another CAD incident report from the emergency center?
Yes, I did.
Did you, in your preparation today for your testimony, see where there was any other or any place where Mr. Taylor described this incident as an overdose?
I did not.
Did you see that someone did describe it as an overdose?
Yes.
And who was that?
So initially, it says that Medic 35 was dispatched to the location for an overdose. So the way that works is typically the 911 operator would have sent information to dispatch the ambulance, and they would have told them that was what their initial dispatch was for, an overdose.
Did you have an opportunity to listen to the 911 call that Mr. Taylor made in regards to this incident?
Yes, I did.
Did he ever describe this as an overdose?
He did not.
Did you have an opportunity over your course of the 30 years in the emergency room? It's fair to say you've seen many emergencies.
Yes, we do.
Where do you currently work?
I work at University of Texas MD Anderson Cancer Center Emergency Department in the Houston Medical Center.
And prior to that, where did you work?
I was at Baylor St. Luke's Medical Center for 20-some years prior to that.
And in all those years, were you practicing emergency medicine?
Yes.
So have you had the opportunity to come in contact with many families who had loved ones who were experiencing significant medical emergencies?
Yes, every day that I worked.
And sometimes those medical emergencies ending in death.
That's correct.
And can you tell this jury whether or not there's any one way that you've seen a person respond to a familial medical emergency with a loved one?
Absolutely not. Everyone behaves differently in these emergency situations. I think it's common everybody behaves differently in just any emergency situation. So now if you're in an emergency department and a loved one is sick or something is going on, some people are calm and you can tell they're upset. Some people are a little more excited. Everybody responds differently. I could never describe that one way to do it. There's no right way to deal with that. I can't imagine being in a situation on the other side of it.
So I now want to draw your attention to when a patient arrives at the emergency center. Okay. Are there situations when a patient would have to be intubated when they get to the emergency center?
Yes, that can happen.
Have you had the opportunity to see whether or not Ms. Benning was ever intubated?
Yes, I did.
And did you find whether or not, did you determine when she was first intubated?
So intubation is actually a process where a tube is put down into the trachea to breathe for them. But in Ms. Benning's case, the EMS put a temporary airway in right away in the ambulance, which is a very common thing to do. And so a tube is put down and it works well to breathe for a patient for a temporary measure. What happens then, we get them in the emergency department and now we need a little bit more permanent measure that's for sure a secured airway, and that's what's called intubation. That's when you see it on TV, they go in with the scope, they look in and then put the tube down and that tube stays in there and that's breathing for them. So that actual intubation followed the temporary airway, but that intubation happened at Vanderbilt in the emergency department.
Okay. And was there any medication that was given to Ms. Benning to assist with intubating her?
Well, yes, so one of the medications, she received succinylcholine in the emergency department.
Is that a common medication that is given to a patient when he or she is being intubated?
Yes.
What is the purpose?
It's a paralytic, so typically you want to give a sedative and a paralytic for a patient to intubate them. That's basically the definition of how you intubate someone.
Did you have an opportunity to review all the medical records? Well, let me ask you, do you see anywhere here on these medical records in front of you? We'll start with page 55, where you see the paralyzing agent succinylcholine given to Ms. Benning.
Yes, I see that in the ED notes.
Okay. And I should ask, is this in fact?
I object to this stating the medical records testimony that was not given because Ms. Benning was dead. All right.
And that's the
page
reason.
101.
That's the reason we're going into the records, Your Honor.
Okay, well, you can cross-examine as you see fit. So this is her opinion.
Overruled.
Do you see on page 55 right in front of you? Are these the medical records of Miss Jade Benning?
Yes, these are the EPIC medical records from Vanderbilt.
And can you circle, if you can, the top right corner with your finger where it states these are Jade Benning's medical records? Can you circle, if you see where it says ED notes, and if you were to go down there,
Oops, sorry.
if you were to go down maybe 9 or 10 lines, do you see where it says paralyzing agent subacetylcholine?
Yes, I do.
Could you circle that for the jury, please?
You're going to start that
And
fight
could you
over
read
here,
that
Stacy?
for the jury, please, that notation that's made?
Yes, so in the ED notes, it says paralyzing agent, succinylcholine, injection, 76 milligrams, and then it was given on 2/26/23 at 00:52.
Would that be the late night, early morning of February 26th?
Yes, early morning.
And as an emergency room doctor, does this state to you that Ms. Benning was in fact given subacetylcholine?
Yes, she was.
And based on your review of the records, was she given that in an effort to help intubate her?
Yes, it's in the other notes as part of the procedure to do the actual intubation.
And it is your representation that this was in fact in the emergency room?
Yes, it was.
Emergency department?
I'm sorry, yes, it was.
I want to now draw your attention to page 90. And if you could clear your screen, please, at the bottom.
How do you do that? Oh, clear. Okay.
On page 90, are these two Ms. Jade Benning's medical records?
Yes, these are her records.
Could you circle her name
You
at the
don't
top?
have to give it a circle. It's right there in the report.
Do you see where Ms. Benning was, or at least subacetylcholine in these records as well? Also, those are, move to the next page, please. To page 90.
These side-by-side reports are impossible to see. Sorry, guys.
Move forward. So let's now go to, was there a time when Ms. Benning, based on your review of the records, was getting fentanyl?
Yes, she received fentanyl.
And do you see when and where she was given fentanyl?
Yes.
If I could I get the envelope, please? Do you see the highlighted area there on page 562?
Yes, I do.
Records? Could you describe to the jury what it means here when it says fentanyl ADS override?
So that's when they actually just pulled out the fentanyl to administer.
Okay. And based on your review of the records, was she ever given fentanyl at this date and time?
She was not.
I now want to draw your attention to page 567 of Ms. Benning's medical records. Do you see the highlighted areas there?
Yes, I do.
And is this in reference to the medication fentanyl?
Yes, it is.
And was she given fentanyl at this time?
Yes, she was.
And what time do you see notated in the medical record of Ms. Benning as to when she was first given fentanyl?
So her initial infusion of fentanyl was 2/26/23 at 00:39.
So
I'm sorry, 00:41. So the pull and the, I think that's enough the time. Yes, 00:41, 00:45 I have where the infusion started. So there may be another page of this as well.
Okay. This is page 727.
That's correct.
Okay. You could go ahead and explain to the jury what this is saying.
So this tells you that the infusion starting, the time that's highlighted on the right is 00:45 for the actual infusion starting.
Okay, and when does it end here in this medical record?
Oh, yes, I can see. I'm sorry. I should put my glasses on. But the end date on this infusion and at this rate was 2/27/2023 at 18:43 or 6:43 p.m.
And in your review of all of Ms. Benning's medical records, is that where you see she was initially given fentanyl at Vanderbilt Hospital?
That is when she initially got fentanyl, yes.
I now want to go back to page 90 of the medical records. Do you see there in reference to the medication succinylcholine?
Yes, I do.
And what is this record representing?
So this is on the ED timeline. So this is basically step-by-step everything that goes on in the emergency department. And this shows you that at 0015 that there was an order placed for succinylcholine.
And is this too in the emergency department?
Yes, it was.
I now want to draw your attention to page 562 of the medical record. What does this represent, Dr. Larkin?
So this is the succinylcholine, again, the pull. So that's taking out the succinylcholine out of the machine to be able to administer the succinylcholine. So that shows it was taken out.
And based on your review of the medical record, I'm sorry, I will go to page 567. What does that represent?
So this is showing you that the succinylcholine injection of 76 milligrams was completed, and it tells you who had ordered it initially, and then it tells you the nurse that acknowledged that as well.
And does it state completed?
Yes, it does.
What does that mean?
That means that the order that had been made to give the succinylcholine actually was completed, so it was given to the patient, and that goes along with the other one we saw earlier that said when it was given.
And is that, again, in the emergency room?
Yes, it was.
Now, I want to now draw your attention back to, is it working?
Oh, nice pour. Good work, man.
And we can go back, Josh, to the records, not the litigation, of the toxicology reports. Did you have an opportunity to review the toxicology report from NMS 23129-285?
Yes, I did.
And did you learn from the review of these records that this was in fact vomit on a comforter that Ms. Benning vomited during the evening as a result of her medical incident?
Yes, I understand that.
And did you consider that too to be a symptom in regards to her medical condition?
Yes, it's not uncommon as someone is having respiratory difficulty or other problem that they have some vomiting.
Did you notice, based on your review of any of these toxicology reports, have you had the opportunity over the 30 years of your practice to have to deal with toxicology?
Yes, so as an emergency physician, you get trained in toxicology. We obviously have patients that come in and we have to look at reports regarding toxicology.
And you're not claiming to be an expert in toxicology, are you?
I am not.
Okay. Did you notice in the records, lab reports of Ms. Benning from NMS, whether or not you noticed that coca-ethylene was present in her system?
Yes, coca-ethylene was present in that NMS sample that we're looking at.
Thank you. Have you ever had an occasion over the course of your career to treat a fentanyl overdose?
Yes, I have.
Have you ever had an occasion over the course of your career to treat a cocaine overdose?
Yes, I have.
And could you describe for the jury what you would expect to see after 30 years of working in the emergency room department? Have you had an occasion to deal with cocaine overdoses?
Yes, so they're almost opposites of each other. So cocaine is more of a stimulant, and then fentanyl is more a depressant. So cocaine overdose, typically when we see them in the emergency department, they've got fast heart rate, they're anxious, they're hot, they might be breathing normal or fast. They can be paranoid, they can be excited, but they're kind of the symptoms that go along with the cocaine. they come in maybe with chest pain because their heart's beating so fast or their blood pressure is so high. So it's all of those things like that are amped up on the system. So the difference with fentanyl is classically is there's more drowsiness, and I think I described that we see it sometimes in the hospital when we give a little bit too much fentanyl to try to treat someone's pain. We have to watch out for them getting too sleepy. But with fentanyl, again, the respirations tend to slow down. It's a little more gradual of a change versus like the cocaine. Like I said, they're hyped up and they've got things going on that are fast. Typically, in the fentanyl overdose, we see that they slow down their breathing. They end up having a respiratory arrest, and after that, again, if the oxygen doesn't get there to the heart and to the brain, then they can have a cardiac arrest. And that's typical progression.
And can you describe to the jury what a fentanyl overdose looks like?
Yes, so as I mentioned, the fentanyl is when they have typically the respiratory arrest. They might be awake and talking, but then all of a sudden they get a slurred speech, or they get quieter, or they start not feeling well and sleepy, and then their breathing starts slowing down. They could have snoring, as we talked about earlier, and then eventually the lack of oxygen can cause worsening things like a cardiac arrest or just a demise at that point from lack of oxygen to the brain and to the heart and the other organs.
And did you take a look at all the symptoms that were described of Ms. Benning in this particular case?
Yes, I did.
And were you able to opine as to, based on the symptoms that were described, what was more consistent with the episode that Ms. Benning was having?
In this case, it's definitely more consistent with fentanyl. And unfortunately, we're seeing more and more of that over the past several years. It's just increased. And it's adulterated drugs. It's not necessary. People know that it's in something that they might be taking. And that's when we see these tragedies and these accidental ingestions of the fentanyl. So to that end, this is more of a fentanyl presentation where, like I said, in this case, she started talking to her friend Nigella. By the end, she really couldn't understand her, so maybe she was getting more not able to speak as well. And then, as Mr. Taylor describes, she's laying on the bed, she's not really responding much, she's snoring, she's got some foaming coming out of the mouth. All those things go along with fentanyl. Not to say there couldn't have been something else, but we know what we see a lot of is mixed things now, and unfortunately what we're seeing is a lot of cocaine that now has fentanyl in it, and that's been kind of the fourth wave of things that we're seeing, so we have to watch out for that. So to answer it, the fentanyl is more likely to be definitely part of this overdose.
As a medical professional in an emergency room, did you notice that Ms. Benning had fentanyl in her system prior to receiving it at Vanderbilt Hospital?
Yes, I did.
And are you able to opine that fentanyl had nothing to do, given all the medical records that you reviewed for Ms. Benning, to do with her medical episode?
Can you restate, please?
Can you opine that fentanyl had nothing to do with the medical episode suffered by Ms. Benning, based on the records that you've read?
No, so fentanyl, we know fentanyl was present, and it was present prior to her getting fentanyl in the hospital.
Yeah, check. I'll get to cross-examine, but that is not what is in the record.
Okay, she's just indicated it is from her perspective, so go ahead.
Now, finally, have you had the opportunity to review the autopsy report from Ms. Benning?
Yes, I have.
And in reviewing the autopsy report, was there anything specific in regards to Ms. Benning's heart that stood out to you?
Yes, and I believe the medical examiner mentioned it as well. There was a enlargement of the left ventricle of the heart, and also the myocytes of the heart. It just means the cells that are in the heart, and they were enlarged in that left ventricular area. And that can be caused by several things like long-standing high blood pressure and other things. But again, that can be consistent with just something chronic, meaning you can't make big cells in that part of your heart quickly. It didn't happen with this event. It's not acute. It had to happen over time. So one of the chronic things that can cause this over time is just cocaine use over time can cause those myocytes to be large and that ventricle to be enlarged.
Now, to be fair, are there other things that could cause this type of myocyte hypertrophy?
Yes, and other things that make the heart work harder, like I said, high blood pressure, other heart problems.
In reviewing the records of Ms. Benning, did you have the opportunity to review her OBGYN records as well?
I didn't focus very much on those, no.
Okay, thank you. And what do you notice here
in regards to what is notated in Ms. Benning's, to be fair. Is this the autopsy of Ms. Benning?
Yes, it is.
Who's printing?
What did you notice?
See us, Love Life. Thank you.
This is what I just referred to. Basically, sections of the ventricle. The ventricle is one of the top chambers of the heart, and per this note, or per the report, it says they revealed focal myocyte hypertrophy. Big fancy words, but it just means the cells in that area were bigger than normal. And again, that's a chronic finding, not an acute finding.
When you say chronic versus acute, does that just mean one episode can't cause this?
Correct. This wasn't caused from the episode that caused her demise. This was something that had to have been going on prior to this to cause this.
And could you then read from page 5 of 5 of Ms. Benning's autopsy report, the highlighted area?
Yes. So histologic exams, so just basically looking at the cells on a microscope. The histological examination of Ms. Benning's organs reveals focal myocyte hypertrophy, the same thing we just talked about, in the heart, but no myocarditis or infarction. So in a case like this, when we have a young person who dies, the MEs are looking to see, could it have been a heart attack caused from something such as cocaine? We see young people that have that. Or could it be a myocarditis, which is an infection of the heart that can cause this kind of thing? The ME did not find those, so she just noted those as negatives in her report.
And of the medical records that you reviewed of Ms. Benning, was there anything you've seen in those records that would notate that she suffered from high blood pressure?
No.
Thank you. I pass the witness.
Thank you.
This is the last witness for the defense.
Dr. Larkin, as you said, you are not a toxicologist, correct?
That is correct.
And neither are you a forensic pathologist, correct?
That's correct.
Dr. Aaron Carney is a forensic pathologist and expert in that field. Do you agree?
Yes.
Now, you talk about some things you reviewed. How much of the testimony, have you been in the courtroom to listen? We have our backs turned to the audience, obviously, but have you been in the courtroom to actually listen to the witnesses?
No, I have not.
Okay. Have you reviewed any of the daily transcripts of the witnesses' testimony that began on Tuesday morning?
I have looked at some of the transcripts.
Okay. Have you looked at Dr. Olashoga's?
No, I have not.
Okay. He was the emergency room doctor who was the first doctor to see Miss Benning, correct?
Yes, I apologize. I did look at that. I forgot the name.
Okay. And Dr. Olashoga's testimony, which you read, considered, she arrived essentially dead, correct?
I mean, I don't believe she arrived dead. I mean, I don't think as an emergency doctor at that point we may make that same thought that he did. You know, when they arrive and they have no pulse and they're not breathing, yes, that's a correct statement. But when you go through what they did to revive them, then you can actually return someone back.
Yes. Brought back from the dead. That's what Vanderbilt and Dr. Olashoga did, correct?
So cardiac arrest, yes.
Yes.
Agree.
And she was intubated without the need for any medication because she was feeling no pain. Is that not correct?
I don't think anyone can say that, but I know she received medications.
After she was intubated, correct?
I believe the succinylcholine was at the intubation time.
There's only one intubation, right?
There is only one.
Because when she was removed from the emergency department to the ICU unit, they don't take it out at the emergency room and then redo it later, correct? There's one intubation.
One intubation, and that happened in the emergency department. That's correct.
Correct. And without going through all these pages of things, we should agree the medical records that are in evidence speak for themselves about when medication was administered and when it wasn't.
Yes, they do.
Okay. And so...
Masterful Melon, thank you very much.
Which is the pronunciation?
2 months.
You pronounce it.
Succinylcholine.
Succinylcholine was administered in the ICU because after she had been resuscitated, she was having seizures and body movements that would be consistent with proper medical procedure, correct?
Yes, you can use succinylcholine other times, absolutely.
Because it's a paralytic.
Yes, it is.
Was it given in the ICU or the ER?
I believe it was given both, and from what he's saying.
If the medical records, Dr. Olashoga's testimony, and would you agree that the records...
Hang on, brother.
Got it.
that Ms. Benning was intubated on 2/25/2023 at 22:06 hours. Is that correct?
I would have to look to verify that, but if that's what you're seeing in the record.
Well, again, the records are what the records are, and testimony has been to that effect.
Yes, sir. I just don't have it in front of me to confirm that.
So that's not a note that you would have made when reviewing Dr. Olashoga's testimony.
I didn't make any notes when I reviewed it, so I didn't make any timing on that.
Okay. Let me just ask about that. When did you do these reviews of the, obviously you could not have reviewed the testimony until it happened, so that would have been this week, correct?
That's correct.
So when did you do that? This week or over the weekend?
So probably towards maybe Friday, I may have looked at some of the transcripts, and then over the past day, I've also been reviewing.
Prior to the trial starting, counsel asked you about reviewing a number of things, including the 911 call, correct?
Yes, sir.
When did you review that?
Just recently, I listened to it, I know yesterday, and then I got the actual transcript of it.
Well, since recently could be a term subject to interpretation, when were you retained and or become involved in this case?
I believe 3 months ago, approximately.
Okay. Recently?
Yes.
If we're talking years?
Yes.
As opposed to months. So, 3 months ago, what was the first thing you reviewed?
I'm guessing I probably would have gone to the medical records initially and then the EMS records.
Well, don't necessarily want you to guess, but the Vanderbilt medical records are voluminous, correct?
Yes, 1,331 pages.
And the autopsy report?
Yes.
You would have reviewed that. And the EMT documents, the runs, you reviewed those, correct?
Yes.
Okay. And would you not agree that for the reason for this is so you can have the facts correct to be able to make an informed opinion?
That's correct.
All right. And so if you provided us information that the EMS was a guy, that was wrong, correct?
I don't know what you're referring to.
Document that you provided to us.
Oh, so that EMS guy was the 911 call. That was just, those are notes. It's not a report.
Okay. But the EMS guy, so you're saying now that was the 911 person as opposed to the paramedic. Is that right?
Well, the paramedics, I believe, were both females, so I may have put that wrong. But again, those are just some very informal notes.
Well, again, but you're putting down on paper your memory of the facts, your knowledge of the facts, correct?
I can, yes.
Right. So if you say the EMS guy said he thought it was an allergic reaction and he didn't check a pulse until he got her into the ambulance, that would not be the person answering the 911 call, would it?
It may not have been.
Did you review the testimony of Najee Jackson?
I did look at some of that, yes.
Just some of it?
That's correct.
So you know that during that call that Ms. Jackson was a part of, Ms. Benning said, I can't feel my legs, correct?
That's correct.
And said to Mr. Taylor, what did you put in my drink? My drink tastes funny. Correct?
Yes.
And from that, we have some time go by before the 911 call. But you recall there being any mention of that, those symptoms on the 911 call? My legs, I can't feel my legs.
No, I don't believe so.
With respect to Dr. Olashoga, do you have any criticism of how he handled Ms. Benning?
No.
In the emergency department?
No.
He did everything you would have done, correct?
I believe so.
Including having tests run, such as they could be run from the emergency department. We're talking about to see what is in her system, correct?
Yes.
You do that.
Yes, I do.
Yes. And you get those results back as quickly as possible, correct?
We do.
It's not like weeks or months later that you're sitting or standing around the emergency department waiting for lab results to come back from a lab in Pennsylvania, correct?
That's correct.
And Dr. Olashoga needed to have those tests run and got Dr. Broccolari as far as this was something that needed to be investigated, correct?
Yes, that's my understanding.
And there's no fentanyl put into Miss Benning's body by Vanderbilt Hospital until 2/26/23 at 0:45 a.m. Is that not correct?
I believe that's correct, yes.
Now you talk about people that come in that you've seen in the Houston emergency room or the day before that. Was it Waco? Was it Baylor?
No, that's Baylor St. Luke's Medical Center in Houston.
Okay, in Houston.
Yeah.
Those people are alive when they present, correct?
Usually.
But some of them, yes.
Most of them are alive.
Have you had someone present who is determined to be dead because of acute cocaine toxicity in your emergency room?
Oh, I'm sure I have, yeah.
And that is Dr. Aaron Carney's cause of death, correct?
Yes, that's correct.
Dr. Larkin, based upon that and your testimony about what is typical of cocaine, typical of fentanyl, in the face of all that, you're saying, oh, it could be a fentanyl overdose, or it was a fentanyl overdose?
Well, we know there was fentanyl as well, and we know there was cocaethylene. I don't know that those were taken into consideration as far as the cause of death. I'm not saying there's not cocaine. What I'm saying is, by the presentation, what happened just prior, it appears that we know there's fentanyl, but the fentanyl was accentuating or causing this respiratory arrest.
And that's your, could have been?
Yes, sir.
Because of that trace finding?
There's fentanyl was found.
You're basing this on the comforter?
I'm basing it on the comforter, and that sample that was also testified to by Dr. Methune and Dr. Jaguar.
Just one or two more things about getting the facts right. You would agree that's important?
Yes, sir.
To base any opinion on. And one of the statements in this report say on the day of her death, text messages indicate that Jay met with her drug dealer. That didn't happen, did it?
Again, that's not a report.
Forget that word. Is that statement?
Okay, those were just personal notes for me that I put down somewhere along the way, and I don't believe that there's any documentation that happened. I think we just know that she had text message contacting with the drug dealer that day, back and forth.
Excuse me, I didn't interrupt, but you put that in your notes as something you were relying on.
Not relying on, something that I was going to be looking at, and obviously I would have corrected that if I had been given a time or asked to, do notes. I didn't do them until just recently when I was getting prepared for this. So if they're inaccurate, they're not complete.
So any inaccuracy, even about fentanyl at the hospital, would make your opinion essentially not acceptable, correct?
No, those aren't my opinions. I've given my opinions in my testimony in court under oath today. And those were, like I said, notes that I was going to review to get prepared for the case today, which I've done. And nothing that I've said corroborates something that's not a truth.
So if there is no fentanyl in Ms. Benning's system when she arrived at the hospital, then it wouldn't be a fentanyl overdose, would it?
Well, we don't, I mean, we know there was some fentanyl there. It was never really tested for.
In her blood at the hospital, in her body at the hospital, regardless, there was no fentanyl detected, correct?
I believe that it was never tested for because there wasn't enough blood in the initial sample from 225 prior to getting fentanyl. I believe that Dr. Carney mentioned that.
But we'll see about that. Nothing else, Ron.
Any other questions?
Yes, sir.
The judge made a ruling saying you need to turn over your notes, and so the defense told all their experts to turn over notes. They scribbled down some notes really quickly, and
Wanted to draw your attention very quickly. When I asked you to take a look at page 55 of the medical records, Ms. Benning,
Yes.
what does that state to you?
It states that succinylcholine, paralyzing agent succinylcholine, was injected, 76 milligrams were given intravenously, 226-23 at 0052. And it's part of the ED notes, again, which is at the top, so that was in the emergency department.
When it says ED to hospital admission, what does that mean?
That's just on all the records, and they start in the ED and then it's on the top, just all the records have that.
And right below that, when it says ED notes, what does that stand for, if you know?
So part of EPIC has a section for ED notes, and that just basically shows notes that were generated during the visit. There's other areas of the record, but these are just basically the notes.
And just so the jury is clear, what is EPIC?
So EPIC is a enterprise system. It's a electronic health record. So it's one of the biggest in the country. Everything that goes on in the hospitals or the doctor's office or anything that's related are all on an EPIC record. It's actually about 40% of the market share in the United States right now. It's a big product. And it's people may be familiar with MyChart. So if you have a MyChart, that's part of EPIC, and that's how you can talk to your doctors and you can get your medicines and you have your appointments. So EPIC is just all that medical record all being in one electronic location.
Okay. And then I will draw your attention to page 43 of the medical records. At the bottom there, where it says ED procedure note by the Dr. Olashuga. Do you see that?
I don't see that. I think you have to go further up. There we go.
I apologize. Okay. Do you see that?
Yes.
And do you notice what number 1 says?
Number 1 is intubation. That's the procedure we talked about earlier.
And does it say given or ordered?
Ordered.
Is there a difference between the two?
Yes, there's typically a note that says about the intubation that says attempted one time, what time it happened, and all that.
You say a date of service? What does that mean?
What is date of service? So date of service is the day that something happened, so you can have the date of service and also the time of service. So this date of service for this procedure note, which the procedure note is the intubation order, was at 2:25:23 at 10:06 p.m.
And so this says it was ordered at 10:06.
But that's not what she said.
Yes, that says it. This procedure note says in the notes that at 10:06 p.m. this procedure was ordered, which was an intubation by Dr. Olashuga.
And so your testimony is this says ordered, right?
Yes, it does.
And this note says given.
Yes.
Okay, and what time is that?
So this is the succinylcholine that was given. Again, that was given 2:26:23 at 0052.
And
Just
within
before
their
1 a.m.
reason to give a paralyzing agent to someone who's dead.
You can intubate someone without a paralyzing agent, depending on their status, but you don't necessarily, you wouldn't necessarily need to do that if someone's dead.
Why would, as an emergency room doctor, why would you give succinylcholine to a patient?
Well, because I guess we got to be careful how we use the word dead. When we say someone's in cardiac arrest, they have respiratory arrest or cardiac arrest, that means they're not breathing, their heart stops. So essentially, I guess we call that dead. But we're resuscitating them. So fortunately, as an emergency physician, these patients that get to that situation, we bring them back. We resuscitate them. It's something we do. So they may have, and you hear people that say, oh, I died twice because I had 2 cardiac arrests, but they are not dead, brain dead. You're not going to stick them, in the morgue at that point. You're going to finish your resuscitation and determine if they truly are dead or they're not.
And I understand that, did you have an opportunity to review any of these toxicology report records?
Well, I did look at them.
And again, you're not a toxicologist, are you?
I am not.
And is this number 231-29285?
Yes, it is.
Have you learned that that is assigned to the comforter that the vomitus of Ms. Benning was located on when she was having her initial emergency episode in her apartment?
Yes.
That is before she went to Vanderbilt.
That's correct.
Have you learned through your review of all the records that there was fentanyl present and the vomitus on the comforter?
Yes.
And is this a record, based on your knowledge, if you know, that states that?
Yes.
And to be clear, you're not stating Dr. Olushalo did anything wrong, are you?
No.
And although Ms. Benning passed away, as stated in this autopsy of acute cocaine toxicity, when it comes to the manner of death, that could not be determined.
Your Honor, I object to that.
That's correct.
She is asked that be stricken, not forensic knowledge.
Yeah, this is a record that's in evidence.
Then there's no reason for this doctor to ask that.
She's answered the question. Do you have any more few questions?
I do not. Thank you. I pass it.
Any other questions from the state?
No.
Thank you, ma'am.
Thank you, sir.
Any further proof on behalf of Mr. Tate?
May we approach briefly, Your Honor?
Okay.
Sidebar. I've got to say the defense witnesses and attorneys have done better at the very end of their case than the whole other part of the trial. Now, you might think that they went and found expert witnesses that were willing to sell their soul for cash, and that might be your opinion. That might be the jury's opinion, too. But what we have is experts who have testified that support the claims of the defense. And as spicy and feisty as some of them might have been, that testimony is now before the jury. So, I don't know where you're getting that. The looking at the data and reaching a different conclusion. Now, I think it's a stretch. For me, I'm not sold on what they've told me, but the testimony is there. I mean, this last witness just testified that the overdose was caused in part by fentanyl. I don't think the data's there to support that. Basically, by saying we had it on the mattress or on the comforter, and they only tested it. It wasn't in the vomit section. I think they only found it in the corner of the mattress as the control area is where they found it, right? Yeah. Mike, happy birthday. Mike, how you doing? Are you feeling old? Well, you are. And I'm here to tell you you're old. So happy birthday. Shout out to Mike. Where's Mike? Is it Nicole? Is it that Mike? Mike. What day is it? Is that?
Remember in the beginning when we started 110 years ago?
Mike. Is it that Mike? That's tomorrow. Yes, he is as old as dirt. Mike's like I'm only 40 something. Isn't there an issue with chain of custody of a comforter anywhere? There is, and the defense has tried to play it that way as well. So, I've never done anything with medical file systems. We were using like Oracle for when I was in the business world. Inventory, production, shipping, billing, everything. It was back on version 9 or 11 or something, I don't remember. Judge is annoyed. Anytime we're not making progress in this case, he's getting mad. Maybe the cocaine he got was laced with fentanyl. The problem is the state has adopted this stance that it couldn't have been. That there was no fentanyl. They've got this theory that they're trying to stick to that doesn't allow that to be the case, and that idea has crossed my head as well, Miss Chris. I was using Lotus 123 and your daisy-chained computers. Somebody took the comforter could have added a little fent unknowingly. Maybe the hospital gloves they were wearing had been contaminated with fentanyl.
Sure.
All right. So we might just skip ahead through this because we're approaching back and forth. Let's see who's.
Would there be any remote proof from the state?
Yes, Your Honor.
Okay, sorry, you just missed a key part, and it was my fault. Here we go. You want to hear this?
Any other proof on behalf of Mr. Taylor?
No, Your Honor, at this time, the defense rests.
Defense rest. There we go.
Would there be any remote proof from the state?
Yes, Your Honor.
Okay, rebuttal.
Dr. Carney?
Where is she?
She is
Oh,
right
that's
here.
my first step.
Step right up.
Actually, the link did not work. I need a few minutes just so I can tell her a few things about the last two witnesses.
Ladies and gentlemen, if you'll step down the hall, we'll break.
We're going to skip ahead.
12:55.
So the case in chief is almost over. We've got rebuttal for the state. They're bringing the testimony back to say this is why the defense experts were wrong. Let's give them just a second.
And other than Dr. Carney, any other rebuttal witnesses?
I don't think so, Your Honor.
All right, let Mr. Taylor step around to the podium. We'll cover his decision not to testify.
Okay, let's listen to this. Mr. Taylor,
Raise your right hand.
put it on the record.
Do you swear to tell the truth, so help you God?
I do. All right. Go ahead.
Your lead witness, thank you. Mr. Taylor, do you understand that you have the right, absolute right not to testify in this matter?
Yes, I do.
You also understand that you have the right to testify if you so choose?
Yes, I do.
And if you don't testify, the judge can tell the jury that no inference can be drawn from your decision not to testify.
That's correct.
You've consulted with your counsel in this case about that decision?
I have.
And your counsel's advised you on the advantages and disadvantages of either choice that you might possibly make?
Yes.
And after considering all those rights and the possible decisions and the ways you might make that decision, you decided not to testify in this case?
Yes.
And that's your own decision?
Yes.
No one's pressured, forced, or coerced you into making that decision?
No.
Thank you.
Okay, you can have.
I'm satisfied, Judge. He doesn't want to testify.
From one, after we hear from the remaining witnesses, you'll give some thought to how long you want from the attorney's perspective to close the arguments.
An hour each.
All right, we'll be recessed to 12.
Yeah. Hold, please. We've got to fast forward a little bit. Lunchtime happens. We are almost done, guys. We are almost caught up. I appreciate you guys sticking with us here today. Defendant did not testify.
All right, so the state wanted to call Dr. Carney.
Yes, Your Honor.
And what, do this so I can factor in while that's going on, the best thing for the jury and the parties, what is the state's thoughts on closing arguments time-wise?
I
Yeah, about an
technically
hour left.
don't know the exact time. It would be at least
Little
30
less.
minutes, maybe 40 minutes for my first close. If
Oh,
it goes longer,
perfect.
I pre-apologize.
How about total?
No, I was talking about for my first close.
So, total, what do you think it would be?
Total.
An hour.
Hour. That works for me, Judge. 45 for the defense.
Your total argument? Let's see how long this goes.
Your Honor, I have one request based off of their opening presentation. They had some photographs and different things in I think it was jurisdiction and maybe opening. Our request is just that anything that is shown to the jury during closing arguments is something that has actually been admitted as an exhibit.
Okay. That, I don't think, is a given.
It's a given, says the judge.
Okay.
And Judge, I have a request, and that is get the close of the proof whenever we get to that.
That's the big qualifier.
Exactly. If we could have a break, perhaps discuss the jury instructions.
Oh, sure, we'll have to do that.
We're going to skip that part.
All right, let the jury think.
All right, last witness, rebuttal for the state. Probably going to address the fentanyl issue. Whether or not it was present. We've got about 40 minutes left, 45 minutes. Or less. She brought her own box.
Good afternoon, Dr. Carney.
Welcome back.
You were not able to hear the prior testimony of Dr. Lindsay and Dr. Larkin, is that correct?
That's correct.
Okay. There was some testimony that was specific to fentanyl and whether Ms. Benning might have died from a cocaine and fentanyl overdose, which your autopsy result is that the cause of death was acute cocaine toxicity. Can you describe what, if anything, what, if any, evidence did you have of fentanyl in Ms. Benning's system prior to her admission at the ED?
I don't have any evidence that she had fentanyl in her system prior to arriving at the emergency department.
And was there specific testing of the urine sample from 2259 that was tested specifically for fentanyl?
Yes, ma'am.
And that was negative, is that correct?
Yes, ma'am.
And then that first blood that was taken at 2231, there was no fentanyl detected, but fentanyl, the specific drug of fentanyl was not part of that test. Can you describe what was tested and kind of what results were not present that give an indication that there was also no fentanyl in her blood?
Well, this commonly happens when we have someone who we believe has taken too much of a substance. They go to the hospital, they are unresponsive, and some testing is done on the urine to try to help direct the blood testing. In this case, we have an initial urine sample that is positive for cocaine and metabolites, no other drugs, no fentanyl. So when I have this limited amount of blood to work with, less than 2 milliliters, I really want to direct the testing so I can catch anything that's there, maybe that wasn't tested for already. In discussion with the toxicologist at Vanderbilt who had followed her for days and been trying to figure out what drugs might be in her system,
we decided on testing for cocaine and metabolites, since it was positive for cocaine initially and metabolites, and I wanted to catch the ethylene methyl ester with it, knowing that the cocaine could break down. I tested for designer opioids. So these are the fentanyls that have the added chemical groups. So you can see it here on the list. There's furanol fentanyl and acryl fentanyl and all of these designer fentanyls, and all of those were negative, as well as one of the things that's been mentioned previously in this case, the 4-ANPP, which can be a precursor to fentanyl. It could also be a metabolite. That was also negative, and the testing reporting limit was very low to try to catch anything that was there if it was negative. And then I think that was the bulk of my testing on that, and then we did the additional testing on the fetal liver tissue.
And the testing on the fetal liver tissue, you've testified about that before, but was there any fentanyl associated with that?
No.
And that's even after treatment in the hospital, correct?
Correct.
And the levels of the subsequent test, which you referenced working with a toxicologist at Vanderbilt, is that Dr. Recovery Addict?
Yes, ma'am.
And so the subsequent testing of blood and urine, those results, were those results consistent with her receiving his medication in the hospital?
Yes, ma'am.
And again, the cause of death is acute cocaine toxicity, correct?
That's correct.
And there is no evidence that there was fentanyl in her system upon admission.
There's a lot of bleeding here.
Emergency department.
That's correct.
There was testimony by one of the defense experts that it was an assumption to say that Ms. Benning ingested something orally. Can you describe, you determined that it was ingested, and that is oral ingestion. Can you explain how you were able to determine that, and if it makes sense that it was not orally ingested?
When we look at one of the toxicology textbooks, or toxicology books that I refer to rather regularly, and it gets updated on a regular basis with all new studies, the studies have shown kind of the average, or the ranges and the averages for the amounts of cocaine in cocaine intoxications that have been detected and tested, both in obviously controlled studies, you know how much they've taken and how much the amounts will be, but even in ones that have been treated in the hospital, whether they've died or not. And the levels that we see in Ms. Benning's blood are pretty much in oral ingestions. So your nasal insufflation or snorting, your IV injections, you don't have this level in those sorts of cases. You really see it in the thousands like this when they've ingested it orally.
Which, that's part of that oral ingestion is because that level is so high. Is that correct?
That's correct.
But also we have that vomit from the comforter that also tested positive for cocaine.
That's true.
And when EMTs see the pink vomit on her mouth, but they also find her face down with her face on the comforter and the vomit stain is under her mouth, that is part of the evidence that you considered in determining this oral ingestion.
Yes, ma'am.
And then we also have a witness who testified that Ms. Benning said to Blaise Taylor, "What did you put in my drink? I knew my drink tasted funny." And you considered that, is that right?
I did.
Dr. Lindsay also made a comment that you determined that the cocaine all spontaneously hydrolyzed in the tube. That was the clear cap tube without the preservative. Does that make sense to you? And can you explain kind of what happened with the clear cap tube and then it hydrolyzed? Is that something that is commonly seen?
Yes, so that's something we kind of talked about before, how typically when we draw blood at the time of autopsy, we want to put it in a gray top tube that has that sodium fluoride to stop those enzymes from breaking down the cocaine, because it can continue to break down even after the person is deceased while it's still sitting there in their body and while it's sitting in the tube if you don't have something to stop those enzymes. We had a clear top tube, which didn't have that, so the blood continues to break down. I've seen this on many occasions with hospital blood samples with maybe a prolonged time after death before autopsy, and so that's why we want to look for that ethylene methyl ester. I found a study that was published back in the 90s, so this has been kind of a known thing for quite some time when you're looking at post-mortem levels of cocaine, that if you want an accurate estimate of the cocaine or accurate number of nanograms per milliliter cocaine that's in the blood at the time of death, then you want to add the cocaine and the ethylene methyl ester together, because that was all parent cocaine initially.
And this is not something that just you know, but is that something that the other forensic pathologists at the medical examiner's office, that is just a normal practice of how you would estimate the parent cocaine?
Yes.
And Dr. Bergolari at Vanderbilt discussed that, and she in fact agreed with you. Is that correct?
I don't remember if we talked about the specific numbers after the fact, but we did talk a lot about the testing and what tests would be most appropriate to order and what we were worried about for her cause of death.
And Dr. Bergleri also was aware of the cocaine on the comforter, and y'all spoke at length about if it was oral ingestion and the numbers and if everything lined up. And Dr. Bergleri was in agreement.
I think we did talk about that because we had a meeting with, several of us, and we discussed, aspects of the case.
Which there were several meetings where everybody was meeting to kind of discuss what the levels were and make sure that everybody was in agreement of kind of what happened and what the tests showed. During those meetings, it came up where it was the lawyers were asking, could you determine how much cocaine was ingested? And the result of that was all of the toxicologists saying no.
That's correct. So the problem is, I can't remember, I may have mentioned this before, when you buy medication at the store, it's tested. There's, quality standards. You know that when you buy that over-the-counter medication, like ibuprofen or Tylenol, you know how much is in each pill because it's been standardized, it's been tested, it's passed, those sorts of testing. With your illicit drugs that you buy on the street, you don't have that kind of testing. You don't know how pure the drug is that you're buying, how much is in this particular packet of powder or liquid compared to another one. You don't even know for sure what's in it. They may tell you it's one thing and it's something else. So there's really no way to say exactly how much amount or how many times something was given.
And part of the high number is that oral ingestion and the other evidence that it was put into a drink and it was liquefied and in a liquid. Is that right?
So liquids or something dissolved in a liquid is going to absorb more quickly than something that's encapsulated, where the acid in your stomach has to eat through a capsule or has to break down a solid mass of the drug. If it's liquid, it's really just going to spread out and it's going to absorb more quickly.
And you previously testified about the one other autopsy case that had a similar level of cocaine concentration in their blood, and it was someone that swallowed some type of cocaine, rock something, in custody out of jail.
Okay.
Objection.
That what's your question about that?
Well, Judge, I was restating her prior testimony so I could get to the question.
Okay, good.
You testified about that previously, and that has the same level as Jade's level in this case, similar.
Yes, it did.
And based on the facts of that case, it would not have been an inmate that would have ingested 16 8 balls.
I mean, it has to be something small enough that he has on his person, he could swallow it quickly while in intake, and then of course it affected him rather quickly as well.
And liquid cocaine can be lethal even at a smaller dose, is that correct?
Well, again, we don't know how much is in it, so, it can be very concentrated.
And so we would not be able to guess that, is that correct?
That's correct.
And also, specifically, cocaine, you've testified to this, has a connection to placental abruption.
Yes, ma'am.
And that is very commonly known, that it is the one substance that has a direct connection to that. Is that correct?
That's correct.
Okay.
Objection leading.
Judge, part of this is reiterating her prior testimony.
Okay, so she's answered that. What's your next question?
Can you describe how Jade Benning arrived to Vanderbilt University Medical Center?
How she arrived?
What was her state when she arrived at the ED?
She had no pulse. Yeah, she was pulseless. She had no blood pressure. She was unresponsive and not breathing on her own. She relied on medical therapy and other providers to basically do her breathing for her.
And Dr. Olashoga testified that she arrived to the emergency department dead. Would you disagree with that?
No.
They also had testimony from Dr. Larkin. She works in an emergency department. She's not a forensic pathologist. And she was testifying about snoring and agonal breathing. Can you describe when does agonal breathing occur? What are the circumstances?
So agonal breathing is that gasping for air type breathing that occurs when the brain is not getting enough oxygen.
And is there one thing that causes that or one circumstance that causes that?
No. So anything that's going to deprive your brain of oxygen. So that kind of that right around the time of death. So it could be drugs, it could be a natural event. It's not specific to any one thing or any one drug.
And that is consistent with Ms. Benning's case of that acute cocaine toxicity?
Yes, so the oxygen is not getting to her brain as needed, and so she's having that agonal breathing.
And the circumstances of the EMTs finding her face down in the bed with the pink vomit under her mouth, can you describe if that happened after the agonal breathing? Is that consistent?
So at that point, it sounds like she's face down in the comforter and she's vomiting and she's not conscious to be able to roll over and kind of protect her own airway so that she gets her face out of the comforter and out of the vomit so that she can breathe. So I would expect it would happen, around the same time or after the agonal breathing.
And would that be the same time that she would be going pulseless?
Yes.
There was also some testimony related to someone who has consistent drug use. Was there if someone is using drugs consistently on a daily basis, do you find signs of kind of physical indications of that at autopsy?
There are things that we can look for. If you have someone who's smoking a drug, they may have more of that kind of black deposition in the lungs from where they're a smoker. We can look for if they're snorting it and it's something like cocaine that's going to constrict the blood vessels and could cause damage to the tissues. We can look for any sort of holes or damage to the nasal septum, the little dividing thing right that divides the two sides of your nose. We can also look for if they're an injection, they inject their drugs. Look for needle marks, needle tracks, where they've injected repeatedly to the point where they've scarred that vein, and they often have multiple needle puncture wounds over that as well.
So there are physical signs that can be seen at autopsy that indicate the manner of use.
Yes.
And specifically to Ms. Benning's heart, there was testimony that the focal myocyte, is it
hypertrophy?
Thank you. That was indicative of long-term cocaine use.
I see scattered myocyte hypertrophy in many cases that aren't related to cocaine, that it's more of a natural cause of death, so I don't think that's specific to cocaine.
And did you have any evidence whatsoever that Ms. Benning was a cocaine user ever?
No.
Getting all sorts of weather alerts. What's going on here?
And Dr. Carney, your
Rising by the weekend.
expert opinion on the cause of death is acute cocaine toxicity, not a fentanyl overdose, correct?
Correct.
All right. Defense, your last shot. Get the last word.
Good afternoon, Dr. Carney.
Good afternoon.
How are you today?
I'm all right.
I just wanted to talk with you about a few things. You stated that on direct examination that you had a meeting with Dr. Bukalari and others.
Yes.
And at that meeting, you guys were discussing the toxicology results for Ms. Benning.
Yes.
And who all was at that meeting?
Oh, we were discussing timeline of events and toxicology.
Do you have notes there in regards to that meeting?
I'm not sure. I know that there was the police and Dr. Bukalari and me, and I think General Norman may have been there as well.
And I'm sorry, did you have notes for that meeting?
I did, but I don't see them here.
In that meeting, were you aware that Dr. Bukalari found that Ms. Benning did in fact have coca-ethylene in her system?
No.
She didn't share that with you?
I don't recall seeing those records. No.
Are you familiar with the CFSRE records?
I am now, but I don't remember discussing this then.
Okay. And now that you have seen the CFSRE records, have you since learned that Ms. Benning did in fact have coca-ethylene in her system?
I believe it was in the urine, and yes.
Okay, thank you. You testified earlier in regards to toxicology report that was a result of the blood that you sent to NMS. And I think you said that you had a very limited amount of blood to test for. Is that right?
That's correct.
And the reason you had a very limited amount, it wasn't because you didn't request enough, it was because you wanted the most accurate picture of what was going on with Ms. Benning at the time she entered the hospital.
That's correct. We want the earliest blood sample if possible.
And the earliest blood sample, to be fair, was retrieved for medical purposes, not forensic purposes, correct?
That's correct.
And so that's why it didn't have the gray topper on top.
Yes, ma'am.
Okay. And when you ordered those tests on that blood for which you relied on for your
results in your autopsy, you did not order the fentanyl test, correct?
Correct. I ordered the designer opioids, it's kind of specialty fentanyl test.
Right, but it's not fentanyl, correct?
Correct.
And so if fentanyl was present, we wouldn't have known because you didn't order that test, is that right?
Yes, I didn't order that test because it was not in the urine. So if it's not in the urine along with the cocaine, there was no reason to waste blood testing for something that's not there.
But to be fair, nothing was in the urine, isn't that true?
No, that's not true. There was cocaine in the urine.
Which urine are you referring to?
The very first one.
The one for 225 and 2259?
Yes, ma'am.
Okay. Well, your blood sample was 225 and 2231, which was before the urine.
Yes, so cocaine was in both.
Okay, but you said you were relying on the urine.
Right, to help direct my testing because I didn't have a lot of blood, so I needed to direct my testing to things that I was concerned about. So the fentanyl had been ruled out in the urine, and the cocaine was ruled in, but I wasn't sure that anyone had tested for the designer fentanyl, so that's why I tested for those.
So but just so that the jury is clear, fentanyl itself would not have shown up.
Not in this particular test.
Not in the blood, okay, just to be clear. Now, what test was that the fentanyl showed up in the 22, that did not show up? Is that 2259?
Yes,
Do you
ma'am.
have a toxicology report number for that?
I don't have it here. I believe that was the CSFRE that was the earliest urine that was tested.
Which test result is that?
That was on the 2259 urine. The CSFRE where they did the testing for the over 1,000 drugs.
Okay, I mean, what's the test number so that I can look at it?
I don't have that one here. I don't have that number right here.
Okay. In regards to the vomit, you will agree with me that the vomit was before the blood and the urine, correct?
Correct.
Were you aware that fentanyl showed up in the vomit?
No, the findings it says for case sample was positive for cocaine and benzoylecgonine.
Did you learn later, if I could have the envelope, please? Just so that we're oriented, the 231, 29, 285?
Yes.
Which is for the comforter, you see that?
Yes.
You see here with the 231, 29, 285, that fentanyl is in fact present in the vomit. Did you know that?
The interpretation, sorry, I'm sorry.
Okay, she's going to explain.
Well, the interpretation here says the case sample 007, which is the fabric in the area with the visible stains, was also none detected for the presence of fentanyl.
Did you know that the reason that NMS may not indicate a positive is because it will be below the reportable limit?
Yes.
Not necessarily because there's no indication of it. Are you aware of that?
Yes. I've never been told that there was ever any fentanyl in it.
And to be fair, did you know that these records are part of what we call a litigation packet?
I did not know that.
And when you get your toxicology report results, they don't come with a litigation packet.
Correct.
Right. You have to request and pay for those.
Okay.
She's upset that she had to pay for it. We paid for that. We paid for this.
Are you familiar with pharmacokinetics?
Some.
Are you able to perform the pharmacokinetics calculations?
No.
Okay. That's for a forensic toxicologist, right?
Right.
Okay. And were you aware that Dr. Kotulski did not agree with your method of combining EME with cocaine to get a definitive measure of concentration level?
Objection, Your Honor. Counsel is misstating the witness
Okay,
testimony.
the jury's heard that. What are you wanting to reference about prior testimony without you determining whether it's correct or not?
No, Your Honor, I checked. It is.
See, there you go again. It's not up to you to check. These ladies and gentlemen of the jury are going to check everything.
Yes,
so
sir.
what is your question?
In regards to your testing to get an accurate picture of exactly what was going on as it relates to substances, a hair follicle test would be a good way to actually get a good picture of what type of drugs and or substances in someone's body. Would you agree?
Well, the problem with that sometimes if you're worried about levels is there's not a lot of studies or samples or experiences you can compare to with hair. they draw blood in people all the time when they treat them for intoxications or when they die and they do an autopsy. There's not a lot of hair testing to even compare to. So for hair, it's more limited in what you can actually do with the interpretation.
And I get it for the levels, because there were a lot of tests here that didn't have levels. But it would have at least shown you what was present, wouldn't it?
What's in the hair? Sure. And show if there's any drugs there.
It wouldn't show?
Yeah, it would show if there were any drugs there, yes.
Thank you. As it relates to the, I know I'm going to mess this up, the focal myocyte
Hypertrophy.
Hypertrophy, thank you. Miss Benning was a young woman, correct?
Yes.
And otherwise a very healthy young woman, correct?
Correct.
Now, we're certainly not saying that the only reason that she would have an enlarged ventricle is because of cocaine use. Not saying that, but it is certainly a possibility, is it not?
I mean, something that will increase your blood pressure would cause your, heart cells to work harder. So you could say myocyte hypertrophy goes with things like that. So that could be a lot of different things. Cocaine's one of many on the list.
What other things would be on the list?
I mean, any sort of stimulant or, even, who knows, anxiety or genetic problems or whatever.
When you say stimulant, what is a stimulant?
Well, like fentanyl, methamphetamine, something that drives the blood pressure up.
When you were determining and making the decision as to what to test for, and I think you said that you had done some research into Miss Benning, and with the cocaine, that was significant enough for you to stop there, right?
Well, it's not so much that it's stopped there, but we really want to, and this is the case because, like I said, the blood sample is limited. We want to kind of focus in on the things that we want to confirm, because otherwise if you test for everything, you're going to run out of blood. You're not going to be able to confirm anything. So in this case, we already knew that she was positive for cocaine, and we wanted to get a number. Like I thought I wanted a number that I could recognize. And then that was really the only positive test that she had.
When you were making your decisions, weren't you not making your decisions under the impression that she had no history of drug use?
I mean, whether she had a history of drug use or not, you need to look at what are your positive tests. And then you can think about the history when you're looking at the interpretation of those results.
But weren't you told she had no history of drug use?
I was told that the only drug history she had was making some marijuana edibles in the past, and that had stopped when she found out she was pregnant. So no recent drug history.
Do you remember taking or giving a testimony previously in regards to Ms. Benning?
Yes.
And do you remember when you gave that testimony, I believe you stated that she does not have a history of drug use. She did not appear to want to take anything that would harm her child or herself.
Right, so knowing with her pregnancy, she stopped even with the marijuana edibles, and there was no reason to believe she had taken any drugs as of late.
But she did have a history of drug use, didn't she?
We talked about that. So you even showed me the transcript, and we talked about how I said she didn't have specifically like the cocaine, that sort of illicit drug use, that the only drug use I was aware of was the marijuana edibles.
Well, I'm looking at the transcript here, it doesn't say that. It just says no history of drug use.
Okay, but we talked about it on my direct, or my, cross the first time to clarify this.
We did.
And if you say that she did not appear to want to take anything that would want to harm herself or her child, how do you explain cocaethylene in her system?
I don't know how the cocaine was delivered to her, if it was absorbed in some sort of alcohol. I do not know how that was done or where the alcohol came from.
Would Ms. Benning not be able to taste cocaine and alcohol if she was given it unknowingly?
I don't know how much alcohol it might be, and I don't know anything about cocaine taste, so I can't help you with that.
Fair enough. And certainly when you, or before you came to any of your conclusions, you had met with law enforcement and the prosecution, correct?
So I met with law enforcement because I rely on law enforcement in their investigation when I'm determining manner of death. So it's very important that I know the circumstances of the case.
And that is where you learned she had no history of drug use, right?
The history that we've discussed, yes.
Thank you.
All right.
Just to clarify, Dr. Carney, your cause of death was not based off of the meetings with anyone. It was just the manner of death. Is that right?
Correct. So the cause of death is something I'll determine through the autopsy and the toxicology and the histology, the looking at the slides, all the work that I do on my end. I really refer to the investigation for manner of death.
Any other questions?
No, Your Honor.
We're done. We're done. We're ready to do a poll. Assuming the state doesn't call any of their rebuttal witnesses.
Any further proof from the state?
No, Your Honor.
Any further proof on behalf of Mr. Tate? Ladies and gentlemen of the jury, if you'll step back down the hall briefly, we'll get back to you. In terms of jury instructions and lesser included offenses, the court plan, as the case law points out, to charge the indicted offense, second-degree murder, voluntary manslaughter, reckless homicide, and criminally negligent homicide as to each of the 4 counts. Any comments, observations?
Lots of lesser included.
Totally appropriate. Yes, that's
Are you requesting, Ms. Brand, or whoever is dealing with this, ask this based on discussions, jury out discussions with your co-counsel, are you requesting the 4214 cause of death instruction?
I was just looking at that, Your Honor.
I mean, co-counsel mentioned that the bench got, I don't know what it was, but it's out of the hearing of the jury that she was asking some of the questions because
That appears like that might be an appropriate instruction.
Vanderbilt and the family caused the death of the fetus.
I don't think the portion of that says, there's like a parentheses portion that says that evidence in this case that the deceased required medical attention as a result of the injuries.
You talk about the 1, 2, 3, 5th paragraph?
Yes, I don't think that paragraph needs to be in.
Okay. But it's the defense position that this instruction should be given for the jury to determine whether it was reasonably foreseen, if in fact they find Mr. Taylor had anything to do with it, whether it's reasonably foreseeable that his actions was the proximate cause of the death. Or something Vandy or the family chose to do.
No, I have not.
Well, you asked, you grilled the family and other people about them deciding not to.
I asked my question on this.
You had multiple witnesses.
This is the defense blaming the hospital or the family's decisions as far as the medical care for the death of the fetus.
Well, I don't think the argument is that there's intervening cause. I think the question is just, the argument as I understand it is that it's more approximate cause. I think that's probably, there are probably general instructions that address that. It's more of like a reasonable doubt kind of thing. I don't think we necessarily have to have that in there.
So you're not seeking 4214?
No, I don't know if that's the right one for this case. Because I don't think that's the argument that there was some kind of intervening cause.
Well, I mean, the question, that's the reason why I got to looking at it, wondering whether it should be in. I mean, there were questions about whether the family declined performing a C-section, what Vandy's advice was, whether the fetus was viable or would have problems, I think was one of the words that was used.
Yeah, I don't think, I don't anticipate that being argument.
Okay. Does the state have any input on that?
Hey, Your Honor, I believe the pattern 708, for example, the defendant, or one for whom the defendant unlawfully killed the alleged victim.
If they're just going to do jury instructions, we're going to
requests from the parties about jury instructions.
bail here.
I would say there's no special request. Can't really think of anything.
No, give it a defense.
Okay.
All right. We're caught up.
What need a break prior to closing?
Yes, please, Your Honor.
How long?
20 minutes?
And I keep kind of coming back to this. I worry about things that maybe y'all are in the heat of the moment don't worry about, and that is if the jury gets this case in at around 4:45 or 5 o'clock, with closing arguments, a break till 2:05, and jury instructions going to get us to that or more, we lose our alternates. So if they deliberate for ever how long they want to, they can stay up here till midnight if they want, but I don't foresee that happening.
Police court, that is one thing I actually was thinking about, would be to have the alternates come back in the morning for the concluding instructions and then dismiss them. So just for the sake of not excusing them and then sending them home.
Any thoughts on that, Mr. Green?
I think that's probably fine.
Okay. Doing closing arguments, making sure we have enough report back in the morning, and do the jury instructions with them starting that deliberation process fresh, so to speak.
May I, Your Honor, suggest something?
Okay.
May I suggest that they get the charge with the closing in the morning so that it's fresh and everything is on their mind then, as opposed to...
Then we just forego 2 or 3 hours of today.
Yes. Let's do that, Judge.
Judge, what I was referencing is that last concluding paragraph of the instructions where it's like excusing the alternates, and you may now go to...
I've never done that before.
We just say, I've seen that, just where that
I did
last
the jury
page.
instructions, and I give them to them and let them start deliberating.
I would just say that is, I think, an option to read the instructions, except for that last page, and say, I will have...
Then they come back tomorrow with little or nothing on their plate, so to speak.
Except deliberation, and that's a full plate.
Are you saying, Mrs. Hollins, you're not ready for your closing argument?
Well, I would like 2 things. It would be nice to have a little time to go through all the evidence. It's been almost 7 days worth of testimony. And then I do think that the jurors will appreciate hearing the closing arguments consistent with the instructions, and then starting fresh for a whole day of deliberation.
Judge, I can say,
they want to go on
a few
with
times,
charges.
the state would be in agreement.
See, why don't you do that?
Let's see, then in the morning, your 45-minute estimate and 1 hour estimate are going to change.
Nope.
It'll be quicker.
Yes, it would.
More efficient.
Yes.
Okay. Because I'm going to hold you to the 1 hour we're setting. Fitz wanted 45, so we'll set an hour for each. All right, let the jury step back down and let them go for the day.
All right, we made it to the end. We have a poll going right now. Make sure you vote. We're asking where you stand on this one. Next week, we have a hearing with Tyler Robinson. It's the preliminary hearing. It's going to go for 3-4 days, maybe longer. I don't know. Ooh, easy there.
Members of the jury, after input from the attorneys who need, rightfully so, a small break, like 20 minutes or so, to gather themselves in terms of their closing arguments and things they may want to reference, factoring in that, plus closing arguments from both sides and the court's instructions to you, which will be a little over 30 minutes, it would probably just having, you can blame me for this if you don't like this decision because it's mine and nobody else's. I get input from the attorneys, but the best thing from my perspective is to recess for the day, have you come back in the morning. There's a number of other things that I consider after 600 plus jury trials. So just trust me on that. Come back in the morning refreshed to be to the point of closing arguments to you and the court's instructions, and then you would begin deliberating shortly after you come here in the morning rather than starting at 5 o'clock tonight, okay? Just remember what I said about not discussing the case, going by any locations, looking things up, listening to anything in any kind of media outlet, social media included, and leave your notes up here. Tomorrow, report in the morning, 8:45, 8:50, and we'll get you up and get the case submitted to you. You can step out with the
All right. 186 objections. We might take that counter a little bit higher. Depends on if anyone objects during the closings tomorrow. There were points in this trial where even the M word was tossed around, where the judge said, "What do you want me to do? Declare mistrial?" Glad that didn't happen.
Give the jury a few moments to get off the floor, and they're printing you the statement. They're printing you a draft. Still be a draft. All right, moving in recess.
All right, there we go. All right, thank you very much for sticking around. It's been a long day, a long day. I think we're done. I'm exhausted. First yesterday and now today. Amber, you got to go back. You got to watch it all normal speed because we were at 1.25 speed to get through everything. So that's sorry. Them's are the rules. We'll be back tomorrow for the closing arguments. We'll be on verdict watch in this case. I think we can get a verdict tomorrow. What do you guys think? Verdict tomorrow? Let's end the poll really quickly, see how it ended up. Let's see, we asked, the question was, how would you vote if you were on the jury? And we came back with 70% saying guilty, including lesser included. So some degree of guilty there. And 30% on the not guilty side. That's with just shy of 300 votes. So we're gonna get some rest. We're gonna get some rest. All right, tonight when you go home, please hug the people you love, smile at someone, make their day just a little bit better, and please stay safe till we go live again tomorrow morning with what will possibly be the last of this case. Blaise Taylor, the state of Tennessee. It's all on the line now. The attorneys have done their job. Now it's up to the jury. And it will be interesting to hear how the closing arguments go. They're not evidence. But it will be interesting to hear this all put together. I think there's some things the state needs to hammer on a little bit that sort of got glazed over during the trial. And one of those has to do with Blaise Taylor's phones and what was turned over and what wasn't turned over. I think that has to be something they hammer on because that looks very suspicious. That looks very, very suspicious. So we'll see what happens. You guys have a good night. We'll see you in the morning. Bye-bye.
Thank you, sir. You're my new best friend.
It's bigger than you. It's bigger than me. It's bigger than all of us.
Don't miss the forest for the trees.
Remember in the beginning when we started 110 years ago?